second day of oral argument here in the Harrisburg courtroom of our Supreme Court of Pennsylvania at our majestic state capitol building. As architect Alfred Houston envisioned this building to be a palace of art, I highly encourage everyone in attendance to visit our rotunda, legislative chambers, and governor's reception room with an eye toward the beautifully created artwork, particularly the famous Violet Oakley murals installed in 1927, and you can see those gorgeous murals all around this courtroom. Oakley was the first female artist to ever receive a major public art commission, and her murals on the evolution of law are simply spectacular. We also marvel at the 52 million pound terracotta dome above the rotunda, a 1/3 scale model of the dome of St. Peter's Basilica in Rome, on top of which a 15-foot gilded statue named Commonwealth stands. Houston intentionally placed this courtroom on the 4th floor with the legislative and executive chambers on the 2nd to physically separate and symbolically indicate that the judiciary is an equal and separate branch of government. The courtroom was designed in the Greco-Roman style as indicated by Ionic columns and the Greek grille wainscoting, all handcrafted. All of the wood in this room, including the bench, is mahogany imported from Belize. I'd also like to draw your attention to the 2-ton bronze chandeliers, unique yet different from one another. Under the main light in each is a statue dedicated to 4 great lawmakers. To my right are the Hebrew lawgivers. Closest to the bench is Moses, and in the back, King Solomon. To my left are the Greeks. Closest to the bench is Aristotle, and in the back is Solon, the father of democracy. The green and gold stained glass dome above us was designed by Alfred Godwin and is one of the many domes in the Capitol, but this is the only one that is stained glass, and it is only visible from inside the courtroom. Senator George Wharton Pepper remarked in 1927 that Oakley's murals would remind the justices of their solemn duty and the advocates to restrain their passions and compel candor, and that these paintings would serve as a silent but convincing witness to those things without which we build in vain. Counsel, before we hear the first case, I'd like to remind you of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a very short summary of the case. You may then begin by stating your name and the party you represent, and please introduce your co-counsel to the court. The justices are familiar with your cases, so I ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues upon which we granted review. Counsel is welcome to rely on their briefs for particular issues if they so desire. In cases in which there are multiple parties represented by separate counsel, you should avoid repeating the same arguments as prior counsel. Please try not to interrupt the justices when they are asking you questions. A justice's question is not meant to trip you up, but rather it indicates there are particular issues we wish to explore further. While we have no set time limit for argument in this court, I will advise counsel when the court has heard enough and is satisfied that all questions have been answered. And at that time, I will ask that you conclude your argument. Mr. Minner, please call the first case.
Jonathan Barris versus Stroud Township. Representing Township, Mr. Neil Albert. Representing amicus, the Office of Attorney General, Mr. J. Bartolone. Representing Mr. Barris, Mr. Paul Kramer, Jr.
Good morning. The question in this appeal is whether a township ordinance is facially unconstitutional under the Second Amendment to the United States Constitution. The challenged ordinance limits, with certain exceptions, the discharging of a firearm to shooting ranges which are restricted to 2 non-residential zoning districts. Further, the ordinance requires that a shooting range is compliant with NRA safety standards, is on a 5-acre minimum lot size, and has a 150-yard minimum setback from adjacent occupied structures. If that is roughly correct, please proceed.
May it please the court, counsel, I first of all would like to second the remarks of the Chief Justice that it is a great privilege to engage in the practice of law in a setting like this. My name is Neil Albert. I am special counsel for Stroud Township. With me on oral argument is Bart DeLone, the Chief Deputy Attorney General for the Commonwealth. We will divide oral argument as follows. The Commonwealth will argue all issues related to the Bruin case. The township has some brief remarks relating to non-Bruin reasons for reversal. I would note that those issues were not briefed because of the court's ruling to address Bruin. However, they were preserved for review in the petition for allowance of appeal of the township, arguments B and C. And I would note that this court had already granted the township's petition for review before Bruin was ever decided. With that as an introduction, when the Commonwealth Court heard this case in 2021, the leading and most recent Second Amendment case of importance was a 2018 Third Circuit decision, New Jersey Rifle and Pistol versus the state of New Jersey. That was a case involving the constitutionality of a 10-round magazine limitation statewide. The Third Circuit found that there was no core Second Amendment right involved, applied an intermediate scrutiny test, and determined that the regulation did not unduly burden Second Amendment, that it was a reasonable fit, and the regulation did not have to be the least restrictive way of achieving the state result. Now, this case was a lengthy opinion and was thoroughly addressed in the Commonwealth Court. Commonwealth Court said it adopted the reasoning of the Third Circuit, but reached the opposite result. And further, it reached the opposite result on a state of facts where the government interest was far stronger. New Jersey Rifle and Pistol was a case turning on the characteristics of a firearm, the magazine capacity. Barris is a discharge case. Whether a firearm holds 1 round or 10 rounds doesn't matter unless it goes off. The minute a firearm goes off, whether it has 1 or 10 round magazines, it's too late. The harm has already occurred. And we felt that the Commonwealth Court would recognize the heightened governmental interest in regulating the place where discharge occurs compared to the right that was held sufficient in the New Jersey case. There are 2 ordinances in play, as the court has already noted. Ordinance number 9 of 2011, which I will refer to as the safety ordinance, with 2 relevant sections. There's section 3 that has a general ban throughout the township on the discharge of firearms, and section 4, which allows discharge under special circumstances, including allowing shooting on ranges in the rural districts of the township, but prohibits throughout the township any shooting at night and any shooting within 150 yards of an occupied structure in the township. That 150-yard restriction is referred to in the Commonwealth Court opinion as a proximity limitation, just so the court is aware. I'm going to very slightly paraphrase a short quote from the Commonwealth Court opinion, which is the heart of the problem here. Although the ordinance did not apply time and proximity limitations throughout the township, it's conceivable that such time, proximity, and property size limitations could pass constitutional muster. These limitations do not apply to Mr. Barris's conduct or property. As the dissent by Senior Judge Ledbetter correctly noted, that's exactly what Section 4 does provide. The failure of the Commonwealth Court to understand Section 4 led to the Commonwealth Court conclusion that the entire ordinance was based upon zoning issues, and the case was decided on the zoning exceptions rather than on the safety ordinance itself. The Commonwealth Court actually almost got it right. It did recognize that there was a special government interest regulating safety of discharge of firearms, and the court actually noted that there are different safety regulations for firearms than would be in the case for safety regulations about swimming pools.
Wasn't the sorry to interrupt your flow, but wasn't the point of the Commonwealth Court that the way your zoning and safety ordinance were structured, it wouldn't have mattered in this case, because you could have a resident with a 100-acre parcel of property that was surrounded by mountain ranges to ward off the back of the zone. But if it wasn't in the two specific districts where your safety regulations apply, the OS and the other, if it was in a residential district, for example, there's no way that the owner of the property could put up a private gun range. Well, isn't that the problem that the Commonwealth Court was articulating in that passage?
At times, the Commonwealth Court appears to go that way, and at times it seems to focus on the zoning. I have studied the opinion many times, and it's an opinion you can pull from various places, various decisions out of. The Commonwealth Court did seem to be aware at times, Your Honor, of exactly that, and at times not.
And isn't that the truth of the matter, that if you had a private residence who owned the appropriate amount of land in the appropriate setback zones, unless their property was located in the two specific zones that you set forth for gun ranges, regardless of the physical requirements of the zoning statutes, they would be unable to have a private range.
That is correct, Your Honor. Yes, yeah, that is no question. That is correct. That's what Section 3 says, and Section 4 implies if you're not with an exception. Yes. Okay. The Commonwealth Court actually almost got it right. It said that the shooting ranges have separate safety requirements from swimming pools, and presumably that's a gesture at the off-site impact. The court recognized that constitutionally a government could regulate shooting ranges as far as minimum lot size, setback requirements, could constitutionally require that a shooting range be designed and constructed according to NRA safety standards. And the Commonwealth Court actually threw in one that wasn't even in the ordinance, that it could require a yearly reinspection by law enforcement authorities. That was something we didn't even have. And as already noted, although the Commonwealth Court was mistaken about the application of the separation distance to the Barris property, it acknowledged that separation distances might be constitutionally permissible. Now, the 150-yard separation distance from an occupied structure was not arrived at independently by the supervisors. This tracks the game code. The game code has a concept called safety zones, which regulate a number of safe hunting practices. Yes? Because of the safety zone, Your Honor?
You have a minimum lot size.
Yes.
Even if Mr. Barris had the required acreage to meet that lot size,
Yes.
he would not be allowed to have a gun range on his property, correct?
Oh, yes, Your Honor. I agree with that. Yes.
Even if he could meet every setback requirement that you have in your ordinance,
Yes.
he still would not be able to have a gun range on his property.
That is correct.
So I understand
Well, it wouldn't have mattered because the township supervisors, in their legislative discretion, made a determination that in a township this populated, it was a township-wide ban on discharging firearms was reasonably necessary to protect the citizens of the township.
And that's, I think, the facially constitutional challenge that Mr. Barris has in this case.
Your Honor, I had wished that the opinion had wrestled with that, because there have been discharge cases in first-class cities and second-class cities. There has never been a squarely presented discharge case at the appellate court level, and this one was very unsatisfactory. It did not grapple with that. It sort of went off on the side issue of zoning, whereas I would have welcomed a square discussion of the discharge issue. We didn't get it. But yeah, the court's is absolutely right. There's a township-wide ban, and it wouldn't have mattered as long as he wasn't in one of those two zones. He doesn't get a shooting range. Yes. Okay. Anything further, Your Honor, or shall I continue? Okay. 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 The 150-yard separation distance is from the game code, which defines safe hunting practices. And I would add that the 150-yard separation distance, where shooting is allowed by a hunter within 150 yards of a occupied structure, involves the context of simply the possibility that there might be a shot let off by a licensed and trained hunter, and only during hunting season. What in this case, we have a shooting range, which involves the dawn to dusk shooting, could be continual, and there are no restrictions at all at who can do it. Anyone with a deed or a lease or even permission can use this shooting range all day long. Now, I believe that the Commonwealth Court analyzed the safety ordinance like an overbroad zoning regulation. The fact that commercial car washes are limited to certain districts does not mean an individual can't wash his car in his own driveway. There was a dissent by Senior Judge Leadbelter to the effect that, which was thought a great judicial understatement, that there is a difference between maintaining a private shooting range and washing your car in your driveway. She called the 150-yard separation distance an obvious safety measure, and said it defied logic that it would not be applied throughout the township. I think Judge Leadbelter clearly understood what Justice Mundy's point about the ordinance, and was analyzing it and finding that it was a reasonable exercise in legislative discretion. In summary, the result reached by the Commonwealth Court was not necessary. If the Commonwealth Court had construed this as a safety measure, had given this ordinance the presumption of constitutionality that ordinances are entitled to, had followed the logic of New Jersey rifle and pistol, if this needed to be considered only as a intermediate scrutiny test, the court would have followed New Jersey rifle and pistol, and we would not be here, or at least we would not be here as the appellants. The effect of that decision was to give Mr. Barris the right to a shooting range that conflicts with both Section 3 of the safety ordinance, which is the township ban, and Section 4 that creates a 150-yard separation distance, apart from any zoning considerations. Created right for a permanent shooting range in a spot where no one is allowed to hunt. Furthermore, this property is surrounded on three sides by residences, and there's a Best Buy 400 feet away. And in the 8 years I have had the privilege of representing Stroud Township in this matter, there has never been any suggestion that Mr. Barris intends to erect a range that's compliant with NRA safety standards.
Counsel.
Yes.
It appears that your entire argument is based upon the Commonwealth Court's decision. That was written before SCOTUS came down with Bruin.
Yes.
How do you address it now? Are you reserving that for counsel?
That is being reserved for counsel, Your Honor. I have reserved all Bruin arguments for counsel. My concluding remark, actually just building on what you just said, As our brief indicates, the township agrees with the Commonwealth's position in every respect, and we expect this court is going to decide based on Bruin. But this case requires reversal, even if Bruin had never been decided.
Questions for counsel? All right, thank you.
Thank you, Mayor.
Welcome back. You're a familiar face in this courtroom.
Thank you, Your Honor. Madam Chief Justice, and may it please the court, my name is Bart DeLone. I'm with the Pennsylvania Attorney General's Office, and I'm here on behalf of the Commonwealth of Pennsylvania as amicus curiae. As my friend from the township pointed out, I'm here to address the Bruin case, and specifically what the test is under Bruin and exactly what issue is being presented in this case. Bruin presents a two-part test. First is whether or not the conduct at issue fits within the scope of the plain text of the Second Amendment. Second is if it meets that, the government must demonstrate that the regulation is consistent with historical traditions of gun regulations. And I think to address that standard, the first thing you need to make sure you understand is exactly what issue is being presented in this case. And this court identified the issue when it granted aliquotter, which is whether or not the Second Amendment consistently provides for shooting ranges at all private residences. And we think the answer to that question is no. And we also think that it doesn't fit within the plain text of the Second Amendment. There's nothing about shooting ranges. There's nothing about the construction or operation or safety procedures under the Second Amendment, and that's the first part of the test. We think the analysis can and should end there.
Excuse me, didn't the Heller case from the United States Supreme Court stand for the proposition that well-regulated implies the imposition of proper training and proper discipline with gun use?
Yes, Your Honor. I think training is an element that's within the Second Amendment, and if this case were like the Ezell cases, for example, where you were talking about a complete ban on training, that might implicate the plain text of the Second Amendment, but here we don't have that.
Would you agree that if you're going to train with a firearm, you would necessarily want to have a gun range to do it?
I would agree that you should have an opportunity to go to a gun range. I don't think it's necessary that you have a gun range at your own residence. And in fact, both the Ezell courts, the Seventh Circuit courts, Ezell I and Ezell II, recognized that municipalities have the right to time, place, and manner restrictions on where and when gun ranges can exist. The problem in Ezell was, in both Ezells actually, was that one was an absolute ban and the other one, Ezell II, was a practical ban throughout the city of Chicago. And here you don't have that.
Well, you have two districts that allow gun use, but like I asked your co-counsel, you could be a property owner that lived in an R district, not included by the township's two districts. You could have the required property size, you could have the required setback requirements, and you could meet every other standard set forth in the township safety and zoning ordinances, and you could still be denied, or you would still be denied, the ability to use your property to train with your firearm.
Well, the ordinances stem from the idea of public safety, and whatever the limitations are, if you don't meet one of them, you would not be able to have a gun range.
Well, I'm talking about not meeting the safety requirements. I'm talking about not being able to fit into your zoning schemat because you're not in the two specific zones that would allow it,
Well, Your Honor.
such as Mr. Barris.
Yeah, but Your Honor, the identification of those two zones also have to do with population density, which is in the record even in the Commonwealth Court's decision. So that's all part of safety. And again, we don't think having a shooting range at your individual residence is within the scope of the Second Amendment's plain text, and that should be the end of the analysis. But even if it were not the end of the analysis, the second part of the test is whether or not it's historically consistent with traditional gun regulations. And as we point out in our briefing, that has been true throughout the centuries. Both Heller and Bruin make it very, very clear that they are not reorganizing the entire legal landscape, and that they were addressing very specific limitations that were, if not sui generis, certainly outliers.
Counsel, following up on Justice Monday, in Heller, the High Court interpreted well-regulated mission to be training. Does that mean Barris's conduct falls within the plain text of the Second Amendment?
Barris's conduct? You mean having a shooting range at your home?
For the purposes of discharging?
Yeah. No, I don't think it does.
And the question I also have, following up on Justice Monday's question, if I'm not mistaken, in Heller, they called the well-regulated militia a prefatory clause, that the operative clause was the right to keep and bear arms.
Yes, Your Honor.
How do we ignore that section?
I don't
Are we giving priority to a well-regulated militia despite Heller's opinion that that's only prefatory and we need to keep the concept of the right to keep and bear arms?
No, we agree with the analysis of how you break down the Second Amendment. It is prefatory. The right to keep and bear arms, as I said to Justice Monday, may have within it implicated the right to have a certain amount of proficiency. But if you are able to go somewhere and practice shooting, then that proficiency is allowed. And that's the big difference between the Ezell cases at Drummond, and frankly, that's the big difference that the Commonwealth Court majority decision talked about, which is they looked at it as, are you having a ban on this person having a gun range at their home? And, Your Honor, I don't see how you can read any part of the Second Amendment as allowing for a constitutional right to a gun range at your own house.
Well, and prior to Bruin, how do I phrase this? There used to be the two-step means-end scrutiny approach.
Right.
And then this whole concept of core rights and corollary rights.
Right.
Is it your position, or what's your position with regard to the fact that training is considered a corollary right, for which Bruin knocked that test out? So I guess the question I have is, if we assume it's a corollary right, does it still exist now that we have Bruin?
Yes, sir, I think it does. I think there is a training element, but as this court identified the issue itself, that's not the issue in this case. The issue in this case is whether or not there's a constitutional right for every individual in Pennsylvania to have a gun range in their house or around their house, even though there's a Best Buy, 400 feet downrange.
Well, even without getting into the specifics of the Best Buy and exactly what was near this proposed gun range, is there anything, looking at the plain text of the Second Amendment, that would prohibit municipalities from regulating the location of shooting ranges or prohibiting target practice in residential areas?
No, there's nothing. And as a matter of fact, I think it's important to emphasize that in Ezell 1, Ezell 2, the Drummond case in the Third Circuit, and even the Commonwealth Court decision below at page 225, they recognized that municipalities have the right to regulate gun ranges. They all say that. What the Commonwealth Court got wrong, and it's understandable because the decision was made pre-Bruin, is they went on to do a means-end scrutiny test which I think, Justice Mundy, your question's related to that. And that is no longer the applicable analytical framework. All you have to do is decide whether or not there are historical analogs for the kind of regulations that the township did here. And we identified all sorts of, I won't go in it in detail here, but we identified all sorts of such regulations going back to the 1714 through the colonial period up through the post-Civil War period, replete with examples of townships and cities saying, we can tell you when and where you can have a gun range. We can't.
The two areas you were looking at, the plain text of the Second Amendment
Right.
and the historical treatment.
Because that's the test that Bruin, if you stop at the plain text and it's not covered within the plain text, and we do not think that having a shooting range in your own residence is covered by the plain text, then you're done. But if you assume that it's somehow covered, then you look to the historical analogs, and we identify case after case after case where municipalities did exactly what the municipality did here. They looked to the population density and they tried to come up with certain regulations to maintain public safety.
What is the appropriate historical framework? Is it 1791? Is it 1776? Is it 1868? Is it 2010 when
Your Honor,
the Second Amendment
Bruin
was
left
incorporated
that
to the states?
Bruin left that question somewhat open. The majority said we could either look to 1791 when the Bill of Rights were ratified, or we could look to 1868 when the 14th Amendment was ratified. They left that question open because in Bruin, the historical analogs were clear. And I would suggest to this court that you can do the exact same thing. Because the historical analogs exist in the colonial period and also exist post-Civil War, the answer is the same either way. I would suggest that if the court wants to make a decision, that since this is a case involving state law that arises under the 14th Amendment, the more proper approach is 1868, which obviously covers the colonial period. But either one gets you to the same answer.
Why not 2010?
Your Honor, I think the whole point of Bruin and Heller before that is that you are looking to the way the population understood these provisions when they were adopted. So I don't think...
Even though for 160 years, no one actually looked at it that way.
Yes, Your Honor, that's what the court said, and the court pointed out, for example, in cases like New York v. Sullivan, that there was a lot of waiting around until they figured out the limits of liability, but the court is very clear in either of those cases that you have to make your analysis based on what either in and around 1791 or 1868, and in our case, Your Honor, the answer is the same either way.
Is it safe to pick the time at which the 14th Amendment was adopted, or...
Excuse me?
Is it safe to pick 1864, 1868?
Oh, yeah, of course it is. That's the Bruin very specifically and very explicitly left the question open. It's actually kind of interesting. In the opinion itself, even though they said we're leaving the question open and academics have differed, the majorities cited to two academics that said the proper answer is 1868.
Commonwealth. Who bears the burden to prove plain text? Is it the government or is the challenger of the statute?
No, Your Honor. The plain text part of the test is the burden of the plaintiff. The court in Bruin made it very clear that there is a presumption of constitutionality once you're past the plain text test. And it says when the plain text test is passed. That's at Bruin 2126. They also refer to it again at Bruin 2141, note 11. So it's very clear that the plain text part of the test is plaintiff's burden. Obviously, if you get past that, it's the government's burden to show that the regulation is consistent with historical traditions.
Is there any information in the lower court with regard to the historical context?
I really don't think there is, Your Honor, and I don't blame the lower court. They didn't have the guidance of Bruin.
Understood.
I think that in one sense they recognized that what they were dealing with and the way they framed the issue was, is there a ban on a particular individual having an individual gun range in their house or around their house? And I think they got that right, but then they went on to do a means-end scrutiny test, which is no longer applicable.
I understand. So, in your view, is it if it would be a finding of this court that the opinion in Heller instructs us to find that the plain text covers use of firearms for training, and we have to go to the second prong to get to the historical context, remand would be appropriate to the township?
I didn't understand the last part of that question, Your Honor.
If we need to get to the second part of the Braun test, in your opinion, would it be appropriate to remand to the township for further hearing on that matter to establish a record in that regard?
You certainly could remand, Your Honor, but the court in Bruin makes it very clear that this is a legal analysis that they're asking courts to do. It's in a historical framework, but it's still a legal analysis. And even though Heller and Bruin talk in terms of nuances with respect to the whole historical analog, with all due respect, we don't think this case has much nuance. And we think the historical analog is as clear as it can be, frankly. And
You said you don't think this case has much what?
nuance. I think it's pretty clear, and I think given the historical analogs and the guidance that the United States Supreme Court has given in Bruin, this can be resolved by this court right now. If the court feels it's necessary to remand, obviously you have the authority to do so. If there are no other questions?
Thank you, Mr. Goli.
Thank you. Thank you.
Let's hear from Mr. Kramer.
Good morning. Good morning, Justices of the Supreme Court. I'm Paul Kramer for John Barris from Monroe County. I was well into my brief in this matter when in June of last year I got a letter from this court saying drop everything and analyze Bruin. With due respect to the analysis provided by Stroud Township's attorney today, I don't understand what that has to do with Bruin or the Second Amendment. I do respect the Commonwealth's position of the distinction about whether or not it's a core case. Clearly, to keep and bear arms, keep Heller, bear arms, Bruin, and so forth. It's in the prefatory clause that a well-regulated militia brings up the issue of the right to train. So whether or not it's a core Second Amendment right has not been decided yet. Apparently the case in Ezell believes it definitely is a core right. But I don't think that's what we're here.
If it is also a right to train, how do you expand that to the right to do that in your own backyard?
I'm sorry, Your Honor?
If you do construe the Second Amendment as including the right to train,
Yes.
How do you expand that to include the right to have a shooting range and train in your own yard?
Well, that assumes that historical analysis controls. I'm not trying to expand it. I am assuming for purposes of my argument that it is a core right.
But even if you do assume that the training part, in order to bear arms, you have to be trained to do so. I understand your position. How do you translate that or expand that into where you train? Can't you go to a shooting range 10 miles away or 5 miles away as opposed to having it in your own home?
I would agree with that. That isn't the burden of proof. I haven't spent a whole lot of time on that issue. And indeed, it's possible, as I've told my client a dozen times, it's quite possible if you overturn this ordinance, another one can be drafted demonstrating that you can't shoot there. But it's Stroud Township's burden today to identify an American tradition justifying Stroud Ordinance 9-11, and they have to use historical analysis. Stroud Township and Attorney General, and I'm relying on their briefs, haven't provided any historical analysis. They've only provided regulations.
Well, let me ask you about that, counsel, because one of the one of the many historical precedents that we were given, and there are a number of them, was a law from the colonial period here in Pennsylvania, and it was very colorfully entitled an act for the more effectual preventing accidents which may happen by fire and for suppressing idleness, drunkenness, and other debaucheries. And it banned target practice within Philadelphia and surrounding towns, prohibiting anyone within any of these areas of the province from firing any gun or other firearm without the governor's special license. So, and there are a number of other precedents we've been offered. So, we've been given, in light of the Bruin precedent, a number of markers indicating to us, or suggesting to us at least, that there is a history and tradition in our nation of restrictions on shooting ranges, on target practice, and what have you. So what is it that you can tell us in the history and tradition of our country or of our Commonwealth that would suggest that your client has a right to a shooting range on his own property? In other words, why does the Second Amendment give him a right to step out of his back door and start shooting rather than step out of his back door and drive a few miles to a range?
I would use the argument that Excel uses, first of all, that the ability to train is needed to make conditions and circumstances safe in that case. And again, in my response to Justice Todd's answer, it could be, if this ordinance were drafted properly, it would demonstrate danger and not allow my client to have a shooting range on his 4.5-acre property. I don't know whether that answers your question or not. And to be perfectly frank with you, I haven't really explored that, why does he have a right here? I'm treating Bruin strictly on historical analysis. And what is historical analysis? Well, Bruin doesn't beat around the bush. There's a paragraph in Bruin that says specifically it's founding era scholarship. 2, it's 19th century case law and comment. 3, it's congressional discussion. 4, it's post-Civil War commentators and case law. Bruin's not interested in various locales where they draw the line. Bruin wants the wisdom of how and why those lines are drawn. Now, the ordinance that that you pointed out a moment ago has more explanation and rationale than most ordinances do, but it's not within the criteria. It's still a regulation. The examples that Bruin and Heller and Bruin use regarding historical analysis, I've just picked a couple. An 1849 treatise, a 1868 scholarship promoting the fair use of weapons, they're both from Heller, an 1880 judicial essay discussing practice in safe places. Again, these are examples of what the Supreme Court considers historical analysis. Bruin uses a citation to the 1689 English Bill of Rights, And there is an 1868 Reconstruction era report. Justice Thomas really says it all for me. Quote, "A handful of jurisdictions does not demonstrate a tradition of prohibition." I couldn't have said that better. I think the Supreme Court recognizes, yes, you can show me 10,000 regulations where different jurisdictions have drawn lines, but there are probably 10,001 that have no regulations. So they want to know, again, the wisdom and understanding behind that. If you would indulge me just 15 seconds regarding the facts. My client sets up a shooting range. Neighbor called, he shoots for a while. Neighbor calls police 3 times. Police come out, different sets of police, people trained for safety reasons, and say, "It looks safe to me." And they tell that to the neighbor. Neighbor calls the supervisor, who, based on absolutely nothing but that telephone call, drafts and passes Stroud Ordinance 9-11. This court recently, in a Rufo versus Board of Review case, said clearly a regulation must not be beyond the necessities of the case and must show a real and substantial relation to the problem. In other words, this Stroud Ordinance didn't show it was needed. It didn't show there were less restrictive measures. It didn't consider the impact on its citizens. It didn't consider the limits of police power that this court uses, again, as recently in the Rufo versus Board of Review case that I mentioned. I don't think Bruin intended to eliminate one constitutional test and replace it with another. I don't think Bruin expands the police power limitations.
Counsel, can I follow up with you on that? I thought Bruin expressly did that. I thought Bruin said something to the effect that the 2-part test that's being used is one step too many. The only step that counts is the historical analysis.
Well,
the only step that counts is whether or not it's a right that's either a core or corollary right.
Right.
Period. After that, you look at the history. You don't do a means-ends analysis. I mean, I thought that's specifically what they said. It's one step too far.
I think Justice Thomas did not like the means scrutiny test.
Yeah, but I mean,
which had that extra step.
I mean, the majority opinion starts out with the proposition that I just stated. What's being used in the lower courts goes one step too far. And which means the means-ends analysis was one step too far. But you're suggesting we should still do that?
Yes, in certain cases. For example, if you determine that firearm discharge was not a core right, I think we could default, for lack of a better word, to the means scrutiny test. I don't know whether that answers your question or not.
Counsel, the concept of Bruin was the state of New York required a person to show special need for self-protection to receive an unrestricted license to carry. So we're dealing with the actual possession of a firearm. The case before us is dealing with its discharge. Your argument is that the opposing counsel has not provided historical context, yet the Office of the Attorney General, out of a 28-page brief, 15 of those pages share with us the historical issue or laws regarding discharge, that being target practice. Share with me, how can you make your argument when the concept Bruin and all Justice Thomas's concerns was concerning the right to carry, possess and bear arm? This case is discharge. Share with us how you make that not an issue.
I think, given the facts of this case, the possibility remains that John Barris, again, I've already said that before, might not be able to use his lot, as is the case. But if you look at the analysis in Excel versus Chicago, there are several versions of that case. It says we have a circumstance there that he has no other place to go. Chicago just said no shooting ranges. No.
With all due respect, counsel, I'm asking you the question with regard to the case before us today. You keep citing Bruin, you keep, referring us to Justice Thomas's concerns that you believe in. The question is, that was to protect an individual's right to carry. Pennsylvania, Stroud, is not trying to preclude Mr. Barris from possessing and owning a firearm. He's trying to, the government is, under its police protections, is trying to protect the public. Why are they not permitted to restrict or regulate the venue for a discharge of a firearm? Under its police powers.
I understand. Justice Doherty, if for no other reason, simply because in order to do something like that, Stroud Township has to demonstrate that there's an historical tradition.
And I share with you, you don't think 15 pages of the various states and municipalities, as indicated by counsel's brief, is sufficient enough?
They're not regulations. The 15 pages, if I remember correctly, he's got much case law and comment in there, which I think qualifies as one of the 4 criteria for historical analysis. But it is, again, we're talking a specific place in here. And as far as a tradition, you might be asking me, what would I do to try to prove there is an historical tradition for John Barris's circumstances? And I can't answer that at all. It could be safe. Three sets of police officers thought it was. It might not be safe, but we don't know the answer to that.
And that's all prior to the establishment of the ordinance, correct, sir?
Correct.
Okay. So the law changes.
Yes.
So considering the law changed, and now there's a restriction applied regulating the venue of discharging a firearm, share with me, or us, how that is an infringement upon your client's right to possess the gun, just not discharge it unless he goes to the appropriate zone.
Understood. I agree with that.
Okay. Thank you.
I think the issue of limitations, I think the police protection limits, as in the Rufo case that this court ruled upon, is a limitation before consideration of historical analysis. Heller had limitations. Yes, you can have a gun in your home, but you can't if you're mentally unsound or if you're a convicted felon. Bruin has limitations. You can carry a weapon, but it can't be a sawed-off shotgun. And it can't be in a sensitive place. And I wish Bruin had mentioned more about what a sensitive place is, but they haven't. And so I think that if this case were before the Bruin court, I think they would say, we can't proceed to historical analysis because this case isn't up to snuff regarding the police powers granted to jurisdictions. So what I'm requesting this court to do is find that the case, well, first of all, find out there's no historical analysis, only a batch of regulations that Justice Thomas doesn't favor. Alternately, I ask the court to find that this case doesn't warrant consideration of historical analysis because it exceeds the local police powers. And I ask the court in that regard to adopt the reasoning of the Commonwealth's court decision as demonstrating an abuse of police power.
Counsel, right here. Don't you agree that the ordinances and regulations that have been presented to us as the history of regulation deal with the intersection of Second Amendment rights and police power? Isn't that precisely what those ordinances and regulations do?
Yes, I want to say yes. I mean, they don't treat the Second Amendment or mention it. I mean,
well,
they're so varied in
with guns.
Yeah, they're so varied in scope that it would be hard to say one is the case that you suggest and one is not. Again, I think that's Stroud Township's burden of proof.
Well, but I'm asking you. I mean, what ordinance doesn't represent some exercise of the police power. I mean,
I'm
that's
sorry.
what they do. These ordinances represent an exercise of the police power regarding discharge of firearms, location of discharge, all in the context of the exercise of police power by the local regulating body.
Sure.
So why isn't that an appropriate historical analog?
It is.
Okay, so then the 15 pages of examples that we have is an appropriate focus for us in determining the historical background.
Depending on the scope of each particular ordinance. Again, and I don't think we have very much in the way offered us by Stroud Township and the Attorney General.
Well, your critique, as you started your argument today, and certainly as indicated in your brief, is something, if I'm understanding it correctly, is unless we have historians who have written on the history of this issue in 1791 or at the time of the 14th Amendment, then we don't have the historical background. So you're suggesting that we need to find historians who interpret the ordinances that have been presented to us in order to have the historical background that you think is necessary under Bruin.
Yes. I think if Township were to draft an ordinance, they would, of course, have to be within the police powers. Do they have to address the Second Amendment in that regard and address historical references? I don't believe they do. That's not what jurisdictions do. I think it has to proceed to this level or to a Commonwealth Court level or something where the court analyzes historical analysis.
Mr. Kramer, do you agree that this court could take, if we so choose, could take judicial notice of the various historical regulations and laws, basically the history on this issue? Do you think we can do that on our own? Is it appropriate for us to conduct that analysis?
I want to say that's not what Justice Thomas laid out for us. Again, he says, don't show me a batch, I think the word, don't show me a batch of regulations. I don't know whether that means he doesn't want to look at regulations at all. That wouldn't
But
be
I wonder, isn't the concept of judicial notice more broad than just looking at regulations? I mean, if we want to look at the entire historical context, we could, if we chose to, correct?
I would agree. I mean, if the court would like to look at other circumstances compared to my client, they certainly can call that into account. But first of all, we don't know what my client's circumstances are, really. But I agree with you, largely. But, well, justices of the Supreme Court, it's a privilege to be able to bring this case to you, and I'm off to the Poconos.
That's a very good closing, Mr. Kramer. All three of you, counsel, did a tremendous job and represented your clients and amicus well, so thank you.
That was good.
Mr. Minner, want to call the next case?
I think if you close the session, I'm sitting now and not to. Yeah, that's ours.
Good morning.
This appeal, we review the Commonwealth Court's grant of This administrative rule would place annual caps on the total emissions of CO2 by such power plants by requiring them to purchase at public auctions an allowance for each ton of CO2 they will emit in that boundary. Also before us is the Commonwealth Court's denial of a petition to intervene in this litigation by several environmental groups. Please proceed.
Good morning, Your Honor, Madam Chief Justice and the Justices of the Court. My name is Matthew White. My co-counsel is Tom Hazlett, my partner as well. I'm here on behalf of Acting Secretary Richard Negrin of the Department of Environmental Protection, and as the acting chairman of the Environmental Quality Board. If it's okay with the court, I will refer to the department and the Environmental Quality Board just as the department or the agency. Technically, when this case started, it started in a different procedural context, and it was just an action by the acting secretary, the then acting secretary, to get the regulation promulgated. I think it's now easier just to think about this as an action, an injunction against the department.
Counsel, could you lift the microphone?
Yes, I'm sorry. Is that better?
Yes,
thank you.
Thank you.
Counsel Jessica O'Neill is representing intervener parties. There's actually 3 separate appeals. It's my understanding that I'm going to address the injunction against the department, and Attorney O'Neill will be addressing the intervention issues. She will also be addressing some separate issues that her clients have with respect to the Environmental Rights Amendment and how that impacts the injunction as well. It's not an argument that the department made.
Counsel, before you start, let me ask you that question. I mean, the department is not taking the view that the Environmental Rights Amendment comes into play in this case?
Your Honor, I think our position is that the Environmental Rights Amendment applies to all actions taken by the Commonwealth that impact the environment. But from the regulatory standpoint, the Environmental Rights Amendment was not relied upon by the department in promulgating the regulation. So I agree with Your Honor that it does apply to the actions and the court's actions to enjoin this, but it was not anything that was part of the record in the promulgation of the regulation.
You're going to be addressing the distinction between taxes and licensing fees?
I'm going to be addressing that and some other issues with respect to the injunction as well.
Okay, so I'll save my questions about the Environmental Rights Amendment for that point in time then.
Thank you, Your Honor. This court and the courts in the Commonwealth have consistently set forth a 6-part test for granting a preliminary injunction. It's standard in that test that the moving party bears a heavy burden to establish each and every element. These elements include a clear right to relief, that the moving party will suffer irreparable harm if the injunction is not granted, and that the harm the moving party will suffer outweighs the harm caused by the injunction. In this case, the Commonwealth Court, in practical effect, collapsed the 6-part test into one question. 4 individual legislators, 4 senators, who opposed the RGGI regulation, raised merely a substantial question that the challenge regulation was contrary to law. When the court made that finding, it by definition found that there was per se irreparable harm. Once the court made that finding, it then found that the moving parties won all the other elements. And the court did no analysis of the 6-part test, much less any analysis that would put any kind of substantial burden on the moving parties to establish the right to relief. If a preliminary injunction to an executive agency regulation by individual legislators is going to be decided by a 1-factor test, then instead of the 6-factor test, this court should explicitly say that's the case. But we don't think that's the law of Pennsylvania, and we don't think it should be the law of Pennsylvania.
Counsel, when is it appropriate to deviate from the requirement of clear right to relief and fall back on the presentation of a substantial question?
Your Honor, it's a very interesting question. The concept of substantial, in injunction practice generally, for civil litigation, not necessarily involving agency regulations, the test is clear right to relief. This court has developed a shorthand, I think, that says a substantial question. I believe, coming out of the Marcellus Shale case, initially with then Judge Brobson, and some other decisions, that the substantial question was simply a way to say you don't have to prove, the moving party doesn't have to prove that they're right on the law. They just have to prove that there's a substantial question. I view that as...
What does that mean? I mean, let me suggest to you my understanding of the deviation from clear right to relief. And I'm going back to Fisher versus DPW 1, which was the injunction of the Abortion Control Act provisions on Medicaid back in the early 1980s.
Okay.
That court first found that there was clear irreparable harm that would ensue. Second, found that this was intended to preserve the status quo, the entry of the injunction. Only after finding that all of the other elements necessary to establish a right to a preliminary injunction did the Fisher court, quoting some of its previous cases, only then can you deviate from the clear right to relief and say there's a substantial question here, and since all of the other factors have been met, we will, enter the, they entered an injunction in that context.
I agree with that, Your Honor. I do believe that that's what's been missing from some of the more recent cases that come out of Commonwealth Court, that analysis that says the other elements have to be met first before you find that there's only a substantial question.
Because there's no equating the phrase clear right to relief with a substantial question. 50-50 does not equal a clear right to relief.
I agree with that, Your Honor.
What percentage then of possibility of success would meet clear right to relief if 50-50 is not adequate, and we know you don't need to be 100% correct? Where in the continuum between 50 and 100 is your view of clear right to relief?
Well, I think, Your Honor, when you have the context of a preliminary injunction, which are oftentimes done in a very expedited fashion, this was fairly expedited, you want to make sure, the court wants to make sure that they are feeling very certain if they're going to use some alleged violation of law as the basis to enjoin conduct. I think that's especially the case when you have co-equal branches of government. And actually, it's not a co-equal branch of government. It's just,
I appreciate what you're saying. You adopted Justice Donahue's view that it has to be more than 50-50. The case law from this court and every other court that has ever issued a preliminary injunction in Pennsylvania is legion to say clear right to relief does not mean you have to win. So I asked you pretty simply, you agreed that it wasn't 50-50 and it isn't 100. What's the percentage of success?
well, Your Honor, I can't put a numerical percentage on it. I think that
you know it's not 50-50.
I do know that.
And you know it's not 100.
Correct.
So,
I think I would say it's north of 75.
Okay.
Counsel, if I might amend my 50-50, is it fair to say that there is a substantial question if it is an open question?
No, Your Honor. I think just simply being an area that different litigants could look at something in different lights, that's almost any case. You wouldn't be in litigation if you didn't have that. So I think just because it's an open question or something that hasn't been decided, it doesn't mean it's a clear right to relief. And I think Conversely, just because something is ironclad, it doesn't have to be ironclad for it to be a substantial question. I think it's got to be something that a court's looking at it when it has that situation in front of it, that it's something that the court has reasonable expectation that they're going to be right when they enter the injunction, and ultimately right when it gets determined on the merits.
Let me offer.
Isn't it natural to assume that after entry of preliminary injunction, on that basis, when the court reaches the merits stage, if the court reaches the merits stage, that is when the true dissecting and consideration of everything before us would take place, and that determination may or may not coincide with what we decided on preliminary injunction, because a reasonable opportunity for relief does not necessarily mean you win. Correct?
Yes, Your Honor. I mean, I think that courts are called upon to exercise their extraordinary equity jurisdiction to prevent immediate irreparable harm, but they do so if they think that they're right on the law, and it's not just something that they might be substantially right. The test, as it's been developed in every injunction case that I've seen, up until we get to some of the more recent decisions on Commonwealth Court, or if you have what Justice Donahue was saying, this sort of all the other elements are clearly met. I think the test is that it's got to be clear right to relief.
But counsel, I guess I'm not quibbling with Justice Donahue's view of the case law, that the idea that the substantial legal question phraseology usually arises in the context of a case where all the other elements are present. I guess where I'm kind of going to push a little bit is, why are we talking about the word substantial in relationship to the likelihood of success? Because I think substantial means, is this a big question? Is it dealing with abortion access? Is it dealing with a fundamental constitutional right? Is it dealing with something that is a high profile? Is it a big question? Not necessarily whether it's 51%, 75%, or 99% likely that you're going to win, but there's a question that is open and it's substantial, meaning it's important. And that's why we need to stop it from going forward temporarily, allow the merits decision to happen, and assuming all the elements are present, and then we'll have it resolved. Isn't that what substantial means?
Well, if that's the definition, then I do think you go back to Justice Donahue's formulation of it, where all the other elements become exceptionally important as well. If it's just an issue of, is this a big question that we don't know the answer to, then I think it's very important that you have to look at all the other elements, and that's another base. If that's the test, then that test wasn't passed in Commonwealth Court because they didn't look at all the other elements at all. They took the first element and said it's a big question, and then found everything else, instead of doing just the opposite of looking and weighing the irreparable harm. They went right from it's a big question, substantial, and said, okay, if it's a big question, substantial, then we don't have to do the irreparable harm analysis because that's per se irreparable harm. And then we don't have to balance because it was per se irreparable harm. So that's where Commonwealth Court went wrong on this, because I think maybe they were looking at it as a big question and then didn't look at all the other analysis first.
Yeah, counsel, let me ask a follow-up question on this substantial question. And I'm not sure that Justice Brobson and I are as far apart on this as it appears to sound. I don't think we are at all. But so the Commonwealth Court, per Judge Wojcik, recognized a substantial question and then decided it. Am I correct? Said this is likely a tax.
Yes, Your Honor. Okay. There was 4 substantive challenges that were brought, and on 3 of them he ruled in our favor, and on the issue of whether the fees were fees instead of a tax, he ruled that he thought that there might be a tax, and therefore it was unconstitutional.
Okay, let's now you're before us, and you're challenging that ruling. And we're going to have to do something with that. We're going to have to say either it's a tax or it's not. Am I correct? Now, and does that resolve that legal issue? Or is there some point in the future, again, that somebody's going to say, well, that was just on the preliminary injunction, and this court, in deciding that issue, didn't actually decide that issue of law. Would we not, in fact, be deciding that issue of law?
Your Honor, in that issue of law has to be, I think, decided, but in full candor to the court, this case, we're up here today on the injunction that was entered about a year ago. The case itself has been argued on the merits in Commonwealth Court. That argument was in November. We don't have a ruling yet, and that very issue is going to be determined by Commonwealth Court.
But if we decide it beforehand, then the issue's decided. What he's suggesting, we decided, the Commonwealth Court looks at it differently, they prevail in their ruling on that issue of law?
No, I think Your Honors have the ability to make that decision as a matter of law today. I was just pointing out that you do not have to. You have to. What's in front of the court today is whether the Commonwealth Court, in granting the preliminary injunction, made the right decision as to whether this was a substantial question of law, whether it was a big question or whether it was.
That's not the question. The question is whether the Commonwealth Court was unreasonable in granting the injunction, whether the Commonwealth Court had any apparently reasonable grounds. Our standard of review on an injunction is extraordinarily deferential to the trial court.
I agree with that.
However, if we let me just follow up on that, just so I'm clear about what we're doing here today. Do we decide whether the Commonwealth Court was correct in finding there was irreparable harm or not?
You know, this court has to look at the record, and which we've briefed, and we will argue today that the court erred in finding irreparable harm because the court did no analysis, and even on the high standard of deference that's afforded the Commonwealth Court erred. It did not make a irreparable harm analysis. On the fee issue, nobody here seriously contends that the RGGI regulation was implemented for a purpose, much less a primary purpose, of raising revenues. It was implemented to regulate producers of a pollutant, carbon dioxide, and to allow the department to better address the harms resulting from those emissions. The department has a statutory power and duty to adopt rules and regulations, quote, for the prevention, control, reduction, and abatement of air pollution. The basic structure of the RGGI regulation shows why the allowances are fees. To engage in a specific activity that imposes significant external costs, that is, putting carbon dioxide into the atmosphere, the department requires participants to purchase an allowance that gives the emitter a right to put 1 ton of carbon dioxide, a pollutant, into the atmosphere. There's a limited number of those allowances, and that permits the emitter as a regulation, it lowers the amount each year as to the number of tons of carbon dioxide that will be put into the atmosphere. By the way, the emitters are all energy producers with the 25 megawatt capacity and have to sell 10% of their energy to the grid. The regulation affects about 66 facilities in the Commonwealth. So that number's in the record, actually, page 1371, but I think it's useful to think about. We did not have this in our brief, but I think it's useful to think about that this regulation applies to 66 facilities.
Well, wouldn't the regulation though also apply to facilities outside of Pennsylvania?
No, Your Honor.
So the auction proceeds that Pennsylvania would get from participating in RGGI will not include payments for credits on the RGGI auction from facilities outside of Pennsylvania.
The department has the ability to regulate the generators of electricity within the Commonwealth. The allowances are acquired at an auction. They can actually be acquired in different ways. They can be traded. They can be, there's actually, the Pennsylvania regulation has a way to get, to do offsetting activities where you can earn allowances. But the basic method is that they're going to be acquired at these allowances. The RGGI organization manages those auctions and then distributes back to the participating states their pro rata share of the allowances that have been sold.
It's going to be commingled at that point in time. You cannot trace the amount of money that's coming from RGGI to the department's coffers to only the 66 energy facilities in Pennsylvania that you're saying are the only ones regulated by the RGGI regulation.
The proceeds are fungible, Your Honor. That's correct. But the allowances, and the allowances are actually fungible because they're tradable. But the regulatory piece of this is that the allowance, at certain times of the year, like every 6 months, the producers of electricity have to present to the Commonwealth, to the department, their allowances. They say, we put in this many tons of CO2, and here are the allowances that permitted us to do that. So the regulation, I stand by what I said, the regulation only regulates those entities. The department is not going to an energy producer in Virginia and says, show me your allowance. They don't care. But the department is coming to the energy emitters in Pennsylvania that they regulate. And that's a very important distinction.
Well, it's forcing, it's a regulation that forces the energy producers in Pennsylvania to participate in a regional auction of credits and allow all that money to be pooled and then shared by multiple states.
And actually, the regulation is written, Your Honor. That's how it's designed to be implemented, but the regulation actually has the ability for Pennsylvania just to do its own auction as well.
Sure, but you're not going to do that. That's not part of the proposal.
That's part of the regulation that they are able to do that if they choose to.
Right.
But that's not how it's designed right now. That's not what this record is. The cost of the regulation is large because the problem is large. Air pollution and the cost that it brings, especially carbon dioxide, is indisputably a very significant issue. And there's no evidence that was presented that the proceeds to be received in the Clean Air Fund exceed the actual cost of the harm to the environment.
And is that the test, counsel? Is that the test? It's the cost of administering the regulatory scheme, which in this case is cleaning up the air.
Yes, Your Honor.
In its broadest terms, as opposed to what it costs to track the allocations, what it costs to make certain that the allocations are appropriately distributed among the providers. That's an administrative cost as opposed to the cost of the regulatory scheme.
We believe that's a correct reading of this court's decision from National Biscuit, which we think is, I think both sides agree that that's the controlling case on what a fee is. What is the test for a fee? And there's 4 factors in that test. The first is the fee applicable only to a business or occupation subject to supervision of the licensing authority under its police power? The answer here is yes. The provision applies only to the 66 facilities that have to come up with the allowance. Is the supervision and regulation actually conducted by the licensing authority? The answer is yes. It's conducted, the supervision by the DEP. Is the payment of a fee a condition upon transacting the business? Yes, the allowances have to be turned in if you're going to generate the power. And is the purpose to reimburse for expense and supervision and the regulation conducted by it? This goes to Justice Donohue's point that it's both the administrative part of it, which is what the Commonwealth Court focused on, but it also goes to the regulation itself. And the proceeds that are going to be generated by the allowances are put into and only into the Clean Air Fund. And the Clean Air Fund has its purpose of fighting air pollution. And the proceeds will be used for things like different carbon capture programs, energy efficiency programs, matters like that. There's not the regulations have not been written yet on how those detailed expenditures are.
Isn't that a problem, though? Isn't it? I mean, because the test requires you to show that the amount generated by the fee is necessary to reimburse for a regulatory scheme. And there's no existing regulation or statute that says how you're going to spend this incredible amount of money that's going to be generated by this. I wonder if there's like a chicken and an egg thing, is you're going to get the revenue first, and then you're going to figure out how to spend it. That doesn't seem to be what the National Biscuit Test requires.
Well, Your Honor, the National Biscuit Test looked at, in fact, it's very interesting. In the National Biscuit Test, where the Supreme Court struck down the fees, it's because the fees only generated enough for like basic administrative costs. They said that's not really a fee. I don't want to read too much into the National Biscuit Test in that regard, because I think some of the regulations at issue were different than what this regulation is doing. But I will say that I agree with Your Honor. There's not I can't point to anything in the record that says here is specifically how these proceeds are going to be spent.
These are the costs of the programs, and this is the money we're generating to offset the costs. There's nothing like that in the record.
But the regulation itself does say, it does say in the regulation itself that about a third is going to be used for energy efficiency programs, a third for renewable energy programs, and a third for abatement of greenhouse gases, like capping abandoned oil wells and energy storage and carbon capture. The purposes are broadly laid out in the regulatory analysis form and in the regulation itself.
But is there something laid out that shows what the cost of those programs are and why the fee, is there evidence of what the cost is to administer those programs such that this is truly a fee as opposed to a revenue generating device?
Well, Your Honor, I would say that there's nothing specifically in the regulation that says here's the cost of the programs that are going to be implemented by this. But I would also add that there's no evidence that was put into this case, into this record, that says that the fees themselves and the amount of fees that they are enough to address the problems of greenhouse gas. The greenhouse gas and the co-pollutants cause. I mean, the record...
Look, I agree. I don't disagree with you. I think everybody up here would agree that, pollution and clean air and clean water are guaranteed under our Constitution, are a very important state interest and for the public. No doubt about it. But I'm looking at the next case, and my concern is, there are plenty of funds that the Commonwealth has that are inadequate to combat what the funds were created to combat. And I worry that if we're going to allow agencies the authority to just impose some sort of a fee to pump that up, then aren't we bypassing the General Assembly's authority and the governor's authority, and we're just basically allowing agencies to pump up their inadequate funds and just build these coffers?
Well, Your Honor, I have to, there's two answers to that. One is the funds themselves are in the Clean Air Fund, and there's specific regulations on how the Clean Air Fund can be spent. There's published code, Title 25, that sort of sets out what the different parameters of how the Clean Air Fund can be used. It's not going to be commingled with any other types of funds. And to Your Honor's point, there's nothing that prevents the General Assembly from enacting laws that further delineate how the Clean Air Fund can be used. That's specific.
Can I interrupt you there? I mean, are the funds that we're talking about part of the trust corpus created by the Equal Rights Amendment?
Your Honor, that's I'm going to have to defer that to Ms. O'Neill, but
frankly, Counsel, I don't understand that. The DEP is the trustee, and the inability to answer that question bothers me, because it should be the DEP that's taking a position on the role of the Equal Rights Amendment in this contest that we have. Because if these funds are indeed part of the corpus of the trust, if the funds in the Clean Air Fund are part of the corpus of the trust, then the discussion that we're having becomes somewhat irrelevant, does it not? Because these funds are only going to be used for the purpose of clean air.
And I agree with Your Honor that to the extent that clean air is part of the values of the Environmental Rights Amendment, then it has to be consistent. The department is not dodging its responsibilities under the Environmental Rights Amendment. I'm just simply constrained to argue the parameters of how the regulation was created, and it did not rely on the Environmental Rights Amendment per se.
I always have to rely on the Equal Rights Amendment. This is maybe the second or third case in the last 8 months where the DEP has presented a position and hasn't taken a stance on the interplay of the Equal Rights Amendment with what you do for a living. I mean, and if there is an entity in the Commonwealth that has frontline responsibilities for the Equal Rights Amendment, it would be the DEP.
Your Honor, I would say this, since I wasn't here for those other arguments. I would simply add that I don't think. Let me rephrase it. I know that the Article 1, Section 27 is not waivable. It applies. Period. I agree with that. Bless you.
So are these funds part of the trust corpus?
When you're saying trust corpus, do you mean the segregated funds in the Clean Air Fund, or are you talking about the trust, the environmental trust?
The trust corpus, the Environmental Rights Amendment trust corpus. I mean, is that where these funds are housed, so to speak, so that they can't be tapped for any other purposes other than the provision of clean air within the Commonwealth for this generation and generations yet to come?
Your Honor, we haven't argued that. So I'm not, it's nothing that we argued at any step in these proceedings. I think that the way we phrased the question, I think my answer to that would be yes, but I do want to be in candor. It's nothing that has been part of our briefs or part of any position that we've taken in this case.
Mr. White, maybe I'm missing something, but why not? Why haven't you argued that? Maybe I'm missing a point here, but why haven't you argued that?
Your Honor, I think it's the statutory framework for this under the Air Pollution Control Act gives the department all the authority it needed to implement this regulation. I don't think that it could incant or use the Environmental Rights Amendment as a basis for something. This court decides whether the Environmental Rights Amendment applies to it or not.
Only if someone argues it to us. I mean, or on the other hand, we too, as trustees of the trust, have obligations. But I'm just perplexed by the lack of enthusiasm, for lack of a better word, that we see from the DEP on the enforcement of the Equal Rights Amendment.
That's why I wondered if perhaps I was missing a point here, because if I'm a lawyer and I have a constitutional amendment that helps me and that I'm acting under, I probably would mention it.
Your Honor, there's nothing. I don't think Your Honor's missing any point. I'm simply presenting to this court what was how the regulation was structured, and how and I'm confined to argue based on the legal principles that were in the regulation as it was promulgated.
Counsel, maybe I can help you a little bit. Maybe I'm not sure if I can actually.
Many people have said I'm not helpable. Your Honor.
The reason why we're here is because DEP and the Environmental Quality Board, exercising its Article 1, Section 27 responsibility, created the RGGI regulation. You believe that the promulgation of the regulation and its implementation are consistent with your responsibilities as the trustee.
Wholeheartedly.
Right. So it's an Article 1, Section 27 case because it sort of justifies nobody's going to argue, we're not going to see an environmental group go, we need to enjoin the enactment of this legislation or this regulation because it violates Article 1, Section 27.
That's correct, Your Honor. And in fact, that's why the interveners believe that they need to participate in this case, because that is their focus.
And you're not taking the position that the funds, the fees that are being paid by Pennsylvania businesses under this regulation is a public natural resource.
I believe that these funds are derived, have to be used for the protection of the air.
By virtue of the Clean Air Act. But you're not saying that fees, money, paid by private businesses is a public natural resource.
Your Honor, I'm saying that the fees are generated because a polluter is paying for an allowance, which gives that polluter the opportunity to put 1 ton of carbon into the atmosphere in Pennsylvania. And the atmosphere is part of the environment and is protected by Article 1, Section 27.
Right.
So the fees that are generated from that have to be used to protect the clean air. And I think, to Justice Donahue's point, I think you get to the same place because the Clean Air Fund has to be consistent with Article 1, Section 27. And my point is that the funds are going into the Clean Air Fund, so they have to be used in a consistent manner.
All right, thank you, Mr. White. Does anyone have any further questions?
I have one question for counsel, and maybe I'm addressing this to the wrong person, but I don't think so. The proposed interveners are claiming entitlement to intervene because they are beneficiaries of the trust?
I believe that's correct, Your Honor.
Do beneficiaries of the trust have the right under Pennsylvania trust law to litigate claims where the trustee itself, as you stand in that position now, have taken on the litigation?
Your Honor, I think in general trust law that the beneficiaries have a right to have a claim against the trustee.
As opposed to participating in the litigation, such as
well,
we have here.
if their rights are going to be determined here, then I think they have an interest in participating.
Well, how is that so? I mean, there are, 13 million beneficiaries, and yet in, generations, how could it be that 13 million people have a right to intervene?
Your Honor, I'm not the expert on intervention. I'll defer that to Ms. O'Neill, but you do touch on one thing. If I may beg the Court's indulgence just to cover one more point. I would like to address a little bit about the irreparable harm per se. This Court and other courts have applied irreparable harm per se in certain situations. We think that it was inappropriate here. The irreparable harm per se tends to be situations where there's a clear violation of a law. So, for instance, in the Pennsylvania PUC versus Israel case, it was taxi cabs that were operating in violation of a licensing requirement. In the Commonwealth v. Coward case, it was a landfill that was violating orders and discharging in violation of Clean Streams law. There's another fundamental point in all those cases on irreparable harm per se. It's that the plaintiff suffered some type of harm. So in Marcellus Shale, the plaintiffs were the ones who had to incur $888,000 of cost for applications, or they had to do retroactive impoundments that were going to cost, as this Court found, between $39 and $65 million each. So here, the plaintiffs are 4 individual senators. They don't have any harm. So when you're looking at irreparable harm per se, and especially when you start with the substantial question, when you get to irreparable harm per se, and the Court says, well, there's a substantial question, therefore there's irreparable harm per se, the Court didn't even look to see whether there's any harm at all. And that's the problem here. There's no harm to these individual senators. So the harm is in the ether in that it's a hypothetical harm that maybe goes to all 13 million people in the Commonwealth who are potential taxpayers, if you will. That's the problem. There's no limitations that were applied here because of the per se irreparable harm.
Okay, thank you.
Thank you, Your Honor.
Chief, can I just ask a follow-up on sorry, we spent a lot of time on merits. We didn't get to irreparable harm. And I understand your point that you're saying that we have to look at the irreparable harm prong as well as the balancing of the harm prongs relative to harm to the plaintiffs, the senators here, right? We can't look at any other harm.
There's no other plaintiffs.
Well, not in this one, but but we'll put that aside. I just want to ask a basic question. If we reverse the injunction in this case, and Pennsylvania participates in the upcoming auction, Pennsylvania stands, if I remember the record correctly, to make probably over $100 million when the auction proceeds are allocated on a per state basis, right? Okay. Part of that money comes from out-of-state generators. Part of that money will come from in-state generators. Correct?
The proceeds are fungible.
Right.
Yes, but the allowances are not.
I understand. I'm talking about the money. We're talking about money. This is about money coming into the coffers of the Commonwealth of Pennsylvania, right? Okay. Yeah. What happens if the Commonwealth Court or this court does rule that it's an unconstitutional tax? Is there a mechanism to send that $100 million back?
Your Honor, this was in the record. It goes back to my point about allowances. The allowances could be returned to the people who presented them, and the allowances have market value because there's a market for these. So even if the RGGI regulation were ultimately, if the injunction was overturned, and then a year from now this court says nope, Commonwealth Court was right the first time, those allowances can be given back to the people who gave them, and they can be traded, they can be exchanged.
No,
they have
the
value.
allowances are going to go away because the regulation upon which the allowances were created would be struck down.
But the allowances, because they fit into the whole RGGI program, are usable by any of the other RGGI states.
So the remedy is the Pennsylvania Clean Air Fund gets to keep the money that the unconstitutional regulation gave it, and the energy producers that had to pay the money have to go try to auction the proceeds to recoup it.
The point, Your Honor, is from an irreparable harm standpoint.
I'm just asking if I got the facts right.
That Your Honor is correct, but unlike the cases where, like in Marcellus Shale, where the drillers would have to expend $80 million, they couldn't get that money back because of the sovereign immunity of the Commonwealth. In this situation, the parties that remit the allowances could get those allowances back and could recognize value off of them.
But so isn't that a problem, though? There is no remedy for the Commonwealth of Pennsylvania getting to keep the proceeds of an unconstitutional regulation? You don't see a problem with that?
I do see a problem with that, Your Honor. I'm not sure what the solution is to it.
Well, the solution is probably an injunction and let the merits be decided as quickly as possible. That might be the solution, but that was just a waxing poetically.
Thank you. Counsel, in many tax cases, we don't provide for a remedy to individuals who actually challenge a tax. And so in those circumstances, the Commonwealth is getting to keep the tax dollars that were paid as a result of an unconstitutional tax. I mean, it happens.
That's correct, Your Honor.
Not the perfect world, but we do it quite frequently in tax cases.
Okay. Mr. White, have you had enough?
I'd love to bore you guys further. Thank you.
Thank you. Let's move on to Ms. O'Neill.
Thank you very much, Your Honor, Chief Justice, Justices. May it please the Court. My name is Jessica O'Neill. I'm here with my co-counsel, Emma Bast, on behalf of Citizens for Pennsylvania's Future, the Clean Air Council, and the Sierra Club. We have referred to my clients as the nonprofits or the environmental groups in this litigation. And we're here speaking on behalf of thousands of Pennsylvanians who seek to protect their constitutional rights to clean air and a healthy environment maintained for their children and grandchildren from the threat of pollution and climate change. And Chief Justice Todd and Justice Donoghue, I think your questions to Mr. White just a few moments ago demonstrate exactly why the nonprofits sought intervention in this litigation. And I'm going to start by addressing the intervention issue, which is, of course, unique to nonprofits, and we contend the denial of our intervention was in error. And then I'm going to move on to the injunction.
Okay, counsel, let me start with the last question I asked counsel for DEP. Under Pennsylvania trust law, do beneficiaries have the right to intervene in an action such as this, or is it the beneficiary's remedy under Pennsylvania trust law to bring a breach of fiduciary duty claim against the trustee if the trustee does not adequately protect the trust?
Justice Donoghue, it's our position that the beneficiary can do either.
I'm asking you what Pennsylvania trust law is, not what, I have an opinion too, but I'm asking you what Pennsylvania trust law provides in these circumstances, because we're trying to develop a cohesive body of case law to control what occurs under the Environmental Rights Amendment. And so this is our first opportunity to address this issue, which is the ability of beneficiaries to participate in litigation such as this.
Yes, and Pennsylvania trust law provides that the beneficiary can do either. And we cited a provision of the Pennsylvania Code, the statutory trust law, in our brief, as well as a citation to the Uniform Trust Code that provides that a beneficiary can, if it wants to, provide notice to the trustee and appear alongside the trustee, intervene and participate alongside the trustee in a matter affecting the corpus of the trust. Also, if the beneficiary believes that the trustee is committing a breach of fiduciary duty, the beneficiary can bring such an action against the trustee. And the case law under the Environmental Rights Amendment is full of actions by beneficiaries, such as these environmental groups, against the trustee. But that's not what we're seeking to do here. We're not making a claim that the trustee, DEP, has breached its fiduciary duties. We're seeking to show up alongside them and intervene on the same side of the V as them. But in this case.
If they represent your interests, doesn't that preclude you from intervening?
We don't believe that they adequately represent our interests in this case.
So then it's a breach of fiduciary duty.
It could be a breach of fiduciary duty.
So instead of going through our case law and our jurisprudence, your request is to intervene. I guess the question I have, despite your intervening pursuant to our EPA, do those potential laborers who could lose their job as a result of Reggie, do they have a constitutional right and legal property interest pursuant to Article 1, Section 1, protection of their property, to also intervene so that the trade unions and the people who will lose their jobs, do they have, is it your position? I guess it is your position. They also have a right to intervene with your opposition.
Well, we don't have... I understand what you're saying, Justice Dougherty, and those groups showed up in this litigation. They are present in the companion case that's not before you right now.
I'm discussing this case. You are asking us to permit you to intervene because the DEP is not representing your interest and you choose not to file a breach of fiduciary duty. You're asking us to overturn the Commonwealth Court who felt your rights were interested. And all I'm suggesting is if we were to do that, did we just now open the door to the plethora of laborers who fear for their property rights, losing their jobs as a result of Reggie? Do they now have an Article 1, Section 1 constitutional right to intervene because their interests are not adequately represented by opposition? That's all I'm asking you.
And the answer, Justice Dougherty, I think is potentially, and they would need to meet the rest of the court's requirements on standing and on intervention in order to do so. We're not suggesting that just because we are beneficiaries, we can roll into this litigation. We've met the rest of the other requirements for standing. We demonstrated legally enforceable interests by virtue of testimony.
Share with me. What is that legally enforceable interest?
So our members got up on the stand before the Commonwealth Court and demonstrated as to their particular interests, their particular concerns, their particular health impacts that they and their family members suffer as a result of the pollution that this regulation seeks to regulate. The Commonwealth Court evaluated that testimony, evaluated that live testimony before him, and determined that that nonprofits had legally enforceable interests by virtue of these injuries to their members.
Isn't that the foundation of DEP, to make sure that we Pennsylvanians breathe clean air?
That is absolutely an obligation of the department.
So why haven't you sued the DEP for breach of fiduciary duty when you put witnesses on who testify that DEP is failing its job because you have witnesses who are breathing dirty air? I'm really confused as to the logic of this argument.
Yes, Your Honor, and we certainly could do that, right? I'm not suggesting that.
But why would you not? If they're the government entity and you're telling us you put on legally enforceable evidence that people are breathing in dirty air when it's the sole duty and responsibility of the department to protect us.
Yes, Your Honor, and I think the Commonwealth Court addressed this very briefly when he noted that this regulation is the department's latest attempt to comply with those obligations. What we've attempted to do in this case is intervene on the same side of the V as the department in order to present those interests as part of the reason why the regulation should be upheld in this case, and specifically why the injunction enjoining the regulation from going into effect should have been denied.
And I understand completely. You're aligned with DEP on this. You're in favor of the regulations that are at issue.
Yes, Your Honor.
What you really want to be is a friend of the court on behalf of DEP. I'm concerned as to the bigger precedent that we set under Article 1, Section 27 for this type of intervention. All of the other cases that we've dealt with, the really dedicated nonprofits who have really played a huge role in the development of our case law on the Equal Rights Amendment, they were all direct actions by those nonprofits. To the best of my knowledge and recollection, this is the first time that we have an environmental nonprofit group appearing or attempting to appear as an intervener. You're not, it's not representing the class of all beneficiaries. It's, you're appearing on behalf of, nonprofits with defined membership and all of those kinds of things. And I understand your perspective on what the law of Pennsylvania is. My brief research in the area would seem to indicate that intervention by beneficiaries is allowed if you have a trustee who is unable or unwilling to act. And we don't have either one of those things here. And so understand my concerns are not directed toward your group, which all of which have done an exceptional job in advancing the Equal Rights Amendment. My concern is Environmental Rights Amendment. My concern is the larger precedent that we set by allowing this type of intervention.
And, Your Honor, I have three responses to that. The first is the raising of the Environmental Rights Amendment. As Your Honors just pointed out, my clients sought in part to intervene to raise the Environmental Rights Amendment's issues within the context of the regulation in this litigation because they had not been present before. The Department had not raised the ERA as a rationale for the regulation, for its positions in the litigation, and we sought to make sure that those issues were before the court. The second thing, the second response I have is to look at the evidence that nonprofits put on at the preliminary injunction hearing At the hearing, we sought to present evidence on those specific interests that we had, and specifically we put forth the expert testimony of two individuals, one, Dr. Raymond Najar, a climatologist out of Penn State and an expert in the impacts of carbon dioxide pollution, and the other, Dr. Deborah Gentile, a pediatrician and a public health expert, to talk about the impacts of particulate matter and the other co-pollutants that come from power plants and the harms that result as a result of those pollutants. And we put forward that evidence before the Commonwealth Court so that the Commonwealth Court could have, as it considered the injunction, the very real harms to beneficiaries and to our members that the rule is designed to prevent. And the third response I have to Your Honor is not directly about environmental groups, but it's to draw an analogy to some other cases that have come before the Commonwealth Court and before this Court. And specifically, I point the Court to the recent challenge to Pennsylvania's mail-in voting statute, Act 77. There was a challenge to that statute by individual lawmakers, and it comes before this Court in the McClinko case. Individual lawmakers bring a challenge. The state agency responsible for implementing that statute, the Department of State, defends the statute. Before the Commonwealth Court, various entities, including the Democratic Party, the Republican Party, various committees associated with those parties, seek intervention. The Commonwealth Court holds intervention hearing, and intervention is granted. Similarly, without the trust implications, but similarly, the case is similarly situated. The state, the Commonwealth, is defending its statute against a challenge, challenging the constitutionality of the statute, and other groups that have a particularized interest in making sure that that statute is upheld seek intervention, and it's granted. And I submit that this is a very similar situation here.
Except this is a trust.
Yes, Your Honor.
And you are beneficiaries. And I take a little bit of exception of your summary of the holding in McClinko on that issue, but that being said, this is a trust. Your clients are beneficiaries. There is a trustee that is pursuing the litigation. And so whatever analogy is there, it's really inapt. And honestly, counsel, I don't know the answer to this. I mean, case law is scant on this issue of the right to intervention by beneficiaries, but you and I seem to have a little bit of a difference of opinion on what it is. So
I think it is a difficult question. I find your analogy to be somewhat persuasive, although I agree that we're just not sure at this point.
Yes, Your Honor, and I agree that the case law is scant here, which is part of the reason that I am here before you, because the case law is scant. But I think in this situation where we have a trustee that is not putting forth those trustee-related justifications for its action.
They're not really in dispute, though. Yeah. Nobody's on the other side is disputing that the regulation doesn't further the interests of Article 1, Section 27. That's not even an issue in the case. The issue in the case is simply, is it a fee or a tax? That has nothing to do with Article 1, Section 27.
Well, I disagree, Justice Robson. I think that your questions a moment ago about wouldn't we consider these proceeds to be part of the trust corpus really do go to the question of how is Article 1, Section 27 being factored into this litigation. And in response to Justice Donohue's question on that issue, I do believe that these proceeds are income derived from the trust corpus and as a result need to be spent for trust purposes.
But there's again, I mean, I hate to interrupt you, but the Commonwealth takes the same position. They say these funds must be used to further the interests of the Clean Air Fund. There's what it seems to me that you want to do, and I think our association standing cases could use some clarification. You want to be a Me Too as a party, and your difference of opinion with the Commonwealth is not your ends and your goals and your beliefs with regard to the regulation, it's litigation strategy. It's what arguments to advance, what arguments not to advance. And I'm not sure that means that your interests are not adequately being represented. It means you differ in litigation strategy.
Well, I think, Justice Robson, to follow that to its end would seem to suggest that that there ought to be some presumption that if the Commonwealth is defending a rule or a statute, then that's it. Then it represents the interests of all the citizens. And we don't have that presumption under Pennsylvania law. And again, perhaps the specifics of the voting case are a little different, but there was not that presumption.
We actually do have that presumption in
Yeah,
Pennsylvania.
we do have that presumption. I mean, what are you saying? I mean, that's implicit in the trust doctrine. Of course they are. That's what they do. They act on behalf of the beneficiaries.
They do act on behalf of the beneficiaries, yes. Perhaps I spoke a little too narrowly. I'm saying when it's defending a statute or a regulation in litigation before this court, again, there's not a presumption that there's no role, that there's no, that groups such as ours are foreclosed as a matter of law from attempting to intervene.
Okay, I think we understand, we understand your position. Is there anything you'd like to say to wrap up?
Your Honor, again, I would urge the court to grant our intervention, and also for the reasons expressed by Mr. White, and also based on the legal argument that these proceeds cannot be considered a tax because they are subject to the strictures of the Environmental Rights Amendment, that the Commonwealth Court erred in granting the injunction.
Very well, thank you.
Thank you.
Ms. Curry?
May it please the court, Bridget Landy Corey of McNeese, Wallace, and Norrick. I'm here this morning. It is still morning. I had to check, along with my colleague Candace Hull, on behalf of the Senate interveners in this matter. Also sitting at council's chairs here is Jim Kutz, who is here on behalf of members of the House of Representatives. Mr. Kutz is not planning to make a presentation to the court today, but he is available for questions if there are any specific to his client. Also from McNeese, we have Drew Crompton and Austin Huey, as well as Erin Kawa from Post and Shell. She's here with Jim Kutz. So I think that covers everyone. So before I get to responding to Mr. White, and again, I'm covering the 79 matter, and Ms. Hull will be covering a response to Ms. O'Neill and the 85-87 dockets. So I'll be responding primarily to Mr. White's presentation. And as Justice Brobson touched on, the instant matter and before the Commonwealth Court here is whether, before the Supreme Court, is whether the Commonwealth Court properly granted the injunction. The burden here is on DEP to demonstrate that the Commonwealth Court's decision was manifestly unreasonable, arbitrary, or capricious, or that the law that Judge Wojcik applied was palpably erroneous or misplaced. And in that regard, appellants have unequivocally failed, and we ask this court to affirm the injunction. I was going to respond to Justice Donahue's questions about what if you rule at this point, could you rule on the merits? And I would just submit that what you're looking at is Judge Wojcik's actions below, and what he was looking at below was the presentation of the case at that stage. We had presented a 2J hearing on the injunction, and the briefing was on obtaining an injunction. And of course, before the court here is whether he properly ruled on the injunction. We have not been focused solely on the merits, and I think it would be premature for the court to rule on those merits in a complete way for those reasons. Sure.
Justice Donahue just missed that point.
Sure.
Could you repeat it? No.
I'm sorry.
It's in response to a question by Justice Donahue, so would you mind repeating that?
Sure. I was just noting that, you had mentioned earlier whether this court could rule on the merits of whether it was a tax and a fee and what effect that would have. Of course, that's baked into the standard for the injunction, and we're here today to talk about whether the Commonwealth Court properly granted that injunction. And in reviewing Judge Wojcik's decision, we're looking at what did he know at the time, and what was and he was looking at a 2-day hearing, he was looking at briefing from the parties on requesting the injunction, as opposed to full focus on the merits. So, of course, the court has broad authority, but I think it would be inappropriate to rule absolutely on the merits when that really hasn't been the focus of the briefing and of counsel on either side at this point.
Okay, so what do you suggest we do with Judge Wojcik's ruling on the tax versus license issue?
Sure. So I'll just Yeah, so of course.
Could we decide it?
I'm sorry?
You're saying we don't decide it, we just say,
Well,
what, could be right?
I think that you affirm the Commonwealth Court's decision that it was likely a tax and not a fee. And there was discussion earlier about what is a substantial legal question. I think that's an interesting academic discussion, and certainly the cases have discussed it in different ways and weighing the different 6 factors of the SEIU case because facts are different in different cases. But I think in this case, Judge Wojcik did clearly weigh the merits of the different counterclaims.
Well, it's not just academic. That seems to me a very important question in this case as a matter of law that we need to decide whether the existence of a substantial constitutional question constitutes irreparable harm per se. I'm taking it that that's your position, and is it?
No, Your Honor. It's not our position.
It's not?
Well,
and what about what the Commonwealth Court did here with respect to that legal question?
Sure, and I didn't mean to minimize the importance of the question because it's certainly an important consideration. It's a very important factor of the test. My point is that Judge Wojcik did analyze the likelihood of success. He did not just, as DEP suggests, identify, oh, this is a big question, it's an open question, it's an important question, and then go no further. He actually analyzed each counterclaim under a likelihood of success question. And of course, we only were successful on one of them.
Would you agree, counsel, just briefly following up on that, would you agree that as a legal matter, if this court says that a petitioner bringing to us or to a lower court a substantial constitutional question establishes irreparable harm per se, then we're going to have a whole lot of preliminary injunctions entered in the Commonwealth?
Well, just to be clear, it's not our position that substantial legal question is sufficient to establish irreparable harm. That's not our position. That's how DEP would like the court to view our position. Our position is that we establish this is very likely a tax and not a fee, and that means very likely it's harmful to the legislative branch because you have one entity that doesn't have that constitutional authority exercising the authority specifically reserved to the General Assembly. I spent a lot of time looking at this substantial legal question analysis. I read a lot of cases looking back, and every court seems to sort of phrase it a little differently. I think something that was helpful that I found was the process gas case, which is, I think, a case a lot of folks are familiar with, and this court incorporated a reference to that in a note to a related rule when you're seeking a stay. And in that case, they specifically say that in order to establish a clear right to relief, you have to show a substantial case on the merits. So I think what has happened potentially is that the discussion over time has evolved, and we've confused this substantial to mean something separate from a likelihood of success.
Maybe we need to fix that.
Absolutely.
Well,
I think you're right.
Substantial
She's
question.
right.
Yeah,
It's a big issue, a big question. It's the
Right.
substantial likelihood of success.
and my point in saying that it's an academic for purposes of us here is that Judge Wojcik did not treat it that way. He looked at whether we were likely to succeed on the merits.
That's my point, and I asked counsel for DEP the same question. What if we disagree with him? Then what?
On whether it's a substantial.
He decided the question. Your point is well taken. I don't think they suggest otherwise. He said it's a substantial question, and I say it's a tax.
I'm not sure that. Are you saying?
What do we do with that?
If you disagree with the finding on that prong of whether we establish that we're likely to succeed on the merits?
Yeah.
Well, he leapt over that, apparently.
Well, he decided it.
And decided.
He decided it. He said, boy, this is a substantial legal question. I say it's a tax.
Well, I think he had to analyze our arguments of whether or not it was likely that we would succeed on the merits, and so he had to examine the merits to that extent because that's what informs whether you're likely to succeed. I think the point is, and it kind of comes back to a little bit of a common sense question. If you're bringing litigation and you want to stop something from happening, or even mandate it in a mandamus action, you have to make a prima facie case that you're kind of right.
I agree entirely. I agree entirely. We're saying exactly the same thing. Okay. My question to you is, the case is now before us.
Sure.
Judge Wojcik did a wonderful job, as he always does. He analyzed, he thought, he wrote.
And he concluded.
And he concluded that this is a tax. So what if we say it's not a tax?
Well, if you would have to find that he was palpably erroneous in applying the law and that he had no reason to find what he found.
See, that doesn't apply to legal questions. It's either right or wrong. I mean, this isn't could be a tax. I don't know, maybe it could be in some circumstances. That's not how this works. And this turns into a pure question of law. I mean, is this a tax? The record is developed. We have everything before us that Judge Wojcik had before him. The case is now before us. In your view, as we review the entry of the preliminary injunction by Judge Wojcik, what do we do with that finding? Do we say we aren't going to look at it now?
Well, I think you have to look at what he did to review the test for the injunction. Right. And if you find that he was manifestly unreasonable and was palpably applying the wrong legal concepts to the facts, and he was the finder of fact here, right? He sat through 2 days of a hearing. So you would have to overturn his judgment on his view of the case up close.
But this is not certainly that's available, but what comes before us today in this particular case, it seems to me, and tell me if I'm wrong, is not the question of whether this judge made a wrong credibility finding on a witness or weighed the facts arbitrarily, or that he was unreasonable. It's a question of law, questions of law. We have this question about our preliminary injunction standard, the legal standard, along the lines I asked you about whether this substantial constitutional question verbiage is now going awry or not. And then we have the question tax fee, and then there's the intervention issue. So these are legal issues that we're concerned with. It's not a question of whether this judge was weighing credibility in X manner or Y manner, or whether he was somehow arbitrary, right? I mean, we have legal issues here, don't we?
Absolutely. I think there are legal issues baked into each element of the SEIU 6-factor test. I think that the reason that the standard is so deferential on an injunction is because the trial court, in this case the Commonwealth Court, has to weigh all of those factors. And this gets to a little bit about the percentage discussion. Is it 50%? Is it 100%? We know it's something more than 50. I think if you have really strong evidence of harm, then perhaps maybe an irreparable harm, then maybe the requirement, and this is a hypothetical, I'm not saying the situation here, but the legal substantial legal question standard might be a little bit closer to, 55%. It's a balancing, and I think that balancing is done by the trial court, and that's why we, as through the courts, have given deference to the Commonwealth Court.
Let me just point out a distinction that I see in the very early cases that deal with these substantial constitutional questions. They didn't answer the question. They didn't answer the question. They said all of the other factors are met. Irreparable harm, preservation of the status quo, et cetera. All of these are met. And now we're faced with the issue, do they have a likelihood of success on the merit? Courts in those situations, after all of the other factors have been met, have said, you know what, this is a substantial constitutional question that we have yet to address under these circumstances, given the clarity of meeting all of the other factors, we're going to grant a preliminary injunction because there is a substantial question. Take the Fisher Court. They didn't decide the issue before it under the Abortion Control Act, they said, wow, this is a big issue that we have never touched. Every other prong is met. Since there is a substantial question, we're going to enter a preliminary injunction. Judge Wojcik didn't do that. He didn't say there's a substantial question and I'm not going to answer it. He said there's a substantial question and you know what? It's a tax. So now that's what we have before us. We have a proposition of law that he then relied on to establish a per se constitutional violation to show irreparable harm. So we have a conglomeration of things that flow from his decision to decide the substantial legal question.
Well, I think perhaps one way to characterize what he did was a belt and suspenders approach. I mean, if he identified an important question and then identified why he thought that we were probably right on it, I don't think that makes him wrong on the law. And we can go through each prong of this test, but you mentioned irreparable harm. He did not rely exclusively on irreparable harm per se. He recognized that, as this court has recognized, when one branch of the government exercises an authority that is exclusively reserved to another branch, that is harmful to the branch that has the authority.
Counsel, can I ask you a more pointed question? Do you agree with the premise that Judge Wojcik finally and fully decided the question of whether this is a tax or a fee?
I do not agree with that premise.
Because there was Commonwealth Court, was it en banc argument in November?
Yes.
I would assume that the Commonwealth Court wouldn't have had en banc argument if Judge Wojcik decided the case fully and finally whether it was a fee or a tax.
Correct.
Okay. So and I'm looking at the opinion, and I thought I saw a segment where he said that the court cannot agree at this time with the department's position that it's a fee and not a tax.
Correct. Yes.
Okay.
Yes, the Commonwealth Court has before it right now the issue, the case on the merits. And we had argument in November, and they have not fully decided the case. And that brings us to what is this issue of tax versus fee? And here, DEP would have us believe that it's a fee, and they say it's a fee because they have to. They don't have the authority to tax. And as Judge Wojcik properly recognized, the power to tax is vested exclusively in the General Assembly. And even if they wanted to delegate it to the department, they could not do so because we do not allow unelected officials in an administrative agency to impose taxes. So there's no amount of interpretation of the Air Pollution Control Act that could authorize them to enact the tax.
So, counsel, you're arguing the merits of the way in which Judge Wojcik decided the tax versus license. You want us to decide that?
I would like you to affirm Judge Wojcik's decision that found that we were likely to succeed on the merits, which justified his injunction.
See, I said this earlier. I don't even know how we would make that holding. I mean, without tipping our hand as to whether or not it's a tax or a fee, and we just don't play, hide the coin that way. I mean, I just don't know. I don't know how we would rule on that. I mean, your better argument is just say we agree that it's a substantial constitutional question and go no further.
Okay.
I don't know how else.
I understand. I think perhaps why we're in this situation is often I don't know how often the injunction gets here before the lower court gets to decide on the merits. I don't know if that's an unusual situation, but I can't imagine it's never happened before. And certainly if all he needs to do is note that it's a substantial legal question, he certainly did that. I'm saying he went further than that, and I want to explain to the court, why the department did not have the authority to do what it's doing.
So from your perspective, we can take Judge Wojcik's opinion up to a point and view this as we would any injunction ruling?
Yes.
Counsel, what makes this a substantial legal question, precisely? Since there's lots of law on how you decide this, what makes this a substantial legal question?
Are you asking what makes it important? I'm sorry.
It's important.
Are you asking what makes it important?
What makes it a substantial legal question that then triggers the deviation from likelihood of success on the merits?
Well, again, that's not our position that all that Judge Wojcik did was recognize a substantial legal question. We're saying that he found there was a likelihood of success. We're saying he did not deviate from any standard.
So you're saying he didn't say this is a substantial question. You're saying he said you're likely to succeed on the merits because this is a tax.
I think he did both.
But you would agree, wouldn't you, that if what he did in fact was allowed his conclusion that it is a substantial legal question to constitute irreparable harm per se, that would be legal error?
I'm not saying that would be legal error, because you can have a situation where, I mean, I think this is playing into the department's narrative, and I'd like to, pick apart that a bit, because there's several legal concepts that are getting woven together.
Well, I just want to know the simple proposition as a matter of law. It's a legal question. If that was the trump card, is that legal error?
If substantial legal question could constitute irreparable harm, is that the question?
Yes. No, if it is, if the existence, this goes to our legal standard, so it's important.
Sure.
Does the existence, if the judge concluded that the presence of a substantial constitutional question constitutes irreparable harm per se, is that error as a matter of law?
I would say it's not. It's not what happened here, but I would say it's not a matter of law, or an error as a matter of law, and this is why. If you have, assuming that a substantial legal question is sufficient for the injunction, a substantial legal question is raised because you have one branch of the government exercising the authority vested in another, and that is incredibly important, fundamental core principles of our Constitution, right? And of course, this court has the lovely responsibility of keeping the parties, in check. And irreparable harm to the party has been recognized in cases that have to do with standing. We recognize that exercising authority of one branch by another is harm to that branch. So if you have a substantial legal question that invokes constitutional principles, then you're going to have irreparable harm per se. Again, that's not what Judge Wojcik did here, but I don't believe that would be legal error.
Counsel, can I just flip that a little bit? Let's say you're right on the constitutional issue, and but we reverse the injunction. They move forward with the RGGI regulation, it's implemented, the money goes into the Clean Air Fund, but at some point in time, the Commonwealth Court or this court says it was an unconstitutional tax. It usurped the authority of the General Assembly. At that point, what relief is available to the legislature to remedy the harm, the constitutional harm that occurred, that being the usurpation of their authority?
There is none. There would be no remedy to fix the harm in that regard. Yeah. So I certainly want to direct my presentation to the things of most interest to the court, but I do think it's important to understand why the department is wrong in calling this a fee. And as Mr. White referenced, and we agree that the controlling case is the National Biscuit versus City of Philadelphia case, which established a four-part test. And as Judge Wojcik noted, a fee is imposed pursuant to the sovereign's police power, and it is intended to defray the expense of the regulation, which is distinguishable from a tax. And Justice Brobson touched on this a bit. Typically, you have an exercise of the police power is a restriction on activity, right? It's a restriction on something that has to be within the jurisdiction of the agency that is implementing it. And you determine what that reasonable restriction is, and then you implement a fee to cover the costs of that restriction. What the department did here is they established the fee and then they're going to decide how to spend it later. And they're asking 66 facilities in Pennsylvania to fund an entire carbon mitigation strategy for the entire state. And that's simply, way off of what the legislature could have intended through the APCA, and it's certainly closer to a tax. It is a tax, and it's not.
Do we base that just on, go ahead, Justice.
Go ahead.
Well, do we base that just on the amount of money or the scope of the fund? Or, in other words, if the Act gives them the authority to undertake these control programs, do we base our weighing of this tax fee issue on, whether it generates $5 or $5 billion? I mean, is it? Do we look at it and say it's so grossly disproportionate that it has to be a tax? What's the litmus test we can employ here to make that determination?
So I think while the volume is significant, we're talking about $5.8 billion by 2030, which is larger than most of the taxes that are out there now. And the department has acknowledged that only 6% is actually going to administer the program. While that's very important, and it is one of the prongs of the National Biscuit Test, the other three all get to this jurisdictional question. Are the entities that are paying the fee under DEP's jurisdiction? And in this case, it's absolutely not. And this is not a hypothetical to make a point. This language directly from the RGGI rulemaking itself dictates who can participate in the auctions. And then we also know that there's a secondary market that anyone can, if you set up an account, you can trade these allowances. But this is the list of entities that can participate. An owner or operator of a CO2 budget unit, that's the power plant, located in the Commonwealth. An owner or operator of a CO2 budget unit located in a participating state, that's another neighboring RGGI state. A broker, an environmental organization, a financial or investment institution, or any other market participant as may be specified in the notice of the auction. This is not applicable only to an entity subject to DEP's jurisdiction. And all three of the other prongs from Nabisco deal with this jurisdiction. It requires that the supervision and regulation actually be conducted by the licensing authority, right? So we don't want agencies collecting fees for something they don't need to do or that they're not actually doing. The third prong is that the fee is a condition upon which the licensee is permitted to transact his business. That might be true of the 66 facilities in Pennsylvania, but it's not true of all of those other categories that I mentioned who are paying this fee. I'd call it a tax.
They may pay the fee, but they don't have to. The only people who have to do it are those entities that are regulated by DEP.
And the other RGGI states. They have to pay it. And I think an important factor here is that when we're talking about the jurisdiction of Pennsylvania and what DEP can do under the Air Pollution Control Act, they can regulate sources in Pennsylvania, but they have to regulate them. The RGGI rulemaking does not set a cap for Pennsylvania allowances. The only time the cap comes into play is when you're talking about the regional footprint of RGGI. And again, this is in DEP's own words from the rulemaking. CO2 emissions from this Commonwealth's power sector are not capped by the CO2 emissions budget, meaning they are not limited to strictly the amount of this Commonwealth's CO2 allowances. They also say, and we talked about this a bit earlier, RGGI CO2 allowances are fungible across the participating states, meaning that though this Commonwealth would have an established allowance budget for each year, this Commonwealth's allowances are available to meet the compliance obligations in any other RGGI state and vice versa at the option of the regulated sources. Therefore, CO2 emissions from this Commonwealth's power sector are not limited to strictly the amount of this Commonwealth's CO2 allowances, meaning they can emit more than what the Pennsylvania share as long as they buy them somewhere on the market. This cooperation allows more flexibility in terms of compliance and allows the market to continue to signal entrance and exit of generation. And though each state has its own annual allocation, and this is the key, compliance occurs at the regional level rather than on a state-by-state basis.
Isn't that just a recognition of the fact that there isn't a wall that goes around Pennsylvania and up 3 million miles into the air so that you can actually segregate the air quality of Pennsylvania from what's going on regionally?
And that may be a rational thought, but that's something that is a policy that has to come from the General Assembly through the statutory authority, and this is outside of that. And this is a tax, not a fee.
Well, you're telling me that that's true because it's a tax, not a fee.
I'm telling you it's true. Well, I'll back up. So you're talking about a recognition of a regional cooperation among states. My point with regard to the police power and whether it's a proper fee is that they're not actually regulating entities within the Commonwealth. They're doing it via an agreement with these other states. So that's not envisioned by what we typically think about as a fee, because the fee has to come from the entity that's being regulated and is subject to DEP's jurisdiction. And I'll also note that, and you touch on a really important point, that RGGI is not in Ohio. It's not in Kentucky. Okay? It's not in West Virginia. But what also flows across borders is electricity. And so, and the modeling from DEP shows that as the RGGI comes into effect in Pennsylvania, the electricity from those states is going to be cheaper, and they're going to generate more. And those power plants are dirtier than in Pennsylvania because we have more natural gas powered plants and newer plants here in Pennsylvania.
So because it doesn't address everything, it shouldn't address anything in terms of regional impact.
Well, I think if we're talking about the exercise of the state's police power and extracting $5.8 billion out of the economy, in order to be a reasonable exercise of the police power, it actually does have to have an impact, a positive impact on the environment.
Well, $5.8 million billion dollars will go into the Clean Air Fund. Is that not a positive impact on Pennsylvania? The money to be used to ensure clean air for Pennsylvania citizens and generations yet to come?
The justification of the government taking money from an entity has to be sufficiently related to cleaning the environment and directly related to the costs associated with that, regulating that entity. And so to make them pay for this, again, this entire carbon mitigation strategy for the state, which really reflects carbon emissions from years and years and years from many, many industries, from you and I, and our carbon footprint every day, is not sufficiently related to what they're actually being required to pay here.
All right, thank you very much, Ms. Curry. We're going to figure this out.
Okay, good luck.
Good argument, thank you.
Thank you very much.
All right, Ms. Hull.
Good afternoon, may it please the court. I'm Candace Hull on behalf of the Senate interveners, and my argument will respond to the issues raised by the proposed nonprofit interveners at docket numbers 85 and 87. I will endeavor not to repeat a discussion of the issues that have already been addressed by Ms. Curry. Initially, in the docket related to the denial of intervention, this court must determine whether the nonprofits should have been permitted to intervene in this case. We submit that the Commonwealth Court correctly determined that they should not. Whether to allow intervention is a matter vested in the discretion of the trial court, and the court's decision should not be disturbed on appeal absent a manifest abuse of that discretion. Judge Wojcik did not abuse his discretion because the nonprofits cannot satisfy any of the criteria for intervention under Rule of Civil Procedure 2374. Of the 4 criteria in Rule 2374, only the final one is even arguably applicable to the nonprofits. To intervene under this subsection of the rule, the nonprofits have to show that they have a legally enforceable interest in this proceeding. They can't do so. To demonstrate the existence of a legally enforceable interest, a person must own an interest in or a lien upon property in question, or must own a cause of action which will be affected by the proceeding. He must have some right, whether legal or equitable, which will be affected. There's no property of the nonprofits. There's no contract of the nonprofits. There's no cause of action of the nonprofits that will be affected by the decision in this case.
Counsel, they're beneficiaries of the trust.
They are beneficiaries of the trust.
Right. So your discussion of property interests and things like that, it's sort of out of sync with what we're dealing with here. Why, as beneficiaries of the trust, don't they have the ability, standing to intervene in this case?
The claims raised by the Senate in this case are not about whether the RGGI rulemaking is a good policy choice for Pennsylvania. And correspondingly, as you heard Mr. White say, the defense is not about the Environmental Rights Amendment. The issues here are about who gets to decide the policy under Pennsylvania's Constitution. The claims are fundamentally about separation of powers and whether or not this action taken by the department was constitutional, and not about the policy of RGGI itself.
Counsel, Justice Bobson, and I agreed with his statement when he said it, indicated that everybody in this litigation agrees that the Equal Rights Amendment is implicated in this case. Do you not agree with that?
We agree that the Environmental Rights Amendment is a part of the Constitution, and just as every other section of the Constitution cannot be violated, neither can the Environmental Rights Amendment. But no one here is alleging that it has been, right? The department has promulgated a regulation that it believes is in compliance with the Environmental Rights Amendment. The nonprofits agree that it's in compliance with the Environmental Rights Amendment. We're not saying it isn't in compliance with the Environmental Rights Amendment. We're challenging this regulation on an entirely separate basis, right? That there are other provisions of the Constitution that make this rulemaking unconstitutional. And the Environmental Rights Amendment does not trump those other provisions. You cannot enact a regulation in furtherance of that amendment if it violates the right of the General Assembly exclusively to impose a tax. Or if you picked another provision, if the provision that says bills must contain a single subject, you could not violate that provision of the Constitution in furtherance of the Environmental Rights Amendment.
That sort of begs the point here. The potential interveners are claiming standing to intervene because as beneficiaries of the trust, they have an interest in supporting the regulation that's at issue because it advances their interest as beneficiaries of the trust. It doesn't have anything to do with the other constitutional issue. They want to be in this case to support the regulation.
That interest in making sure that the Environmental Rights Amendment is complied with, or frankly any other provision of the Constitution is complied with, is a generalized interest shared by all Pennsylvanians and not specific enough to grant them the right to intervene under the intervention rules or the jurisprudence on standing that accompanies it. If they are allowed to intervene to support the department as trustee of the environment, then they could essentially do so in every case involving the DEP or an environmental issue, whether any other party has raised that ERA concern or not. And they're not identifying a specific cause of action, property interest, beyond a general interest in the enforcement of Pennsylvania's Constitution. The ERA says specifically that Pennsylvania's public national resources are the common property of all the people, including generations yet to come. that would, the proposed interveners are no different than any other citizen of the Commonwealth in that regard. And if they are allowed to intervene, then anyone here could intervene.
Do you think they would be more properly amicus?
Absolutely. No one is disputing that they feel passionately about these issues and that they are important issues to their members and to others in the Commonwealth, and they have been leading advocates for their positions, but they can do so by participating as friends of the court, and they can convey those policy concerns, which is really what they are, rather than particular causes of action or property interests that are at issue in the case. And I think the court mentioned it earlier, but simply because they might have a different legal strategy that they want to put forward here also does not give them standing to intervene, because again, that would open the floodgates to all types of participants in litigation if you simply felt that someone was not putting forth the correct legal strategy in a particular case. In addition to not having a cause of action or a legal interest in the case, the Commonwealth Court, Judge Wojcik, found that any interest they do have is adequately represented by the department, and we agree with that. They have admitted here that they are for upholding the RGGI regulation. They have not been able to identify anything in particular that they disagree with regarding how the department has defended that regulation. They might want the court to also note the existence of the Environmental Rights Amendment, but Mr. White here is capably representing the department's position on why this regulation should be upheld, and there is no distinction in that regard between the nonprofit interveners' position and the department. The trustee analysis, I think, is important, and again, some of the court's comments got to the heart of that. There's no divergence between the trustee and the beneficiary here. In the other Environmental Rights Amendment cases, there was a concern that some entity within the Commonwealth was not properly fulfilling its duties as trustees. Here, the position of the nonprofit interveners is that the Commonwealth is doing what it's supposed to do, and we just want to intervene to keep an eye on them to make sure they keep doing what they're supposed to be doing. To raise this additional, I would characterize it as a policy concern rather than an additional legal position actually at issue in the case.
Would it be enough if it were the latter? If you were wrong about that and if they were raising that legal position, would that be enough for intervention?
They have to have a claim that is specific to them, that is going to be affected by the outcome of this. If they could show that, then they would establish that first prong of the test for intervention, and then they would have to show that whatever that interest is, it's not being protected by the department. We do not think they can meet either one of those parts of the test.
Okay, can you reach a conclusion for us here, and we'll see if any of the justices have any final questions for you.
Certainly.
This is where you say, no, Madam Chief Justice, I'm only getting started.
I'm glad you're not arguing.
I would just note that I believe the department, the Senate and the Senate interveners also agree that the funds go into the Clean Air Fund and, as described, must be spent on something related to air pollution. That's a very broad category, but contrary to the nonprofits interveners assertions, we're not saying that they go into the general fund and could be used for any purpose at all. And in conclusion, I would say Judge Wojcik properly concluded that the RGGI regulation results in an unconstitutional tax, that violation of the Pennsylvania Constitution is irreparable harm per se, and that a violation of the law cannot be in the public interest, and that the regulation must be enjoined. So for those reasons, we ask that the court affirm the denial of intervention and uphold the injunction. Thank you.
Thank you. Ms. Hull, Ms. Curie, Ms. O'Neill, Mr. White, y'all did a tremendous job today, and your clients were well represented. So thank you. Mr. Minner, we're going to take our recess now, and we'll resume at 1 o'clock.
We're going to recess until 1 o'clock.
afternoon. In this appeal, Goli Technologies entered into a consulting agreement with Vinculum. The agreement contained a restrictive covenant which precluded Goli from competing with Vinculum for 1 year following termination of the agreement, and provided for attorney's fees in the event of a breach. After Goli breached the agreement, Vinculum filed suit and sought damages for lost profits beyond the 1 year period after the breach and counsel fees. We must determine whether damages flowing from the breach of a restrictive covenant are limited to the period of the restrictive covenant, and whether an award of counsel fees is appropriate under these circumstances. Please proceed.
It may please the court. First, let me say it's an honor to be here before you all. It's a privilege to represent my client, a minority-owned, female-owned Pennsylvania small business. And it's a privilege to have been on this case with Travis Gold, who's a sensational advocate. So the first thing I would like to mention here is that this is not necessarily a non-compete case. The restriction involved in this case is very different from a non-compete provision, which a lot of the case law, almost all the case law cited by the appellee involves. This is a very narrowly tailored restriction that applied to one client where the defendant, the principal of the defendant, Mr. Goli, was placed by my client, and that would be PennDOT, to work on mobile applications. He's a software engineer. I understand that sort of the zeitgeist these days is very anti-non-competes, but I just wanted to make it clear that this is not a non-compete case. It sort of reminds me of when people think of ancient Egypt and they think Cleopatra and the construction of the Great Pyramids, they lump them together. Well, Cleopatra actually lived closer in time to us than she did to when the pyramids were built. So it's very confusing to lump non-compete with what we're dealing with here, which is really a non-solicitation for one client.
Which is still a restrictive covenant.
Which is a restrictive covenant, correct.
Very restricted.
Yes, it's a very, I say narrowly tailored, as narrowly tailored as it can be, one client. And this is also not an employee case, which most of the case law cited by the appellee involves. This is another company, another vendor who places IT consultants in very highly skilled niche positions, usually with government agencies. And Goli Technologies, the appellee, is a business. It has multiple consultants at PennDOT. Goli Technologies started violating the restrictive covenant, the non-solicitation, almost immediately after signing the consulting agreement with Vinculum.
Counsel, can I just interrupt you for
Yes.
a minute? Because I think we're really familiar with the facts here, and we sort of have two issues in front of us. One is whether your restrictive covenant, which also includes an attorney's fees provision, required you to be the prevailing party on everything, and whether there is a prevailing party component. And the second issue is simply, as a matter of law in Pennsylvania, is there a per se bar for someone who is seeking enforcement of a restrictive covenant from receiving damages beyond the period of the non-compete or restrictive covenant? Those are two legal questions.
Yes, those are exactly the issues that you've articulated involved on this appeal. And the first issue that Your Honors mentioned would be the attorney's fees issue. This is not a statutory fee-shifting case. This is a case where a consulting agreement between two businesses had a fee-shifting clause, and it didn't have prevailing party language. It was one-sided. It was if there's a breach of the agreement, including the restrictive covenant, which the trial court found that there was, that Vinculum, the non-breaching party, could recover its reasonable counsel fees incurred with, quote, enforcing the agreement. That's what the language in the contract says. In this case, there was a counterclaim filed because of payments from Vinculum to Goli Technologies were withheld after the breach, after the series of breaches, because the contract actually allowed Vinculum to withhold payment in the event of a breach. The trial court found in favor of Goli Technologies on the counterclaim, and found in favor of Vinculum on its claim to enforce the restrictive covenant, but then netted out the amounts, and it actually wound up yielding roughly a $10,000 judgment in favor of Goli Technologies. And for that reason, the court found that Vinculum was not a prevailing party. So our position here is that the prevailing party analysis is inapplicable because the contract did not have a prevailing party clause. It simply said that if a breach is found that Vinculum is entitled to recover its reasonable counsel fees incurred in connection with enforcing the agreement, which is exactly what happened.
That's regardless of how damages were ultimately awarded and determined on the claim and the counterclaim.
Correct. Our position is simply based on the finding of liability for the breach of the restrictive covenant. That triggered the application of the attorney's fees provision.
You keep saying breach. That's not what the contract says. It says for each violation. Correct?
Correct, Your Honor. Yes, I'm using breach as sort of the legal term of art, but yes.
No, well, but we're enforcing the language of a contract. And your argument is it doesn't say prevailing party, but it doesn't say breach either. I don't know if it makes a difference, but it does say for a violation.
Yes.
Did you just say that both parties violated the non-compete, one by withholding wages, the other by breaching the restrictive covenant?
No, Your Honor. Well, first, there weren't wages because these were two businesses that had contracted with each other.
Withholding payment.
Yes, withholding payment. The court found that that was it was a breach of contract counterclaim, and the court found that Vinculum owed money for money that it had withheld, even though the agreement allowed it to do that. But there was no provision in the contract that provided for Goli Technologies to obtain counsel fees. Again, it was simply based on the finding that there was a breach of the restrictive covenant by Goli Technologies, that was a violation of the agreement. There were multiple violations of the agreement. And the trial court wouldn't even entertain an analysis of the reasonableness of the fees. It just said no fees can be awarded because when they netted out the counterclaim judgment and the principal claim judgment, that there was a $10,000 net amount in favor of Goli Technologies. So, we've surveyed Pennsylvania law. I've looked elsewhere. It's all in the brief. Our position is it's really just a matter of contract language interpretation, and there's really no authority for the trial court to view this as discretionary. The trial court certainly was entitled to analyze the reasonableness of fees, but it never reached that. It just said no fees could be awarded, period. So, again, our position is that was error by the trial court, error by the Superior Court in affirming the denial of any counsel fees in favor of Vinculum. On the second issue, that relates to damages. Damages on account of the breach of this non-solicitation clause. There was a one-year period after the termination of the consulting agreement between these two businesses whereby Goli Technologies was prohibited from either placing the principal of Goli Technologies at PennDOT or placing any other consultants at PennDOT. Goli Technologies was free to do business anywhere else on the planet, anywhere else in the Commonwealth, even another Commonwealth agency, just not PennDOT. Goli Technologies admittedly breached it. The trial court found that during that one-year period after the separation of the parties, that two consultants were placed at PennDOT, and those consultants are still there as far as we know to this day. They were certainly still there as of the date of the trial, but the court arbitrarily cut off the damages at 1 year. We view that as arbitrary. We view that just because the provision said that he couldn't compete or he couldn't solicit at PennDOT for a year, that doesn't mean the damages flowing from his breach had to be cut off at 1 year.
Counsel, let's explore that. You just asked us to follow the plain, unambiguous language of the contract, and that you believe your client wins. But now you're asking us to look at the one-year language that's specific and plain and expand on that. How does that mesh with your argument?
Sure. So the one-year provision in the contract applied to a period of time where Goli Technologies was not allowed to make any placements at PennDOT.
Correct, but I apologize. So had he breached on the 400th day,
yes,
there would be no cause of action.
If Goli Technologies had essentially sat on the sidelines for a year with PennDOT and placed consultants elsewhere and waited until 1 year elapsed, absolutely. There would be no breach, there would be no liability, let alone damages.
But your position is that your clients they're entitled to additional monies despite the time restriction?
They're entitled to all damages that proximately flow from the breach. Pennsylvania law is clear that damages can be awarded that are the proximate cause of a breach. But for the admitted breaches that it did occur during the restrictive period, there wouldn't be these consultants placed there. There wouldn't be ongoing damages. So our position is that the 1 year restriction applied to the period of time when a breach could occur, but it doesn't limit damages resulting from that breach.
So I think, so the trial court, I think, and the Superior Court seem to believe that Pennsylvania law imposes a per se bar of the calculation of damages in a restrictive covenant case to the period of the restrictive covenant.
Right.
I'm not sure that is the law, and if it is, I think that's why we took the case, to look at that. Right. But I have a factual question for you. What evidence did you put in the record at trial to show that in year 2, Goli Technologies was in a better competitive position because it competed in violation of the covenant in the first year than it would have been if it had honored it?
Right. Your Honor, no evidence was presented because when we attempted to do so, we were met with an objection which was sustained. So we were not allowed to put on any evidence of any competitive activity by Goli Technologies after the end of that 1 year restriction.
Can offer a proof as to what that evidence would have been?
We did. I mean, we had Mr. Goli on the stand, and we're prepared to ask him all about his competitive activities after the end of that first year, and ask him about the consultants that were placed after the end of that first year.
That's different from the question I asked you. I asked you about, because there's no question that in year 2, Goli could place business with PennDOT, right? The question really is, what evidence is there that Goli's position in placing business in year 2 was enhanced by its breach in year 1 versus if it would have just sat out the first year? Because that seems to me to be a possible area of damages for anybody to explore if there's no per se bar.
Right.
But I'm wondering whether there's evidence here that suggests that you tried to do that. The record is not great in terms of pretrial disclosures and things like that. So I'm just wondering, right, did you intend to present that type of case, that in year 2, had they sat out, their revenue would have been X, but because they didn't sit out in year 1, their revenue was Y?
Right. I mean, that sort of evidence really comes down to sort of expert testimony, but we were prohibited from the get-go from putting on really any evidence of any damage after year 1. So, I mean, I think to answer your question is the record does not include evidence of any damage of any kind after.
You would have been in your pretrial disclosures, you would have disclosed any expert testimony that you want to present on that subject.
Correct. There was no expert testimony. The only testimony was on behalf of my client, who explained that, you know, the competitive advantage that Mr. Goli has was he's every day physically at PennDOT. He's on site, so he has relationships there. He was able to get people in there essentially with no bids because of his relationships at PennDOT, and he was only there because Vinculum placed him there. But to answer Your Honor's question in terms of was there evidence of anything beyond year 1? I mean, the answer is no, because the trial court was the trial court, in fact, denied a discovery motion when we were trying to get information about what happened after the end of year 1. So we really had nothing even to go on coming into trial. Of course, at trial, we attempted to ask Mr. Goli questions about it, but objections were made and they were sustained. So we were precluded from doing it.
The problem when evidence is not permitted to be entered is the only way we can review it is if you've made an offer of proof to the court below as to what you would have offered and would have shown had you been permitted, and there's nothing like that in this record, correct?
I mean, there's nothing in the record other than our attempts to ask Mr. Goli at trial questions that we were hoping to get answered in discovery, and the court said no.
Okay, and you're relying, in essence, on a common sense analysis that since he was there, he had the opportunity to develop contacts and do things in year 2 that he would not have ordinarily had the opportunity to do.
I think also there is some testimony about the plaintiff to the effect of, just being there and then getting that head start. There's a discussion of head start damages in the brief that gave him sort of a leg up that he otherwise wouldn't have had if he had sat out.
Have we ever, in Pennsylvania courts, recognized head start damages?
There's been no case that I've found that's really addressed it squarely. I think that's part of the reason maybe Your Honors have taken this case on. We've cited the cases from other jurisdictions where Head Start damages were awarded under the theory that, where you don't sit out for that year and you get that Head Start, it gives you that extra leg up that you wouldn't have had going forward.
But these are public, don't these contracts, these placements have to be bid?
In theory, yeah, they're supposed to be bid. But of course, PennDOT, they have an MSP, a managed services provider below them, an intermediary, but ultimately PennDOT personnel are making the call, and they're the ones on site with Mr. Goli. He has those relationships. I mean,
well, but Mr. Goli had those relationships when you had him placed.
Right.
Just because he sat out a year didn't necessarily mean those relationships. Again, I'm trying to go, I think there's the legal question of whether there's a per se bar, and then there's sort of the factual question as to whether, if we say there isn't, did you preserve any kind of a case?
Fair enough. Yeah, I mean, I think we're focused obviously on the legal question, whether there's a per se bar. If not, I think it should be, if there's no per se bar, it should be remanded. Again, we should be allowed to present evidence at trial that we were intending to do so concerning all the placements that were made after the end of the first year.
Is that a limit? Is there a limiting principle? I mean, you asked for 2017. Would it apply to 2018, 2019? What's the limiting principle?
Sure, Your Honor. I mean, in the brief, our argument is just relying on Pennsylvania law, which is, again, all damages that flow from a breach are recoverable. So
that's a different argument than Head Start damages, and I think it's your better argument from my perspective. I mean, your principal argument was you're entitled to damages that flowed from the violation of the restrictive covenant.
Right.
And during the period of the non-compete, a contract was placed by Goli with PennDOT. You want damages that flow from that contract. I don't know if it's a year contract with PennDOT or whatever the amount of time was. That's the damages that you want. You just want, simply stated, damages that flow from the breach.
Right, Your Honor.
Your principal argument was not Head Start damages, was it?
That was not the principal argument. Our principal argument is damages that proximately flow from the breach. So there's actually a distinction to be drawn potentially between the two consultants that were placed during this restrictive period, and we recovered damages on account of those two placements through the end of the 1 year, even though they stayed on for years and years after.
Was there evidence of record of the term of the contracts that were placed during that period of non-compete?
There was evidence of record that the two consultants that were placed during the 1 year prohibitory period were still there at PennDOT, so there were still ongoing damages flowing from the breach.
Yeah, but that wasn't my question. I mean, when he entered into an agreement with PennDOT to place these individuals, was there a contract for a period of time when those people would remain at PennDOT?
There's just a work order with no defined term. It's just that they, as long as there's the work needed, they're still there. I mean, they're effectively permanent positions, but as of the date of the trial, as Mr. Goli admitted, that himself and the other one that were placed during the restricted period were still there. So that's where our argument comes from, damages that flow from the breaches that did occur during the restricted period. There were additional consultants placed after the end of the first year.
Why would you be entitled to damages flowing from that?
That's the Head Start theory.
No, it's not. The Head Start theory is that by competing initially, they get a head start. In your case, it's very easy. They got a head start on the two people they placed. I mean, this is so factually intense. But let me just follow through on this issue about the benefit of the breach, getting the damages that flow from the breach.
Right.
What was your argument? That you get damages up to and including the time of the trial?
Sure.
Period. That's what I'm asking you. Or like forever until those people are fired. Because that's a very different.
Right. Yeah, our position was that we were entitled to damages for at least the 2 consultants placed during the prohibitory period, as long as they were still there, because they were placed and they stayed in those positions.
No, there's no limiting principle, as Justice Weck just mentioned. I mean, what if you got damages up till the time of trial? What would they have been? Are they computable?
Sure. Yeah. I mean, if you add up the revenues that were realized, I mean, the number we had a right to know request. We had information about each consultant, but again, the trial court just blocked us from putting on any of that evidence after any damages of any kind after the end of the first year, whether it was consultants who were placed during the prohibitory period or after. It was all rejected by the trial court. And I will also add that, we did try to get an injunction at the beginning of the case, and we were denied an injunction because the court found that there was no irreparable harm, that damages were recoverable. The agreement itself actually stipulates that injunctive relief would be awarded. The trial court denied injunctive relief as part of its verdict, and just left us with damages. But the idea of including injunctive relief is to prevent this situation from occurring, where how do we compute these damages? How long does it go?
At most, your injunction would have barred Mr. Goli and this other person from working for PennDOT during that year. And to Justice Donahue's point, Mr. Goli and this other person could have been placed in year 2 without violating the breach.
They could have been placed in year 2 if there was no breach at all during the 1-year prohibitory period. Like I said earlier, and then they could have been placed then, but they weren't.
Right. But so that's kind of going back to my point, which is, and I think the point that the other justices are asking you about is, you need to somehow tie the breach in year 1 to evidentiary-wise to damages that flowed to your client that would not have occurred but for the breach. The problem you have is, one, I don't think you proffered any of that evidence below. You simply wanted to do what Justice Donahue is asking you about, is just say, we get the damages for these 2 employees and the revenue that they generated until they were fired. So I'm kind of thinking, I'm understanding and feeling the idea about the per se bar thing, but I think your problem is, I think your evidentiary arguments below and this theory that you want doesn't match with us removing the per se bar, because you haven't told me yet how you intended to prove that prove your damages in year 2 that you incurred because of the breach in year 1.
It's really a simple mathematical formula of PennDOT pays its MSP, MSP pays the vendor, and they pay the consultant. So whatever that margin is going forward for at least the 2 consultants that were placed during their prohibitory period is very easy to compute. But when we tried to put the evidence on, again, there's
but see, the problem is those 2 could have been placed with PennDOT in year 2.
But they weren't. I mean, if he had
they were.
if he sat out, no, they were placed in the prohibitory period.
No, but if he sat out,
but he didn't.
They could. I know, but you would agree. You have to agree that those 2 could have been placed in year 2.
Right.
What I'm not hearing you saying is that by virtue of placing them in year 1, they received some sort of advantage for placement in year 2. And there's evidence that you would have presented that they would not have been placed in year 2, but for the fact of the breach in year 1. That's what I kind of want to hear from you, and I didn't see it in the record, and I don't see it. I didn't see it in your brief, and I'm not hearing it today.
Right. Again, the idea of the injunctive component is to deter somebody from breaching a non-compete. You can think of the Ford Pinto case. In this case, there was obviously a calculation made by Goli Technologies that, okay, we can pay damages for year 1 and then be home free after that, and that's not what was agreed to. I mean, there was an intentional breach.
That's the problem with the per se bar. It encourages exactly that happening.
Right.
Which is why a per se bar doesn't make any sense. The way to deter violations is to allow damages to flow beyond the period of the non-compete. But the question is, what's the evidence? I mean, was there evidence that if Goli hadn't placed these individuals with PennDOT, you would have? I mean, there's, we just don't have an evidentiary predicate to
Right.
make the determination.
Well, the record does show that prior to the breach, Vinculum had 11 consultants at PennDOT. After the breach was all said and done, they had 5, and Goli went from 0 to 6. So that was circumstantial evidence. There was really no way to prove that any particular position could have been filled. Although Mr. Goli, I'm sorry, Your Honor.
Good circumstantial evidence. You don't have any money attached to it, though. There's no dollar amount attached to what you're talking about.
So what do you want us to do?
Right. Just one final point in terms of the record. Mr. Goli actually admitted on the stand that none of these requisitions were so specialized that Vinculum wouldn't have been able to fulfill them. Vinculum could have fulfilled them. Goli Technologies was able to. Again, he's inside there. He's there every day. A lot easier for him to do so. But Your Honor's question about what are we asking? We're asking you to issue a ruling that says there is no per se bar on damages that is arbitrarily linked to the prohibitory period. That if there's
To be able to demonstrate the amount of those damages.
Absolutely, Your Honor. Yes.
And it's not just for 2017, it's for whatever period the damages flowed.
Correct. For whatever breaches occurred during the prohibitory period, at least, any damages that flowed afterwards, they're all approximate cause. They're all approximate result of the breaches, of the violations.
All right. Any other questions for Mr. Ruff? Thank you, sir.
All right. Thank you.
Let's hear from your opposing counsel, Mr. Gold.
Good afternoon, everyone. I'll share Mr. Rothman's comment that it is an honor to be here, so thank you very much. May it please the Court. Thank you. May it please the Court, Travis Gold on behalf of Goli Technologies, LLC. We are here to discuss the issue of attorney's fees and of the, as it's been now phrased, the question of whether there is a per se bar on damages to the duration of the non-compete agreement. Let me start by saying that we have a restrictive covenant here which has historically been strongly disfavored, as the Sacco opinion put it, by the courts in the Commonwealth. That means we're not just dealing with ordinary contract principles here, we're dealing with how, within reasonable bounds, can we narrowly tailor these contractual remedies to carry out the fact that we tolerate restrictive covenants in this state, but we're not going to go out of our way to enforce them to the same extent as other contracts.
Well, that latter part seems a bridge too far. I mean, they bargained for something here, and part of what brings this appeal to us is there's a colorable issue that they didn't get what they bargained for. Isn't that fair to say?
If we were having this conversation in 1967, I would agree with you wholeheartedly, Justice Wecht. But because of...
We wouldn't have been having that conversation then because I was only 5 and you weren't born yet.
Touché. But because of what the Hayes opinion did with that issue of contractual remedies from a non-compete, Hayes was, of course, the case dealing with the question of do we temporally limit restrictive covenants to the period of the non-compete agreement only. And what they were saying there is a lot of the same principles I hear this court touching on now. Expectation damages. There may be ways that, and lower courts in the Hayes decision were going this direction, there may be ways to think reasonably that you need to go longer than the duration of the agreement in order to make a party who is aggrieved whole. But they said no. We're narrowly tailoring the remedies from a non-compete agreement, and we're limiting the injunction just to the period the agreement says. We're not here about injunctions. I agree with that. Sorry, but...
So this is a decided case. There's no reason for us to talk about this at all. You're telling us that Hayes controls the outcome.
I'm telling Your Honor that Hayes is suggestive of the outcome. I don't mean to, if I sound glib, I apologize. I do not mean to communicate that it's so open and shut.
Well,
but what...
Let's ferret out the policy a little bit, though.
Sure.
Because again, we're looking at this not necessarily from your facts and your case, but from a legal principle.
Yes, sir.
Let's say you have a one-year restrictive covenant, which the duration is relatively brief, and during that period, the person subject to the restrictive covenant goes with another employer, and that employer goes, look, I think you should violate the restrictive covenant. At most, we're going to benefit $50,000 from you competing against your former employer this year, and that's going to be the cap on damages. We'll pay the $50,000 if you're found liable, but if we allow you to compete now in violation, that's going to increase your revenue in the out years, 2, 3, 4. So we're going to tell you to breach now. We'll pay the $50,000 because we're going to make a heck of a lot more from you if we allow you to break your non-compete.
If I may reword Your Honor's question, just make sure I'm understanding it properly. What we're getting at is, do we take efficient breach that far, that it's okay to breach for economic purposes?
No. My question is, doesn't the per se bar foster that kind of business judgment to say, Pennsylvania has a per se bar, even though if we allow you to compete, we're going to generate exponential revenue as a result of it, and the math works out to support you and pay the damages you're going to owe your employer because we're going to make more money in the out years.
Understood, Your Honor. The answer to Your Honor's question is yes, a party can see what I'm attempting to argue here and take that away, but there is a curative measure that any two parties can take, well, especially the party in Vinculum's position, the employer, can take to prevent that sort of, if you want to call it misuse, from taking place, which is, it's the same actually measure that gets done nowadays to deal with the Hayes precedent, which is you have a non-compete period of however many years, 1 year, 5 years, whatever you write down. You add to that at the end, but if you do break this agreement, we're going to toll it. The clock does not start ticking until you behave. And that is a common tactic that employers put into their agreements, and it prevents that sort of business judgment from ever being made by a future employer who wants to assist someone in competing.
I did some non-compete litigation in practice, and I don't remember ever seeing a clause like that in a non-compete. I'm not sure I can accept your premise that it's a common practice. But you're basically saying then we should adopt a per se bar rule, even recognizing the mischief that could result.
Oh, it's just, Your Honor, that a per se bar was already adopted by this court back in, it's old precedent, but back in World War II, the Massachusetts bonding decision. It was not a non-compete case, but it dealt with the same kind of question we're dealing with here. We have an agreement. That was the insurance agency case with the agreement with the insurance company that said, we are your agency, we will get business and give it to you. Don't leave us unless you give us 30 days notice. The insurance company left them. They tried to present expert evidence, somewhat like Mr. Rothman was arguing on behalf of Vinculum. They tried to present a case at trial that said, because the rug was tugged out from under us without the 30 days notice, we were damaged a lot more than 30 days loss of business. We had no ability to replace everything we lost, which we would have had if we had had the fair warning. This court, long ago, said, no, you can't do that. The value of a contract for 30 days is 30 days of business, period. And I am asking this court to endorse the same approach. The value of a contract for 1 year is 1 year, period. Not to try to pull some malevolent act, but simply to say that what was in these two parties' brains when they put pen to paper was, this is worth 1 year.
But is that economically rational? Is that arbitrary, or does it fail to correspond to the economic reality?
I don't mean to be dense, Your Honor. Could you elaborate on the question?
The run-out period doesn't make any sense to you, the Hallberg rationale?
The Hallberg rationale does make sense to me under the unique facts of Hallberg, which was someone sells an established business and promises, I am not going to reinvent something like this just to compete with you after I just sold it to you. You paid as the price the ability to own this market without me getting in the way for a while. Then that party immediately started competing, immediately built a new business up. So we get into the literal meaning of Head Start damages. That party that agreed he would not do anything for a year or however long it was had a year of Head Start to get running and be a fully developed competitor by the time the clock ran out. And that's why even after the non-compete period ended in Hallberg, we had a serious problem of damages continuing to accrue. That is not the facts in this case, because in this case it's understood, and the Superior Court grasped onto this fact, that Goli Technologies was already fully developed. These were two more or less equally developed competitors, and Goli Technologies was only locked out of this one employee. And by breaking that, it wasn't like Goli Technologies was not able to break that agreement and thereby benefit by becoming something gigantic that it would not have otherwise been. It was already there.
All right. I think we understand it's a very discrete legal issue, and if you have anything to sum up, you may.
Just real briefly on the issue of attorney's fees, which I did not have much of a chance to touch on, if I may, Your Honor, just very briefly. Thank you. Under this court's decision in McMullen, it said parties may contract for the breaching party to pay the attorney's fees of the prevailing party, but it has to be reasonable and can be reduced where necessary. I take away from those words that you have to be prevailing. No, it's not written in our agreement, but I believe it is a reasonable takeaway. Just like the court in McMullen was concerned about abuse of fee-shifting provisions in contracts, I believe here it is potentially abusive to say to a party that is the net loser in a case, had to pay the breaching party more than it earned or received as an award, that you are entitled to an award for that result.
Counsel, how do you respond to the difference in a general fee-shifting provision in a contract that really doesn't that benefits both sides, and you have to decide who gets the benefit of that provision, which I think was McMullen, versus a fee-shifting provision here, which exclusively benefits one side? There's no provision in this agreement that gives your client attorney's fees. This provision only gives the Vinculum attorney's fees if it incurred them in enforcing the non-compete, not with regard to any other provision in the contract, and it's not a general fee-shifting provision. How do you address that distinction?
I address that distinction by saying that I agree wholeheartedly that there was no chance in the world that my client was ever going to be entitled to contractual attorney's fees. Notwithstanding that, no party, even the beneficiary of a one-sided fee-shifting agreement, I believe, consistent with McMullen and consistent with the interpretation of McMullen by, I believe, it was Judge Bartell in the Evergreen Power decision, can ever receive attorney's fees if they don't win, if in the net they lose their case. Even if they have something they were successful on, if when all the dust settles, they had to pay money, not receive money, I believe that precludes attorney's fees.
What would the jurisprudential reason be for that? What's the jurisprudential reason for the holding that you just articulated?
One, I believe the plain language of McMullen supports it. Two,
No, the plain language. McMullen essentially dealt with the exclusion of the phrase reasonable from attorney's fees in the contract. And
Agreed.
From a jurisprudential standpoint, this court said too much danger involved with that.
Agree wholeheartedly.
The court has the ability to determine reasonable attorney's fees. That's what courts do. What is wrong with a contract that says you get an award for each violation? Why would the court step in and say, as a matter of policy, that is an inappropriate contractual provision?
Because what it is enticing parties to do is be in a situation like this, where someone trying to look at this dispassionately, as us lawyers try to do, but sometimes fool ourselves into thinking we're doing when we're not, is see, I have a situation where my client was the victim of a breach, but I've done something wrong as well that when this gets to judgment is going to result in me losing more than I'm gaining. Notwithstanding that, I have the carrot in front of me that I'm going to get attorney's fees at the end of this, no matter what. So why not litigate it to the end?
Well, you're throwing back at us. I'll throw back at you the point that you made, which is the resolution.
Is it answering your question, throwing back?
Yes, the resolution is to put it in the contract and have a mutual fee-shifting provision, and forces the court to say, pick who gets the benefit of that, and usually we default to the prevailing party because we can't give attorney's fees to both. But your client didn't agree to any language that gives your client attorney's fees at all, and you certainly could have agreed to limit the attorney's fees language in the contract that is one-sided and benefits Vinculum.
I agree, Your Honor, that would have been another way, the same way that I offered you earlier, that you could have a tolling provision for the one-year problem. That is a way that this problem could have been solved. It wasn't solved that way, but I don't believe that precludes an argument that it is not reasonable, again, to borrow evergreen Committee Powers interpretation of McMullen, it is not reasonable to award attorney's fees to a non-prevailing party. Just because my client is precluded from ever getting $1 of attorney's fees does not mean that upon breach, even if he wins more than Vinculum, if Vinculum is found to cause more damage, that it should receive an award of attorney's fees.
Why would it be inappropriate? Why would it be inappropriate to view this, given the language of the contract, to say Vinculum did prevail on their claim, they just didn't prevail on the counterclaim? So you award attorney's fees for the amount of cost for attorney's fees to prosecute the claim, but not to defend the counterclaim.
If Your Honor wants to pick it apart that way, I see the reasonability in that. I don't mean to disparage, but to...
That's what we do.
And you do it well. I would suggest that there would have to be some work done to reconcile that with the decision in ProfitWise, which was saying there it was easy. The agreement said prevailing party wins. We didn't have all this additional minutia. But what ProfitWise additionally got into was saying, how do we figure out if there is or is not a prevailing party when there's a settlement? And there they said, no one prevailed, we don't do anything. So you'd have to evade that issue, not evade, but address it a bit. Understood completely. In a world without McMullen, I would not be having this conversation, but I believe because the door's already been opened to, we have to make sure things are reasonable. It is not inappropriate. I don't need the double negative. It is appropriate to say that getting an attorney's fees award for being the net loser in a case is not reasonable. As to Your Honor's argument or pointing out, can we pick out just this provision of the contract that was breached and separate it from the rest? We could. I would say that if we're going to do that, it should be made clear that that's the law going forward, because it wasn't commonsensical to me coming into this. I would also say that before we go there wholeheartedly, let's remember that this entire dilemma could have been avoided if Vinculum had simply paid the additional wages or consulting fees, whatever label we want to give, the additional sums that were owed under the party's contract. He could have paid the money and gone to collect it later.
No, but your client agreed to allow them to hold the money. It was essentially a contracted for interpleader.
Agreed to allow them to withhold the money up to the amount of damages caused. But right, once Vinculum went beyond... I'm sorry, Your Honor, I didn't mean to interrupt.
Well, obviously, but their view of the damages at the time was in excess of the $40,000 that they withheld. And essentially, like I said, I read it as sort of a contracted to interpleader. They held the money, you came and got it, and at the end of the day, of the $40,000 in dispute, they got 30, you got 10. They won. Why am I wrong?
Well, they got 30, we got 40, and therefore we got,
you got 10.
10.
You got 10. They withheld the funds because they were contractually allowed to do that, and that money was then in dispute, sort of like an interpleader, and of that disputed funds, they kept 30 and you got 10.
I agree that out of $40,000, they kept 30 and we got 10. I do not agree with the statement that they were the net winner, because the trial court did award us $10,000. As far as it being a contracted for interpleader, I understand the interpretation, and I don't disagree with the interpretation, but I do respond that when they decided to avail themselves of that provision, they acted at their own peril. It was up to them to do their darndest to accurately compute the damages that Goli Technologies' breach had caused. And to the extent that they went beyond that and withheld more than they were entitled to withhold, that's where I think they made a mistake and opened themselves up to being the net loser, and therefore opened themselves up to being precluded from attorney's fees. Had they not done that, I would not be making this argument today.
Counsel, if I just may. Counsel,
yes, sir.
Your position that the withholding of money is not, or is part of or not part of the breach of contract regarding the non-compete clause?
The withholding of the money is absolutely a breach of contract. It was absolutely a breach of the same
Is it a breach? The specific issue here is the breach of the non-compete, not a breach of contract. That would be a separate cause of action, the way I see it. I'm asking you. You're saying that your client's the prevailing party and not Vinculum.
I understand where your Honor's getting at, I believe. Yes, I believe that it was a breach of the non-compete clause because forgive me if I'm wrong, but I believe it is the non-compete provision that provides for the withholding of money if there is a breach. And it is that term that I was just arguing to Justice Robson that I believe was abused by withholding too much. So yes, I believe there was a breach by both sides.
Okay, we're going to wrap it up. Mr. Ruffin, Mr. Gold, we understand your arguments, and it's simply a matter of contract interpretation. Fortunately, that's something we like to do. So we've got this. Thank you very much.
Thank you very much, Your Honors.
Mr. Mayor?
Thomas Washington versus the Department of Corrections. Representing Mr. Washington, Mr. Ted Hagee. Representing the Department, Ms. Goli.
Good afternoon. This appeal presents the issue of whether due process requires the Department of Corrections to provide an inmate with notice and an opportunity to be heard regarding a statutory increase in the rate of deduction of funds from the inmate's account to pay court-ordered costs and restitution.
Madam Chief Justice, Your Honors, may it please the Court. I'm Ted Hagee, and I have the privilege of representing Mr. Thomas Washington in this appeal. As the Due Process Clause guarantees, Mr. Washington asked this Court to provide him with notice and an opportunity to be heard as to the Department of Corrections' application of a heightened 25% rate by which it takes his constitutionally protected property. Under controlling due process principles as reflected in Bundy, Johnson, and Montanez, the DOC must provide notice of the rate and a meaningful opportunity to explain why the deductions should not take place, notwithstanding the dictates of Act 84. Here, the DOC admits this was not done. And as a constitutional matter, reversal is required for that reason alone, as the deprivation of a constitutionally protected interest at inception triggers due process. To be sure, the 25% increase followed from specific language in the amended statute. But as the dissent correctly recognized, that is a distinction without a difference as far as Mr. Washington's independent right to due process is concerned. Whether the DOC adjudicates the applicable rate based on statutory criteria or by its own policy, the act of taking property triggers due process all the same, and for good reason. If due process were not provided, the DOC could increase the deduction rate after an original deduction with impunity. The safeguard that is due process would be rendered meaningless, but that as a result this Court's precedents have never condoned. And
explore that a minute, because I know this was in the dissent. I would think that you wouldn't have any argument from the Department of Corrections if they, because they have the discretion under the statute to take more than 25%. That under our precedent, if they exercised that discretion, because the statute says 25 and there's nothing else in the ether that says anything other than 25, if they set it at 25.2, the only way your client would know that is if they provided you notice. The client can't, it's not in the statute. And then it would seem that the department would have to give you under our precedent an opportunity to be heard as to why that decision by DOC under the circumstances of your particular client has to be set aside as an abuse of discretion. But here, the department had no discretion. It was the General Assembly and the governor that took your client's property for 25%. If you succeeded at a hearing, which I'm interested to hear what this hearing would look like, there could very well be a mandamus action compelling the department to take the 25%. I just don't know what is this hearing going to look like, and what discretion did the department exercise that made its decision here adjudicatory?
Sure, Your Honor. Well, if I could answer with a few points to that. The election of a 25% rate based on the statutory criteria, which does call for a 25% rate, is an adjudicatory act. And we know that the DOC has discretion to impose that rate, but the DOC also has discretion under its interpretation and Mr. Washington's interpretation of the amended Act 84 to impose a lower rate. And
wait. The department has the discretion to impose a rate lower than 25%?
It does, Your Honor.
Where in the statute is that?
Sure. That comes from the statutory, the last Roman numeral in the subsection B5. It talks and calls upon the DOC to adopt guidelines as to how it applies the statute. So when we look at the DOC's discretion to apply guidelines, that gives us the answer. Indeed, the DOC has interpreted the text through its policy DC ADM 005, and that policy exempts from the 25% rate any individual who has $10 or less in their account. Now, importantly, that policy was enacted in 2020, after the statute was amended. So it's the DOC's post-amendment interpretation and implementation of the amended Act 84. And as to those individuals that have that certain dollar figure in their account, the DOC has elected to apply a 0% rate of deduction. That shows that the DOC has discretion to go below the presumptive rate in the statute.
I guess it shows that the DOC thinks it has discretion to go below the 25% rate. But I think that's an interesting argument. It's something that I hadn't picked up, and there's no one here challenging that regulation. So under that regulation, you intend to argue that at this hearing that your client has less than $10 in his account, and therefore they should have imposed a 0%.
Well, not exactly, Your Honor. Well, as a preliminary step, I think this Court has the ability to avoid the statutory interpretation question altogether. And that's because the right to procedural due process, as Bundy explained, is absolute. That's at page 559 of the Bundy opinion. It's a right that must be provided independent of the merits of any underlying challenge, because a constitutionally protected interest may only be taken through the procedural safeguards that the 14th Amendment calls for, notice and hearing.
What relief can you be granted? If it says at least 25% and you nominally get a victory, right, because you get that hearing, but they're not allowed to go below 25%. So isn't it a hollow victory?
I don't think it is a hollow victory, Your Honor. For a few reasons. One, I believe the statute, when properly construed, including by the DOC's own interpretation, does permit deviations in appropriate circumstances. But even if this Court read the statute, and again, I don't believe this needs to be decided to grant Mr. Washington the relief that the Constitution requires, but even if the DOC could not go below the 25% rate, due process would still have a very meaningful function. One of the fundamental reasons for requiring notice and hearing is that so that an individual facing a property deprivation is informed of what the government intends to take and how it plans to do so, and to then give that person a fair opportunity to make sure the government is not making any mistakes. This procedural safeguard is an important constitutional right in itself, and its error-detecting purpose and function, according to Bundy, is just as important as any substantive challenge. That's at page 558. Now here, catching even a small error could be incredibly meaningful. For example, if a miscalculation is made and the DOC intending to take 25% actually takes out, let's say, 27% due to a calculating error, well, that could be incredibly meaningful for someone making only 19 cents an hour. And it's also not hard to conceive of any number of errors that could be made through simple ministerial actions.
But your client and all the prisoners, inmates have notice of the amount of the deduction. Your client raised this claim because he looked at his account and saw the deduction was being taken out at 25%.
Right, but the DOC admits that that was not noticed within the meaning of Bundy.
Well, see, that's the big issue, is does Bundy and all, you know, those cases kind of came up in the context when the department actually was exercising discretion. I think your whole case rises or falls on whether the department has discretion here. If the department acted with discretionary authority, then they had to give your client notice and an opportunity to challenge that exercise of discretion. But you seem to be suggesting that when the General Assembly sets a fee to engage, and I'm taking this case to the logical extent, that all nurses in Pennsylvania must pay an annual registration fee of $350. That before the Bureau of Professional and Occupational Affairs can impose that fee on a nurse, they have to give the nurse notification of it, an opportunity to say what before they can extract the fee.
Well, Your Honor, I think the Johnson decision of this court provides the answer here and explains why the Constitution must be followed irrespective of the statute and why the statute not need be reached. This court's Johnson decision, which was decided after the statute was amended as well, unequivocally holds that objections, including to the rate of deduction, must be heard notwithstanding the dictates of Act 84. And contrary to the DOC's claim that Johnson dealt with only the pre-amended statute, the petition there challenged not just pre-amendment deductions, but all deductions to continue, and that includes those that would take place under the amended statutory scheme. Specifically, the Johnson pleading claimed that the DOC wrongly deducts funds from petitioner's inmate account and continues to deduct funds till this day. That's at page 1180 and 1186 of the opinion. Now, despite the fact that the post-amendment deductions were implicated, including those under the amended Act 84, this court did not invoke the amended statute to qualify the reach of due process in any way. In fact, just the opposite. This court gave its strongest expression in the entire Bundy line: due process applies notwithstanding the dictates of Act 84. And that is controlling here, Your Honor, irrespective of any sort of statutory interpretation. But I'd like to address the point that Your Honor raised earlier about what does this hearing look like?
That was Justice Webb who raised that.
My apologies, Your Honor. I thought I heard it from you as well, but if any justice wants...
I'm sure he said it much better than I did.
I'm happy to address that point for the court's consideration. I think Bundy is instructive here. Bundy recognized that providing due process is unlikely to impact upon the DOC's institutional goals. That's at page 558. And notably, the DOC does not argue otherwise here. It's been a decade since Montanez ordered the DOC to provide due process with respect to Act 84 deductions, and no administrative crisis has since occurred. And there's nothing to suggest that it would occur in this case either. In fact, the DOC's own procedure contemplates that there can be changes to its deduction policy and that it has to provide due process with respect to that. Specifically, under Section 3A4 of the DC ADM 005 policy, the DOC has a protocol in place when there's been a change to a Bundy item. Specifically, the DOC will send a notification of amended deductions memo, which triggers a 15-day period for an individual to be heard through written objections. Now, it would be very simple for the DOC to apply a similar level of notice and hearing here, and we're not asking for any formal judicial hearing. It's an administrative process that can be done.
Post deprivation?
I'm sorry, Your Honor?
Could it be post a later hearing? Post deprivation?
It could. The Johnson case recognizes just that.
Right. And it's the formality. It's the formality of the hearing that you require. In other words, it's the form of the thing rather than the realistic availability of meaningful relief.
Under the 14th Amendment, this is the process and procedure by which the government may take an individual's property. It's a safeguard, and that's a right in itself.
I take issue with your reliance on Johnson for this position, and I'm reading from the decision, and it says, "We now hold that the aspect of Bundy applies to inmates whose accounts were subject to Act 84 deductions without the benefit of pre-deprivation safeguards. Thus, due process requires the department, in response to an administrative grievance, which accurately recites that no Bundy process was afforded prior to the first Act 84 deduction. So it makes a distinction that this only applies to those class of inmates who had never received pre-deprivation notice at all.
Well, I think.
Whereas in this case, it's my understanding that these people all got pre-deprivation notice. They just didn't get re-notice after the amount of deduction changed.
And that's exactly the problem here, Your Honor. Mr. Johnson, or apologies, Mr. Washington does not contest that, the DOC failed to give notice and post-deprivation remedies after the Johnson opinion to those that received notice of the 20% rate of deduction. But here it's the 25% rate which causes the constitutional problem. It's undisputed here that the DOC has not provided notice in hearing as to that increased rate of deprivation, and the rate of deduction is a specific Bundy item. Every case in the Bundy trilogy has recognized that it is an independent item, and the dissent correctly explained that once there's a change to a Bundy item, due process is triggered because it's a new deprivation of property.
My question is, why don't you share with us what you believe the due process should be?
Well, I think the answer to that comes from this Court's own precedent, which sets the standard for what due process requires. As the Bundy case explained, the DOC has significant discretion to implement the strictures of due process in a flexible way that is minimally burdensome. It simply must be meaningful. It must be given to the individual, and providing that individual a meaningful opportunity to state any objections they have to the deduction scheme.
So following Johnson, your client received notice of the 25% increase when he looked at his statement. Why is that not sufficient due process such that he could then request a hearing?
Well, that answer flows from this Court's own precedents, going back to the Montanez, and the Montanez was a Third Circuit case, but that and the Bundy case.
But see, Bundy, those cases were that there was absolutely no notice provided. So this is, I can easily distinguish those cases from Johnson and your argument. So let's leave Bundy and Montanez on the side. We all understand that your client's entitled to due process for a deprivation of property. He's already been informed. Now, your argument is Johnson said that there could be, post-deprivation notice. You received that. You received a statement which indicated that a 5% increase had occurred. Why is that not sufficient due process for your client to challenge or follow the appropriate grievance?
Well, Your Honor, Mr. Washington did not receive notice of the 25% deduction.
How did he find out that 25% was taken out?
The money was already taken from him. The DOC provided him—
That would be a post-deprivation, correct? Consistent with Johnson.
Johnson calls for a post-deprivation notice and remedy. But here it's undisputed that no notice was provided to Mr. Washington. In fact, the DOC says as much in its brief, and its policy for providing notice of a change to a Bundy item or any change in its Bundy policy is through an amended or a notification of amended deductions memo.
Which brings me back to my original question. What do you think the appropriate due process notice should be for your client?
I don't think this Court needs to decide the issue. I think this Court—
I'm trying to gather your argument and put it in some context. What do you think?
Sure. Me personally,
for your client's behalf.
If a meaningful opportunity is given to Mr. Washington to raise his objections to the deduction scheme, and he has several objections to it, due process is satisfied.
Should it be like a grievance, a form?
It can certainly be a written process, an administrative written—
Should it be the warden telling everybody over the loudspeaker, hey, everybody, we're increasing?
That could satisfy notice, but it's not just notice in itself. It's an opportunity to be heard after that Bundy item.
Hey, everybody, we're increasing it. You can file the grievance form if you have any issue. That's sufficient.
And if Mr. Washington's grievance form is considered in a meaningful time, in a meaningful way, that could satisfy due process. But here it's uncontested that that never occurred. The DSC doesn't argue as much.
What's the meaningful way? That's what I'm trying to. That's what also I'm trying to understand, which I thought you were going to answer. Let's say we have this hearing. Is there, in your view, a valid challenge to the 25%?
Yes.
Under the statute?
Yes.
What is that challenge?
Well, we can look at Mr. Washington's own challenges. Mr. Washington has pled, and this is coming up on the preliminary objection stage, and this is a pro se pleading, which shapes how we view this pleading and the level of rigor of which we look to the allegations in it. But Mr. Washington has pled that the increased rate of deduction is hampering his access to the courts. That's one of the underlying substantive challenges.
That's a constitutional challenge to the statute.
No, we are challenging how the statute is as applied to Mr. Washington.
Okay, so it's an as-applied constitutional challenge. Can the Department of Corrections rule on an as-applied constitutional challenge to the statute?
Yes, the Department of Corrections already exempts from the 25% rate certain individuals that it deems warranting of relief. It's those that have basically an indigency exception. They have $10 or less in the account. We are not going to take 25% deductions from you. Due process guarantees Mr. Washington the same opportunity to present his claims for why the 25% rate should not be applied to him. And one of the really fundamental reasons why the DOC might not apply it is if applying that heightened rate is inhibiting him from accessing the judicial system. There's other challenges here as well. Mr. Washington has pled that the increased rate of deduction as to him is unreasonable, and the Montanez case considered that very challenge. Now, the Montanez case adjudicated that a 20% rate was reasonable on that record, but it's undisputed here, Your Honor, that the heightened 25% rate has never been adjudicated. And on this record and under the facts the amici so powerfully demonstrate, the oppressiveness of a 25% rate as applied to someone making only 19 cents an hour and who has pled at this stage, the preliminary objection stage, a monthly income of only $30, it very well could be unreasonable.
See, I completely get all of that. I'm just wondering why you're not bringing an as-applied constitutional challenge to the statute in the Commonwealth Court, because that's where you can get relief. I don't know of any case law that says an agency can hold a statute unconstitutional as applied. I may be wrong. They can conduct the hearing and create the record, but I'm not sure they have the ability to declare a statute unconstitutional.
Well, apologies if I misspoke, Your Honor. That's not quite how I intended to frame it. Under the statute, the DOC has discretion in how it implements Act 84.
Well, I guess, okay, so your argument is because the statute says shall deduct a minimum of 25%, but creates a general catch-all that allows the agency to create a regulation, they can pass a regulation to change shall to may.
It's not changing shall to may. Shall acts as a general rule here. Deduct 25%, but you can hear claims for exemption, as the DOC's own policy understands. The DOC has already recognized in its policy that certain indigent individuals get exemptions from the 25% rate, and Mr. Washington, under due process, the right to notice and hearing, has his same opportunity to present his claim for relief.
Okay.
He very...
I think we get it. Is there another question?
I have one follow-up question. If we find a constitutional violation, your relief would include a post-deprivation hearing.
That's exactly right, Your Honor. Under Johnson.
It may also include nominal damages at some level.
Exactly right as well.
So that's the remedies that are available under these circumstances.
Yes.
It also provides a constitutional groundwork for future claims.
That's exactly right, Your Honor. The underlying merits of Mr. Washington's challenges do not need to be adjudicated today. That happens in the hearing. Irrespective of whether he actually has meritorious claims, due process guarantees him a forum to make his claims.
Okay, thank you, Mr. Hayes.
Thank you, Your Honors.
Good afternoon. May it please the Court. Kim Adams on behalf of the Department of Corrections. There is no dispute that Act 84 is constitutional, and the General Assembly gave the Department of Corrections the power to deduct money from inmates' accounts. Montanez and Bundy were very distinct in the statute because pre-2019, Act 84 gave the Department discretion in the rate at which it deducted money from inmate accounts.
Counsel, suppose tomorrow the department decides to bump it from 25% to 99%. Would a hearing be required for that increase?
If the department increased from the mandatory 25% to 99%, we would have to give inmates notice of doing that because the department is then using their discretion and going above the mandate of what Act 24 is. And if the inmate, per the policy DC ADM 005, they would have the opportunity to grieve that, and if they can show that by not paying the money that they would be subject to more incarceration or stricter supervision, they'd be entitled to a hearing at that point.
So the triggering, what triggers it in your view is the moment they go above 25.00.
Yes. Even as Justice Bronson said, if we went 25.1, because we were going above that mandatory 25%, which is set by statute, we would have to give notice.
Why don't you have to give notice, period? I'm just sort of just a little bit confused by this notion. Your client is taking money from inmates.
Correct.
Your client is depriving the inmates of property.
Correct.
Why doesn't that trigger due process protections?
Due process is triggered, per this court in Monday, before the first Act 84 deduction is made. When an inmate comes into the Department of Corrections custody, we must give them that notice before we take any money out of their inmate account.
Pardon me.
And that happened here.
Can I just clarify for a moment? They have to be given notice of the rate of the deduction under Monday.
That is part of it, yes.
Well, it's what it says.
Yes.
So when the rate increases, which is taking additional property, why doesn't that trigger due process protections?
That additional money, that additional 5%, was a legislative act done by the General Assembly. And due process does not necessarily always flow to legislative acts. The U.S. Supreme Court in bimetallic found that. They said that even if it sends somebody to ruin, if it applies to a whole class of people, due process is not triggered. There's no dispute here. Mr. Washington was provided notice before his first Act 84 deduction. The rate of change came through the General Assembly. It was the General Assembly's will and then signed into law by the governor that the Department of Corrections is to take 25%. The Department of Corrections, we do not have any benefit. We're essentially the middleman or the debt collector. We take the money out of the inmate account at the 25%, which the General Assembly set at not less than 25%. We cannot take less than 25%, and we pass it along to the county of the residence of the inmate who's been incarcerated.
So my problem with your argument is you can take less, you believe, at least outside of this courtroom, that you can take less than 25%.
We take that in very limited circumstances for inmates whose accounts go below 10%, to make sure that, $10, to make sure that we are not infringing on constitutional rights. If an inmate,
well, it's either discretionary or it's non-discretionary. I mean, it doesn't, the rationale or reason doesn't matter. You're in here arguing you can't go 25% because that was the will of the General Assembly and the governor. They didn't qualify it in any way as to when you can accept it. So it seems to me I don't know how you can have it both ways. On one hand, you have no discretion, but on the other hand, you do.
Again, it's just for that limited purpose of inmates who are indigent whose accounts are $10 or less.
Could you come up with another limited purpose?
Could we?
Yeah. You came up with this one. Could you come up with another one?
We potentially could.
And what's your authority in the statute to do that?
I mean, we do have authority in how we implement Act 84. I do not think that goes to us being able to change the rate of deduction to 25%.
If he gets a hearing and he convinces the hearing officer, or maybe it's not a hearing officer, it could be a relatively informal process, and it goes directly to the warden of the prison. It doesn't even have to go to the secretary or through a normal hearing process. And the warden determines through the grievance process, you know what, this deduction's too much for you. I'm going to exercise the discretion that the Department of Corrections has under the statute, given your circumstances. The 25% is too much. It's impairing your ability to go to the courts or any number of things. Your deduction is going to be reduced to 15. Do you have the authority to do that?
I do not believe so, because the way the case law is set right now, inmates don't have the ability to have are not entitled to an ability to pay hearing for hardships. They're only entitled to an ability to pay hearing if there's a threat of additional incarceration or if increased supervision. That's correct.
Let me follow. Did I understand you correctly to say that because the General Assembly and the governor decide to pass legislation or amended 84 so that the minimum you could collect is 25%. However, under 9728B5, the catch-all phrase, the Department of Corrections shall develop guidelines relating to its responsibilities under this paragraph, now permits you to make a regulation to withdraw less than the mandate written by the General Assembly and approved by the governor. But yet, you don't have to provide notice. Your argument doesn't seem to make sense.
So, for an inmate who has more than $10 in his account.
But that's a regulation you made.
It's our policy, yes.
It's our policy. But would that $10, could that be in many scenarios less than the mandated 25%?
I'm not sure I understand your question. I'm sorry.
What's the maximum or the minimum level you're permitted to remove?
0.
If it's at $10, we do not remove any money. And the way this works, an inmate comes into the prison with money, and they're provided notice. We don't take from that original money. If an inmate has a gift put on the books of $100, that's when we would deduct the 25%. If an inmate drops below $10, we're not taking money from that $10. If they get $100, then our account goes back up over 10, we'll take whatever portion is left.
And the concept, it's a policy argument, but I'm trying to follow your concept. The concept of restitution and court costs is to make the inmate responsible for her criminal conduct. So when a family member supplies monies to assist in the quality of incarcerated life and not to pay restitution or court costs, you independently make a regulation to decide how much you're going to take from them to pay court costs at the deprivation of their quality of life incarcerated.
Yes, and this court on numerous occasions has held that gifts are not exempt from Act 84.
Yeah, this court can change anything.
I understand, but as I'm standing here today, that's not been changed. It is, once that money is given to that person, that becomes that person's money. It's a gift. It's not a loan. It's not meant to be repaid. It's a gift. And again, this court has found that gifts are not exempt from Act 84.
All right. Do you want to wrap up, Ms. Adams?
Just thank you for your time. And again, since this was a legislative act, we did not need to provide the additional notice.
Thank you. Is this your first time arguing before the Supreme Court?
It is, Your Honor.
And how about you, Mr. Hayden? It is as well.
Fine job by both of you.
Very good.
Thank you.
Thank you.
Didn't even appear nervous.
No, sorry.
You did not even appear nervous.
And we were really nice.
Nicer than usual.
The Department of Community and Economic Development versus the City of Chester, Mayor Chester, Council of Chester, representing the appellants, Mr. Mark Pfeiffer, representing the receiver, Ms. Tiffany Allen.
Okay, a quick little case here, right? These appeals involve a municipal receivership proceeding pursuant to the Pennsylvania Municipalities Financial Recovery Act of 1987, known as Act 47, and require our court to examine the role of an Act 47 receiver, the ability of an Act 47 receiver to suspend the duties of municipal officials, and the extent to which a municipality retains the right of self-governance during an Act 47 receivership. Please proceed.
Good afternoon. May it please the court, my name is Mark Pfeiffer from Buchanan, Ingersoll, Rooney. I represent the City of Chester proudly, and the mayor and city council of the City of Chester as a body. The primary elections occurred 2 weeks ago, and the mayor and the Councilman Morgan lost. They were the two primary people the receivers' remedies were aimed at, which highlights the problem with the remedies. They were aimed at public officials, but they actually hit the office. when the new mayor comes into office and when the new council people come into office, they will not have had any responsibility for what has occurred. They will not have any responsibility for the financial difficulties that has occurred over the last 5 or more decades, longer than my lifetime.
Counsel, I don't understand how the personalities bear on the legal question. I mean, you have the burden, among other things, of establishing for us why the Home Rule Charter should trump Act 47 rather than vice versa. And the fact that it's Smith or Jones or you know, any other individual doesn't seem to impact that legal question, does it?
The point that I'm trying to make, probably not articulately, is that when the person comes in and gets inaugurated in January, they're not going to have the full power in the full office of the mayor.
Well, the receiver can deal with that accordingly, can't he?
That's the issue before us today.
That's the issue before you today. The receiver could file another modification. Doesn't necessarily mean the receiver is going to file another modification, but the person who comes into the office, the mayor particularly, is not going to have the power to delegate responsibility to the other elected officials. The mayor is not going to be effectively the chief executive of the city. That job is going to be, and that's required under the Home Rule Charter. That's provided under the Home Rule Charter. Instead of the method under the Home Rule Charter, the chief of staff is going to effectively be the chief executive.
I'm sorry, just not to belabor this, just briefly. You seem to be, in your papers and now in your argument, you seem to be battling against the plan that the General Assembly scripted for situations like this. They said in these emergency situations, we have to have this mechanism, and you folks, you know, you're this basket case out there, and they've created this for your situation, and now your argument, your leadoff argument today seems to me to be, okay, we're going to be good now, please back off because we've elected different management to take office in 8 months or whatever. That doesn't seem to me to be a legal argument against the powers that the General Assembly chose to give this receiver.
Two ways to respond to that. Act 47 does not script that result. In fact, in a fiscal emergency, under Section 605 of Act 47, says during a fiscal emergency, the elected and appointed officials continue to fulfill their duties. And when you look at what the receiver's powers are, they are not broad powers. They are enumerated in 706. And 706 does not give the receiver the right to govern the municipality, does not give the receiver the right to act on behalf of the municipality, except in one situation, and that's the filing of the bankruptcy, which the receiver has done, and only gives the receiver the right to modify the recovery plan to effectuate financial stability. These elected officials have two roles here. They are both the elected officials, so they have the legislative function of the city, but in this Home Rule Charter, they are delegated, appointed administrative officials, so they run the departments as well. And the Section 605 says even those appointed administrative roles stay in place.
Well, but Section 704 provides that the confirmation of the recovery plan shall have the effect of suspending the authority of elected and appointed officials of the distressed municipality to the extent that the power would interfere with the powers granted to the receiver or the goals of the recovery plan. So your initial premise in response to Justice Wecht that the receivership doesn't have an effect on the powers is false.
Now, Section 704 is important. I think it's probably the most important provision here. And Section 704 is the effect of confirmation. It is the byproduct of confirmation. Any power that actually conflicts with the confirmed plan is suspended, and it is presumably suspended automatically without anybody doing anything. It is not an enabling statute enabling the receiver to effectuate a plan which causes a suspension of the duties. It's a cart before the horse scenario. The receiver is asking the court to enable it, or has asked the court, or has taken upon it himself to suspend the duties when Section 704 says that the duties are only suspended as a byproduct of the Act.
Okay, I found the format of your brief a little bit difficult to follow because there's multiple provisions of the recovery plan, and you don't really go provision by provision. You sort of you mix 4 examples in and things like that. But let's take one specifically, the one that I think you have the biggest issue with. And I can see why you have the issue. It expressly, it says this provision of the charter is amended to substitute the word "the receiver" for city council. We know which provision I'm talking about?
Yep.
Okay. That is an express provision of the recovery plan that purports to actually amend the charter.
Correct.
And I understand your challenge to that particular thing. That's with regard to the exercise of authority by the city council to disregard the residency requirement and look outside. Could this receiver, under the law, have accomplished the same thing a different way that would be legal? Could the receiver say, city council must explore qualified individuals beyond the residency of the city of Chester to fill these positions, and I have to approve all those hires because under the Act, I specifically have the power to approve contracts and disapprove contracts? Would that have been fine?
Let me start off by saying the modification, the express modification of the Home Rule Charter was the leading point because it was a glaring issue.
That's why I'm using it as the example.
Correct. That is not the main thrust of the case. Whether or not the receiver has the ability to do it in a different way, I haven't thoroughly analyzed it. The main thrust of this case is the suspension of the duties and change in the form of government, change the responsibilities of.
Well, let's take the suspension of the duties one, because that comes up a lot too. It's the provision in the contract that essentially prevents city council from having the other hat of also being department heads. That's the one you're talking about.
Correct.
Under that, it's the mayor, if I remember the charter correctly, that has the authority to appoint department heads and may but is not required to appoint council people, correct?
Correct.
So what if the receivership says, the modification plan had said, Mayor, you must appoint qualified outside people as department heads, and that's how you must exercise your discretion. How is that a violation of the Act?
That modifies the Home Rule Charter.
No, it doesn't. It just tells the mayor how to exercise the discretion the mayor has in the Home Rule Charter.
It changes the form of government because the mayor, under the form of government, under the Home Rule Charter, has the discretion to pick and to assign duties to people he chooses, including the elected officials. But
Act 47, doesn't Act 47 give the receiver the express power to approve and disapprove hires?
These aren't necessarily hires. These,
circling back.
Well,
Because
no.
they're elected as council people, but they're not elected as department heads.
Or if I may ask the question, tell me if I'm wrong, because what I'm understanding your argument is somewhat different than my colleagues. Under Section 102, the concept of Act 47 is to enact the quote-unquote procedures and provide powers and guidelines to ensure fiscal integrity. And that is when conducting government affairs. Pursuant to Section 605, the elected officials in a distressed municipality shall continue to carry out the duties of their respective offices. Section 704 is interpreted to mean if those elected officials are interfering with the fiscal or with the expenditures based on their revenues and dealing with anything that Act 47 receiver wants to go to the fiscal aspect of, or I should say fiscal integrity, those duties are suspended, not the elected position from the people of Chester. Is that what you're saying?
it's not the elected positions. There's two rules, legislative and administrative. The appointed officials are acting in the administrative capacity. That is protected under 605 of Act 47. It's a fiscal emergency. The fiscal emergency has not ended. 605 says that the general rule is they stay in power and they still fulfill their duties. Only if there's a conflict between an actual existing plan and those duties are they suspended. But 704 does not.
Stop. When you say suspended, do you mean suspended from their elected position?
No.
Or the power to affect the fiscal integrity of Chester is suspended if it's in conflict with the position of the receiver?
704 says that the powers of the officials, or the duties of the officials, I can't remember which word it uses, are suspended to the extent that it conflicts with the plan or the powers of the receiver. The powers of the receiver are enumerated in 706. And the 706 provides the mechanism by which the receiver can effectuate a modification to the plan. And
the Commonwealth Court has a standard before it can modify a plan, and the Commonwealth Court opinion went through this in somewhat meticulous detail. And so maybe you could tell me where was the clear and convincing evidence that the plan modification was arbitrary, capricious, or wholly inadequate to alleviate the fiscal emergency in the distressed municipality. We keep missing over this sort of overlying point here, is that you have a municipality that is not only in a distressed municipality, but at the highest level of a distressed municipality than one could have in Act 47. So what is it that the Commonwealth Court did here that exceeded its very limited ability to deny a plan modification?
so the arbitrary and capricious standard comes into play in 605, which says during a fiscal emergency, the appointed and elected officials' duties stay in place. And 102 talks about the
It just cannot be. I mean, if in pursuing those activities of the elected office and the administrative responsibilities they assign to themselves, they are interfering with the attempt to bring the municipality out of fiscal distress, how could it possibly be that Act 47 says that can't be touched?
So here's an underlying and perhaps crucial issue. There are two ways that this could be done. It could be done through a plan amendment, or it could be done through the Act actually provides for the receiver to issue orders, and if they're not complied with, a mandamus provision. The 605 says as a general rule, you can't remove these duties from the appointed and elected officials. But But
for us to overcome this standard that the Commonwealth Court is held to is, to me, almost inconceivable.
there's a problem with it's an arbitrary and capricious issue here, because the Home Rule Charter is protected by the Constitution. The Home Rule Charter Act protects the Home Rule Charter and actually says that if there's any conflict, there's liberal construction in favor of the Home Rule municipality.
The Home Rule Charter is only protected unless the General Assembly denies the municipality of that charter, which they did by way of Act 47.
No, I don't think that's accurate, because 605 is the General Assembly saying during a fiscal emergency, these people stay in power. And they limit the ability of a receiver to remove people from office by having the provision saying confirmation of a plan can't effectuate a change in the form of government.
That's not what it says. It says, shall not be construed to change the form of government. What you're arguing is what has been done here should be construed as a change to the form of government. The statute says precisely the opposite.
If If that were the proper interpretation of that provision, and the provision is muddy at best, but if that were the proper interpretation of that provision, the plan could say, we are hereby changing the form of government, and everybody knows we're changing the form of government, but the court is powerless to conclude or construe this as a change in the form of government. That's not the intent here. The intent is 605 to leave the officials in power, and the suspension of duties under 704 is limited to situations where there's a conflict between an existing plan. 704 does not enable the receiver to step in and strip unilaterally.
But counsel, you're omitting the fact that 704A specifically gives the authority to suspend the authority of the elected and appointed officials of the distressed municipality. So you're wanting to say that the receiver's removing them from office. He's not. He's acting pursuant to that power to suspend their authority.
That is not a power of the receiver. That is a byproduct of the plan. The plan gets confirmed. That's a byproduct of confirmation. The plan gets confirmed. And if there is a conflict, then the suspension occurs. But the problem is Act 47 doesn't require that result. And when you look at 2961 of the Home Rule Charter Code, it shouldn't be construed that way. You layer on top of that the fact that there's a provision in the Constitution dealing with removal of appointed officials, and you can't have a plan which removes officials in violation of the Constitution or in violation of 605 of Act 47 without it being arbitrary or capricious.
But you can't have a plan that restricts the powers of elected officials.
I don't think you can.
Well, the provision the language says that a confirmed plan may limit the powers of the elected officials pursuant to the terms of the plan.
It doesn't say that. It says that a confirmed plan suspends the powers to the extent that there is a conflict. It's the chicken and the egg, the cart before
I'm not sure I understand your chicken and egg. You have a confirmed plan that in several respects restricts the discretion that elected officials have and appointed officials have purportedly to help improve the financial condition of this distressed municipality, which has been distressed for far too long. And you're saying that they can do it, but they can't do it.
Section 704 does not say the receiver has the authority to propose and implement a plan that suspends the officials.
But it has the authority to enact a plan that has that result.
It has the authority to enact a plan within the scope of 706, the receiver's authorities of 706 and 703, and if the incidental effect is there's a conflict, then in that limited situation.
I don't see the word conflict. I mean, look, we can read the statute and interpret it. Can I take you in a little bit of different direction that Justice Donahue was exploring with you?
Absolutely.
I'm sure you might like that. Why shouldn't this be bifurcated? To Justice Donahue's point, there is an express provision on which a court reviews a plan modification and an express level of I would say, extraordinarily deferential standard to these plan modifications. And it seems to me that makes sense if I were to analyze the General Assembly's intent, because you don't want plan modifications held up or plans held up with a bunch of litigation. You want them looked at, confirmed, get them done. And then there's this back-end process in a separate statute that says appointed or elected officials can similarly petition the Commonwealth Court to, I don't think it says that, but it's the point, to enjoin any action of the receiver that is contrary to Chapter 7 or Act 47, right? Why didn't, when the General Assembly created those two processes, get the approval of the modification plan, and all you're looking is at whether the plan provisions reasonably or not arbitrarily can aid in the recovery. And if it does, they're approved. And all these challenges you're raising to whether the receiver is violating Act Chapter 7 or Act 47 or something like that should be brought in a separate action in the Commonwealth Court by you challenging or seeking an injunction to the implementation of the plan.
The problem with that is effectively immediately upon confirmation, the rules are suspended. And
no, I'll disagree with you. Effective the approval of the plan under the extraordinary discretion afforded by the Commonwealth Court, the plan gets implemented. You have a problem with the plan in this extent that you think it's contrary to Act 47, right? Then what the General Assembly has effectively done, I'm asking you, tell me why I'm wrong, is said, we're going to let the plan go forward and we're going to flip the burden to the city officials to prove in Commonwealth Court that there's the burden of proof gets put on you to prove that there was a violation of Act 47 and to seek injunctive relief. What's wrong with that?
I think there's a delay, and during that delay in the period of time between confirmation and the court considering whether or not to issue an injunction, the officials have had their duties stripped, and the damage has occurred during that period of time because the damage occurs under this plan upon confirmation, and that's when the damage occurs.
I understand that, but couldn't you argue that in a preliminary injunction in front of the Commonwealth Court? And it would be your burden to prove it.
I think I wouldn't be able to. Effectively, I think I've argued everything that you would argue in a preliminary injunction, but
I mean, maybe Justice Stroud is correct that was a viable approach, possibly, but you brought every single one of these constitutional issues to the Commonwealth Court, who rejected all of them. That's part of the analysis that it did in determining whether there was an arbitrariness or capriciousness involved with this plan modification.
But if you have a constitutional provision that says you cannot remove appointed officials, public officials, and this isn't Act 47 suspending the duties. It is the receiver taking it upon himself to propose a plan under Act 47 that's not contemplated by Act 47 to suspend the duties.
How can you say it's not contemplated by Act 47 when we've quoted you the provisions about his powers to suspend the authority? I mean, it seems like you're arguing to us as if this is a blank slate, as if there's not a declaration of emergency, and as if the General Assembly hasn't put into the Section 102 that this could even go a step further, that they could even abolish a local government unit. So, I mean, you're really whistling past the graveyard, aren't you?
No, we're not at the point where there's an abolishment of the government unit, because that would have to go up to the Secretary. The Secretary would have to make the decision. And at that point, we'd have to look at whether or not Act 47 is in itself constitutional in that regard. But I don't think this court has to make a determination about whether or not it's constitutional because of the rules of construction that apply here. 2961 of the Home Rule Charter Code says if there's any dispute, things get resolved in favor of the municipality. There are provisions, I think Fagan versus Smith talks about if there is potential constitutional problems, the courts are supposed to construe things to avoid those constitutional problems. There is not a specific provision in Act 47 that authorizes the receiver to implement a plan where the plan itself effectuates the wholesale change in government.
May I just have one more? Sure. Counsel, did the receiver ever seek a mandamus pursuant to 709?
Yes.
And what was the result?
Largely the city prevailed in that. It occurred about a year before, 9 months before. The city prevailed. The receiver attempted to remove the duties of Councilman Morgan. The Commonwealth Court initially granted it, removing his duties. I filed a motion for reconsideration, and then the Commonwealth Court changed the order so that to say that nothing in the order could affect the change in the form of government.
And as a result of that prior judicial order saying do not change the government that the people of Chester elected, the receiver then went pursuant to another section to suspend not the duties that interfere with the fiscal integrity of Chester, but to remove duly elected officials from their position of authority. Yes or no?
To remove appointed officials from their position of authority.
And the receiver was appointed by a judge, correct?
The receiver is appointed by a judge.
And the singular receiver appointed by the judge decided to go against what the people of Chester selected, yet democracy worked by unelecting Mr. Kirkland.
And the fact that the receiver is a judicial officer poses problems here. I mean, it poses constitutional separation of powers problems that I don't think I properly analyzed because I don't think the court has actually dealt with them before. For example, the mayor is the head of the public works, which puts him in charge of the police. Now a receiver, an arm of the court, is effectively at the top and effectively in charge of the police.
Counsel, how do you get to this conclusion that the receiver is an arm of the court? The receiver is chosen by the executive branch and confirmed by the court. That's not the court's chosen receiver.
No, but
it's the executive.
And it's not the court.
And it's not the court.
Under the judicial code, a judicial officer is defined to include a receiver.
Unless there's a statute that says otherwise. I mean, there are many situations where a court chooses a receiver. That's true. That's not what happens here. Here, the executive branch chooses the receiver, and the court merely confirms that appointment.
So then that creates other issues if that's how the court's viewing it.
That's what the statute says. I mean, I'm not construing anything. I'm trying to understand how a receiver comes into place under Act 47, and that's my understanding of how it occurs.
It occurs because it's chosen by the executive, but a receiver is inherently an arm of the court. And if you have an arm of the court that is, controlling the police, do you then have problems with criminal law? I'm not a criminal lawyer.
Authority for saying that, if a receiver's an arm of the court.
The judicial code. The judicial code.
Statutory creature. This is a creature of statute appointed under the department. We're not, he or she, in this case the he, is not working for us or for some court. It's not like a receiver appointed in the orphans court or in civil division or family division. It's a creature of the Act 47 statute. They could have called him the poobah or the imperator or something else. They happen to call him a receiver because it's akin to a bankruptcy type situation.
Correct, but the problem is the receiver under the judicial code is residing in the judiciary. Had they created a different organization, a different arm of the government in the executive, I think there'd be no question. You're right. They could call it poobah or whatever they want.
By residing in the judiciary, is he sitting in the conference room of the Delaware County President Judge? No.
No, but under the judiciary code, a judicial officer is defined to include a receiver.
Okay, I think we understand. If you want to take a moment to conclude, please do. Okay.
Real quick, I think 704.
I misspoke. I'm not sure we understand. But if you'd like to take a moment to conclude.
I know I have I think everybody understands the challenges facing the city of Chester. I don't think removing the elected officials, particularly incoming new elected officials who had nothing to do with any of the past, does any good for the citizens of the city of Chester. It only takes their self-governance away from them. A receiver is not a type of person who should be in there answering phone calls about potholes and dealing with crime. The receiver is appointed for financial issues, and if you look at Act 47, it's a financial enabler, pretty much is what the receiver does, not governance. And this goes beyond, and in doing so, it violates the Home Rule Charter Act, and it violates the Article 9, Section 2 of the Constitution.
Okay, thank you, sir.
Thank you.
Let's hear from Ms. Allen. You thought we weren't going to ever get to you, okay?
You're correct, Your Honor. Okay. Madam Chief Justice, and may it please the Court, my name is Tiffany Allen, and I, along with my co-counsel, Ben Patchen, represent Michael Dowery in his capacity as the receiver for the City of Chester. Receivership under Act 47 is the last chance for any municipality to become viable again. The crux of this case involves the power of an Act 47 receiver to reform city operations as part of his statutory duty to ensure the continued provision of vital and necessary services for the municipality. Judge Seisler on the Commonwealth Court, after hearing 3 days of testimony, wrote a detailed opinion finding that the initiatives set forth in the receiver's modified recovery plan were not only vital to the city's recovery, but also necessary to achieve the goals of Act 47. Municipal operations and fiscal management are intertwined, and the provision of such was envisioned by the General Assembly when it enacted Act 47. Any other reading of Act 47, specifically Chapter 7 of the Act, would likely eviscerate the legislative purpose and effectiveness of Act 47.
Counsel, can I test your theory on that.
Yes.
What is it about the fiscal recovery of the city of Chester in the record that is linked to city council people also serving as the heads of boards and commissions?
Yes, so first, Your Honor, the most glaring issue that the receiver has faced when he came on board was learning that the city has not made the full MMO payment for the police pension plan since 2013. And it was came out in testimony by Mayor Kirkland at the Commonwealth Court that the payment was never made since 2016 when he was first elected as the mayor, despite receiving reports from the Auditor General.
Counselor, let's stop right there. I would prefer not to, because I have to address this. I'm concerned. You're saying that you removed government officials because a pension plan wasn't paid. Yet the duty and responsibility of a receiver is fiscal integrity. So the authority permitted pursuant to Act 47 would have been for the receiver to pay, correct? Yes or no?
No and yes. That's a maybe to your answer first.
The receiver's excuse me. The receiver is not to pay
He
a
is, and
pension
he did.
plan?
He did. He paid the first time the payment for the MMO was made was in 2021 after the appointment of the receiver. I used that as an example to show that we're not.
You also used it as an example as why you removed a duly elected public official. See, that's the gist of this for me. You have to share with me where you think you get the authority when you're there only to protect the city of Chester fiscally, not to violate the decisions of the people of Chester. They did that at their last election. So share with me, where in Act 47 do you have the right to usurp the people's decision?
Justice Dougherty and Justice Brobson, I'll be able to answer both of your questions. I use my example of the MMO payment not being paid to show that these were the actions of elected officials. First, the receiver is not seeking to remove the elected officials from their positions. They remain the elected officials, and they retain their legislative capabilities of passing an ordinance. They can do that. We are not stripping that power away from them. What we were seeking through the modified recovery plan is to suspend their administrative duties, which are permissive and not mandatory under the Home Rule Charter. They retain those legislative abilities and roles as they were elected. Also,
who controls the Chester Police Department?
The mayor is the director of public works, but there is also a police chief that does the day-to-day operations. The mayor is not in the police department every single day making schedules.
That's not what I asked.
But I'm telling you, what we are seeking is professional management over all the city departments. Not so how there is a police chief, how there is a chief over the fire department. We are seeking that for all city departments. Also, to your question of where does the authority come from, I would like to walk you through how we see it from the receiver's point of view. Under Article 9, Section 2 of the PA Constitution, it says that Home Rule Charter municipalities have the right to act in any way that is not denied by the General Assembly. The Home Rule Charter law under Section 2961 has that same provision, that Home Rule Charter municipalities all can act to the extent that is not denied by the General Assembly. Similarly, the City of Chester's Home Rule Charter has that same provision, that it can act pursuant to its charter to the extent that it does not conflict with any other state law. We now have Act 47, which is a statute enacted by the General Assembly, which under Section 704A2 suspends the powers of the elected officials and the appointed officials that are granted under charter. It specifically does say charter as one of those laws. It suspends them to the extent it interferes with both the receiver's powers or the recovery plan. And we developed a record over 2.5 years and after 3 days of hearing before the Commonwealth Court that show that there is interference and obstruction on behalf of the elected officials that is keeping the receiver from actually providing the continued provision of those vital and necessary services. It's not just fiscal. Yes, fiscal emergency is part of the definition, but if you look at Section 702A, I believe, where it defines vital and necessary, it says they are the basic and fundamental municipal services, and it provides a list of what that can include. It's not purely fiscal based, and I believe the General Assembly contemplated that it's not only fiscal. If we go to Section 102, specifically Section 4, it goes to the health and welfare and safety of the municipality.
So share with me how 605 meshes with 704.
So 605 first talks about the powers of the governor. So 605 says that appointed or elected officials retain their power to the extent it does not conflict with the powers of the governor. That's the part that the city in all of its briefings tend to ignore. They talk about the first sentence, but not the second part of that act. Now, Chapter 7 is the chapter that governs receivership. And it also talks about once there is a confirmed plan that the authority of the officials is suspended to the extent that it conflicts with the plan or the receiver's powers.
And let's get to the gist of this. When you say suspend, you mean in essence neuter the duly elected officials. They have what can they do?
So the Home Rule Charter lays out several legislative duties of the elected officials. We are not looking to take away those legislative duties. We are not saying that the receiver is now suddenly holding executive sessions or handling a public council meeting. They can still do that. There are many operations in the city that the elected officials can pass a resolution
So if the new mayor selects a police commissioner, can that be done, or does it have to be approved by the receiver?
It's our position that it will have to be approved by the receiver to the extent.
But wait, let's stop. We don't need to get to the extent. Tell me where in Act 47 fiscal responsibility duties that the receiver, an unelected official, has the right to choose a representative of the police department that will protect the citizens of Chester. I'm really struggling with this.
Well, it was already approved in one of the prior plans that the receiver does have the ability to approve the hire and firing of.
That's fiscal. I'm talking about the appointment.
Well, the appointment affects the fiscal position of the city in terms of salary. Can we pay this person complement of the police department? And the receiver definitely has a role in that decision. So fiscal and operations, they're intertwined. You cannot separate the two. In order to have good governance, you need good operations, because what will happen is if the city ever comes out of Act 47, if the operations and the management is not skilled and qualified enough to handle it, then it will find itself in the same position. And that's what we're trying to avoid.
So it's your position that if this new mayor selects an individual he chooses to run the police department, that he needs to get the approval of an unelected receiver, as opposed, because you're saying Act 47 permits that, as opposed to being concerned over the fiscal responsibility, which would be applied through a mandamus should the mayor and the new police chief not follow the fiscal responsibilities or plan of the receiver. That's what you're telling us.
I'm saying that the receiver would be empowered to at least give his input over the hiring of a new police chief should it affect the goals of the plan, the goals of Act 47, the goals of the General Assembly. And may I add that the mayor-elect is on the receiver's side. He actually filed a plan, and we called it the Roots Compromise, because he understood the need to have professional management within the city of Chester. He agreed with us on that, and he understood why the receiver was seeking the suspension of duties. And also, receivership at some point will end. So these plan initiatives and these plan modifications are during the life of the receivership, meaning that elected officials, they will continue to do their job, they will continue to be legislators.
And I want to repeat myself, but how are they doing their job if they're not allowed to select the individual they believe is most responsible to lead a police department?
Well, as the record was developed, there is a history with this current administration and in the city in general of nepotism, of hiring favoritism, of pension spiking.
This administration is gone.
It's not gone yet. It's not gone until the swearing in of the new elected officials. So we still have 6, 7, 8 months of working with this current administration, and we need to implement these initiatives now. We cannot wait.
Counsel, can I interrupt for
I just want to get back to her previous
okay,
answer.
go ahead.
Before Justice Doherty's question, Ms. Allen, you were addressing a chronology of payments that had not been made since 2013. And if we can go back to that, I would just like to hear the rest of your answer on that topic.
Yes, Your Honor. I was using it as an example of where we saw city operations fall short, in that the minimal municipal payment for the police pension plan was not made by the city since 2013 until 2021, when the receiver was on board. That payment was not made at all, and it contributed to the $40 million deficit of the police pension plan, which retirees depend on. You see that in an amicus brief that was filed by the FOP on behalf of the receiver and the initiatives in the plan. So we see that although there's this fiscal component, which is a big component, that's the whole point of Act 47 in a sense, right? But there's also the operations. Who's overseeing? Where are the internal controls? Where are the policies? They're intertwined, and that's our position.
Was the receiver able to rectify that situation of the back payments being outstanding? How did that resolve?
Well, we're in bankruptcy now, so the deficit is still there. We don't have enough revenue or operating expenses to cover the $40 million deficit for the plan or any other deficit that the city has incurred over the years.
Was that failure to pay the police pension payments discovered by the receiver?
It was, to my understanding, it was discovered. Well, it was discovered during the emergency action plan process, where there's a coordinator, and the receiver dug deeper. He looked into it. They went to the auditor general to see about notices to the city, and they did more of an investigation and to see how do we get back on track in a sense.
Thank you, Ms. Allen.
Counsel, can I just clarify for my own understanding?
Yes.
The plan modifications that we're seeing here, and I'm not sure I agree with the adjective I'm going to attach to it, but I will say they are extreme modifications to the plan. This does not have to happen under Act 47. There are other Act 47 scenarios where you don't have the evidence of record of misfeasance and malfeasance that was presented to the Commonwealth Court, and based upon that, the Commonwealth Court found that there was no clear and convincing evidence that was what was being proposed in this modification was for any reason other than to alleviate the distressed municipality status. So I just want to make clear for my understanding that you don't have to end up where we are here when you have an Act 47 plan. This might be viewed as extreme modifications. They're modifications anticipated under Act 47, and they were based upon evidence of misfeasance and malfeasance.
Yes, Your Honor, and you're exactly correct. It does not have to get to this point. I believe that the General Assembly contemplated legislative and municipal officials working with the receiver in order to implement the initiatives. Just so the court, I'm sure you're aware, this is the third plan, right? So the receiver was enacted in 2020. He put out the plan first, and then there was a modification in June 2021 that was approved by the court. This is the third one. This is after 2.5 years of trying to work with the officials and seeing that he was being stopped and obstructed every step of the way to even get basic human resources policies implemented so that they could operate in a way that was professional and streamlined and not haphazard. So this was the last resort. This was also after a mandamus order that was issued by the Commonwealth Court that allowed the councilman to stay in his administrative position, but put a check on his duty to communicate with the receiver what was happening, and we see that was even disregarded by the city. So if the city is willing to disregard a court order after a Section 709 mandamus action, which he's allowed to file, then what's the next recourse? The next recourse is to reinforce Section 704. Council said, which I agree, that Section 04 suspension of duties is an automatic thing once there is a confirmed plan, right?
Counsel, if I can interrupt for a second.
It's okay.
I think that point is really, for me, at the nub of this case, because I do think the facts brought you to this point. But the single biggest question that the petitioners, appellants, however you want, objectors, I don't know what word is proper, that they seem to be raising is not just that the provisions of the plan are extreme, because I think extreme can be in there. The question is whether it crossed some sort of a line, that there's just something that you can't have in a plan that doesn't have the effect of suspending the powers and the duties, but actually does it, that affirmatively substitutes the word for receiver in the Home Rule Charter for the words counsel. There may have been a less extreme or extreme but nonetheless valid way to do that, as in mayor, you shall, or city council, you shall look for people outside of the city to hire. How do you respond to that point, which these aren't just extreme, but they cross a line?
So we disagree, obviously, that it crosses the line. Again, this was what you were proposing of working with council or, instructing council or putting out an order under section, I believe, 708, where the receiver can put out an order with compliance with the plan. The receiver has done that. He's attempted to work with council to say, let's look for non-residents if they're qualified for a position. And the pushback is, well, I want person X or I want person Y to be in this position, even though that person doesn't have the qualifications and for no other reason other than that's who, the mayor or a certain council person may want to hire. Under Section 704, once there is a confirmed plan, that extent of their authority is suspended if it conflicts with the goals of recovery under Act 47 or the receiver's powers. That suspension is automatic. Appellant agrees that it's automatic. However, since the confirmation of the very first plan in 2020, they've still been operating and they've still been exercising these duties in conflict or against the plan, because I know the word conflict is not in Act 47, but they've still been operating against the plan. So what we did in this new modification was essentially reinforce Section 704.
And I think that's a point well taken. I clearly got the sense from reading the record that this modification was out of frustration. But that's another key argument that the objectors raised that you haven't addressed, which is the General Assembly created the mandamus remedy for those instances where the elected officials are failing to follow the directions of the receiver. That seems to be the only remedy that they created. It seems to me to be I don't want to use the word loophole, it's used too many times, but a workaround to say, well, I'm just going to take what relief I would have asked for in mandamus and make it actually physically part of the plan. When it's, again, and you can tell me why I'm wrong, it seems to me the General Assembly didn't want that. They wanted you to go to Commonwealth Court if the elected officials weren't following your directives, get a mandamus, and even contempt if you had to get contempt, civil contempt or something like that. But I think it's the frustration that led to this, and how is that consistent with what the General Assembly wanted?
Two parts to that question. The first is the receiver in March of 2022 filed a mandamus action, and we had a hearing. We had an evidentiary hearing, and the court put out an opinion. And although she did not suspend the administrative duties of that council person at issue at that time, she did put parameters on his responsibility to report as the director of finance and human resources to the receiver. He failed to do so.
Well, then the solution is contempt.
So that's what you're saying, Your Honor. We did not. That's not within Act 47. Act 47 does not really require or put forth our reading of it, some type of sanction if a mandamus is not followed. So we look into...
It's a court order. I mean, there's plenty of, courts have the power to enforce their own orders.
No, I agree, but however, as we're here today before the Supreme Court, the litigious nature of the city council people is that they're going to find some way to say that that court order for contempt is not contemplated by Act 47.
So are you are you sharing with us that the malfeasance or the unethical conduct or the obstruction by government officials falls within the purview and the intent of Act 47?
Well, Act 47 clearly states that the exercise of duties, if it conflicts with the plan or the receiver's powers, then they are suspended. So, yes, it does.
So share with me, Chester's home charter rule, correct?
Their home rule charter, correct.
Is there a provision with regard to the removal of a public official, either by recall, impeachment?
By impeachment, but we're not removing public officials that were elected.
But you are de facto removing. You've removed the public officials by suspending their duties.
No.
2, if you're believing that there's malfeasance, this could have been reported to the U.S. Attorney or the Attorney General for criminal prosecution if you're saying what they're doing is malfeasant or criminal.
I never used the word criminal. I said that they are obstructing and interfering with the receiver's initiative.
Obstructing is a criminal term.
But not...
A government official who's obstructing in his position is committing a criminal activity. It's in the Crimes Code. But that being said, I'm using your language. I'm just listening to you. So I have a question. So it's your position that you used the court for a mandamus, but the violation of that mandamus causes you not to go back to the court to seek the legal remedy of a contempt, but instead to return to Act 47 and one subsection of an act to try to usurp and remove the duties and responsibilities of all the elected officials of Chester.
Respectfully, I disagree. We are not removing elected officials. We are not usurping their legislative duties. We are seeking to suspend their permissive administrative duties. The mayor has the choice under the Home Rule Charter to not appoint any person on council as a department head. That's what the Home Rule Charter says. It's permissive, it's not mandatory. They are still council people. They can still act on behalf of the constituents that voted for them. They can still pass an ordinance for a summer food program. That's not what we're saying that they can't do. But what we are saying is that... How could they
pass an ordinance for a summer food program when that would require taxpayer dollars and the concept of a receiver?
Because when the receiver reviews it and it's in the budget, they can approve it.
Could you answer that question again? I didn't hear you.
I was saying that, and this is a real-life situation happening now, summer food programs are provided by the cities or municipalities. If the city of Chester wants to have their yearly summer food program, the receiver reviews it, it's within the budget, it's not something that's going to exacerbate the fiscal emergency that they're already in, and it's for the health, safety, and welfare of the residents, then City Council can, as legislators, approve that ordinance and the program can go forward. We're not saying that they cannot do that.
Are you telling us that when the receiver gets involved and stops a proposed action by one of the officials of Chester, it's only in a situation where there's a fiscal question, it's only in an economic situation where funds are about to be expended or were expended or should have been expended, or is it beyond that? Are there other situations besides fiscal determinants?
It is beyond that. Fiscal is a part of it, but when you look at the definition under Act 47 for vital and necessary, it's the basic fundamental municipal services, which we interpret to be beyond fiscal. It also means internal controls. It also means professional management. It also means having operations and policies in place so that when you have to make these fiscal determinations, you have people who understand what's at stake so that this does not happen again, where when the city is eventually out of receivership, hopefully at some point, that there is an organization in place and a system in place that these services are provided, they're paid for, and the deficit does not continue to grow until what we see this multi-million-dollar number at this point.
Okay, do you have any closing you would like to make? Anything that you'd like to make sure we understand?
I believe that you all fully understand what's happening here, and we will rely on our briefs for the other arguments that were posed by the court in order.
Good argument.
Thank you.
Is this your first time?
It is. Yes.
Very nice job.
You handled yourself well with me.
Thank you.
Outstanding job under pressure.
Thank you. I appreciate it.
Thank you. Thank you, sir. Mr. Renner?
What's that?
Pennsylvania Interscholastic Athletic Association versus Simon Campbell, representing the PIAA, Mr. Aplt Jr., representing Mr. Campbell, Mr. Craig Stoudemire.
Good afternoon. Last but not least, in this appeal by allowance involving the right to know law, we must determine whether the General Assembly's express inclusion of the Pennsylvania Interscholastic Athletic Association, or PIAA, in the definition of state-affiliated entity amounts to unconstitutional special legislation. Additionally, we must consider whether subjecting the PIAA to the disclosure mandates of the right to know law contravenes the provisions of the nonprofit corporation law pertaining to the disclosure of records. Please proceed.
Thank you, Your Honor. Good afternoon. May it please the Court. Alan Boynton on behalf of the appellant, the Pennsylvania Interscholastic Athletic Association, Incorporated, more commonly known as either PIAA or PIAA.
If I were more sports-minded, I would have said that correctly, PIAA.
He's a good sport, though.
I'm a good sport, but that's about as far as it goes.
Well, I think before I start, I would like to comment based on the prior argument. This is also my first argument before the Court, and it has only taken me 40 years to get here.
Glad you're here.
Thank you. The Court accepted aliquotter on two issues, the first of which appears to be a constitutional issue of first impression, specifically whether the General Assembly can evade the constitutional ban on special legislation by creating a perfectly valid definition for a class, but then making that definition illusory by including with it a list of entities to be included within the scope of that definition, one of which does not remotely come close to meeting the definition that the General Assembly actually adopted. Now, it's probably important to start with a point that is actually not contested in this case, and that is that the General Assembly may very well have had some reason they wanted PIAA to be included within the right to know law. In many respects, Pennsylvania at the professional, collegiate, and high school level is a sports-mad state. With that in mind, it's probably not surprising that those with passions could have prompted the General Assembly to want to have PIAA within the scope of the right to know law. The problem, though, is in the means adopted to accomplish that goal. The General Assembly adopted a perfectly reasonable definition for the class in question. It defined a state-affiliated entity as a, quote, Commonwealth authority or Commonwealth entity. That is a class that is not limited to one entity and is certainly capable of expansion. Then in 2016, the Office of Open Records, which is the administrative body responsible for interpreting and enforcing the law, issued a decision in what is called the Aplt case, which is cited in our brief, and they expressly set forth the criteria to assess whether an entity meets that definition set by the General Assembly. And the OOR identified several specific factors that characterize a state-affiliated entity. First, whether the entity was created by the General Assembly through enabling legislation. Second, the extent of the financial relationship between the entity and the Commonwealth. Third, whether the entity was granted governmental powers by the General Assembly. Fourth, whether the entity is administered by Commonwealth employees and or elected Commonwealth officials. And fifth, whether the entity annually reports to the governor and the General Assembly. Now, these all seem to be valid criteria and perfectly appropriate to define a state-related entity. And if we were before the court simply on that definition and on those criteria, there would be no case. No one has ever even attempted to argue that PIAA meets these criteria. The Commonwealth Court didn't attempt to do it. Mr. Campbell doesn't attempt to do it. The reason is obvious. The uncontested facts of this case are, one, PIAA was not created by enabling legislation. It is the only entity that is listed among those 14 in the definition that is a private party incorporated under the nonprofit corporation law. Second, PIAA has not been granted any governmental powers by the General Assembly. Third, PIAA is not funded by a single dime from the General Assembly. It was never given any power by the General Assembly to raise its own funds. No, I don't believe it does. If that approach was taken, there would be thousands of entities in the state who receive money from public schools. Every decision by the OOR, by the Commonwealth Court, and by this court has focused on a direct relationship between the Commonwealth and the entity receiving money. Receiving money from a state, if you adopted, from the public schools, if you adopted that as a criteria, cafeteria workers, janitors, contractors, all those receive those, and they would be considered state-affiliated entities simply because they have a... I don't believe it even fits that one because it doesn't receive Commonwealth money. Remember, we're talking about a Commonwealth agency, not a local agency. The right to know law does have provisions for local agencies. They didn't put PIAA under that one. They put it under the Commonwealth one. Under local agencies, that could have been relevant, but not under a state-affiliated one.
Maybe it's enough just because the legislature deemed it appropriate to name the PIAA in the statute under the definition of state-related affiliated entities. And maybe that's because it's an entity that is just so far-reaching into every household of every family across our Commonwealth. If you look at the number of children that participate in interscholastic sports, it's an organization that says what the coaches can do and can't do, what the players can do and can't do, what the rules of the game are, what the rules are for the officials, what the schedules are, what you can do if you want to transfer schools, what you can do or can't do to be eligible to play the sports, what the medical requirements is. Isn't that enough reason to say that because you wield so much power and impact on our citizens, that it's enough to say that those citizens are entitled to know what goes on behind the curtain?
I understand the argument, but I think that approach conflates the distinction between a regulatory agency and a nonprofit voluntary membership corporation. Those schools that you're talking about all voluntarily came together and created this organization on their own to voluntarily agree to establish rules. There are no regulatory powers that PIAA has to enforce any laws, any rules. The strongest power that they have is simply to kick a school out of the organization.
The only game in town?
No, absolutely not.
Counsel, with regard to your voluntary organization, it's your organization that determines the classification of whether you're D1, 2, or 3, correct?
Well, the Constitution, which is adopted by the membership, defines classifications, that process, and they establish that schools are to be classified based upon...
The schools that are determined to be a D1, D2, or D3 are based upon PIAA.
Well, we call them single A, double A, triple A, et cetera.
I got it.
Yes.
And you also allocate or are monitoring the presentation of, like, say, scholarships. You permit scholarships.
We have no role in scholarships. I'm not sure what you mean.
So the PIAA doesn't determine whether a D3 school can get scholarships?
No. Again, we don't have D1, 2, 3, single A, double A, triple A, up to 6A, depending on the school.
My bad.
But changing that thing, scholarships have no role in any aspect of that.
Okay.
PIAA has no relationship with the collegiate scholarship process. That is the NCAA issue.
Got it.
Counsel, can I ask a related question? If we were to decide that the disclosure requirements of the nonprofit corporation law controlled in this situation as opposed to the right to know law, wouldn't we avoid the constitutional issue?
Yes, that was actually the second issue that this court accepted Alec on. I was going to get to that, but yes, you can avoid the constitutional issue if you conclude the PIAA is properly subject to the right to know law. Our position is still that the disclosure provisions do not apply because the nonprofit corporation law disclosure provisions trump the provisions in the right to know law. And there's a specific conflicts provision in the right to know law that says if there is a conflicting statute, conflicting law, that law controls. So yes, I would agree with that.
Could I follow up, Counsel, and ask you, I was thinking about, I understand one of these things is not like the others argument. That's a good argument. But what about the fact that sitting on the board of directors are all these school district employees, all these school officials, taxpayer paid? Are they sitting there as representatives of those public entities, or do you maintain that they're private citizens? Or does it matter?
Well, let me avoid the last part of that. I'm not sure if it matters or not. But the way PIAA is structured on the board of directors, there are 12 districts in the state. PIAA is a very decentralized organization, and there may be a misconception about the scope of PIAA's influence at the headquarters. There are only 14 employees. This is not a major corporation or anything. Headquarters only has 14 employees. Most of the organization is run by volunteers, mostly at the local level. So getting to your point about who serves on the board of directors, each district of the 12 districts, depending on the size, elects members to the board of directors. So, for example, in District 7, also known as the WPIL, which is in southwestern PA, it's our largest district. They are large enough that they elect 3 people to the board of directors. So all the schools every spring have an annual meeting together. They elect members to the district committee, which handles the local competition, and the district committee then elects 3 people to serve. Those people do not have to be school employees. Some of them are not. Some people elected to district committees are not. We have parent representatives on the board. We have officials. We have a girls representative on the board. They do not have to be. They may be, but they do not have to be school employees.
And if they are, counsel, they're local government
That's correct.
officials, not state.
There is one person on the board of directors who's appointed by the Secretary of Education. That is it. There are 32 members on the board, only one of whom is state-related.
Mr. Boynton, could you address the Butler area school district's position that your inclusion, your challenge to inclusion as an agency for this purpose is barred by the doctrine of latches?
Well, I believe we hit it in our brief, but I will respond directly to it. One is it was not raised below at any point, and in our view it is waived for that reason. But this court has addressed the question of the constitutionality and whether and how soon a claim has to be made. And I believe that there is compelling precedent that an unconstitutional provision can be challenged at any time.
Even though it's been 10 years that you've been cooperating with the right to know law?
Provided that we're not trying to reverse something that occurred in the past. I believe that there was a case a year or two ago where the court refused to reverse or declare a statute unconstitutional on the basis that it would have reversed an election that was already completed, and that would have been inappropriate. But subsequent to that, in another case, the court said there's no bar in addressing a challenge to a statute when you're looking for prospective relief.
Thank you.
Okay.
Additional questions? They're dropping like flies.
Apparently.
Do you want to sum up?
Would you like me to address any further points on the nonprofit corporation law? I believe I responded to Justice Donahue's question.
I think it's a clear-cut answer.
I think it is, because the statute is very clear that any conflicting statute controls, and this Court has said that. And there's actually already precedent with the Associations Code, which is analogous to the nonprofit corporation law, in which the Office of Open Records has already said that that law's statutory disclosure provisions control.
Now, let me ask you to answer the argument raised by opposing counsel, which is the exemption applies where the record is exempt from disclosure by another law. And their argument would be, well, the nonprofit law doesn't make it exempt from disclosure.
They're arguing a different section of the statute than we do. We don't even refer to that section. They don't even respond to our argument. We refer to Section 3101.1, which they don't even address, which is the conflicts provision, as opposed to an exemption. We're not arguing exemption. We're arguing that another statute completely preempts the record disclosure provision of the right to know law.
Thank you.
Justice Mundy, do you have any further questions? I asked because you were the only one who knew it was AA, not You have special knowledge in this area. All right, thank you very much.
Thank you, Your Honor.
Nice job for a rookie.
Yeah.
Madam Chief Justice, Justices, may it please the Court, my name is Craig Staudenmeyer, and I'm here this afternoon on behalf of Simon Campbell, who is the original requester and the appellee here. Let me say, too, if it helps any, this is the first time I've been in front of you this year, if that helps at all.
And we'll say welcome.
All right. And I also am painfully aware that I'm the last counsel voice, either presumably or hopefully, that you'll hear. So I'll
we already had lunch, so we're generated, so just take as much time as you
As you've heard from my opponent's argument, the issue of the constitutionality of including them within the section defining state-affiliated entities. And I don't want to seem trite when I start this way, but I think Justice Mundy hit the nail on the head. It is because the legislature says it is. Now, I understand that there are exceptions to that, but those exceptions are rare, they're limited, and it's an extremely heavy burden for someone who contests a constitutional statute. It's because of the presumption of constitutionality to get over that hurdle. And our contention is that here, both substantively and factually, the PIAA has not done that. Now, with regard to PIAA, and also with regard to the nonprofit law question, they have misdirected the issue. The challenge here, the challenge they've raised, and the challenge that you accepted review on with regard to the constitutional issue was whether or not this violates the provision of the Constitution that prohibits special laws. And the case law under that analysis has said that if there's a rational relation between the law that's passed and it serves a legitimate state interest, then the law survives. Even in a situation like this where you seem to have a sort of unique entity that has been defined. And we both cite the Harrisburg Redevelopment Authority case, and I'm not going to belabor the issue, but that case sort of has the same sort of guideline. And by that I mean that when you look at the organization of the PIAA and what the Commonwealth Court did in looking at the analysis they did, you have an organization here, by its own admission, that involves 350,000 student athletes in the Commonwealth each year. It involves over 1,400 public and private schools, and it's statewide. And so in looking at this, one of the other aspects the Commonwealth Court recognized was that you as the reviewing court here can review, and as long as there appears to be a legitimate interest served by the statute stands. And I think here it doesn't take a great leap of legal or logical argument to understand what the legislature was up to. They wanted to look at the PIAA because, as we point out in our briefs, they actually went to the point of passing a statute, the Pennsylvania Athletic Oversight Council Act, which created this council, which actually met over a period of 2 years to suggest 19 revisions to PIAA's governance document. Now, PIAA says, well, for example, one of the governance was about making them more closely aligned with the open meetings law. And they said, well, we sort of do that, but we don't go the whole way. The issue, though, that sort of begs the question, the issue is that the legislature has looked earlier at PIAA and has attempted to exercise some control over it. And I think that's enough of a control shown by that statute and the subsequent right-to-know law.
Well, Counsel, if I may.
Sure.
PIAA is not created by an enabling statute. It's not receiving its primary funding from the state, and it's listed as a nonprofit. If we were to follow your logic, and we were to affirm the Commonwealth Court, would that not permit right-to-know requests of all nonprofits incurring, expense to nonprofits?
It would not, Your Honor, and the reason is that the PIAA is a unique nonprofit. What do I mean by that? The uniqueness of it, Your Honor, comes from the fact that it covers such a vast array of students within the Commonwealth. It's made up of the public and private schools that we heard about earlier, over 1,400 of them. So I think in terms of a nonprofit, yes, that's its creation, its functionality. But looking at what it touches on, and I think there might also be a tendency to sort of divest the issue of high school and middle school athletic sports from education. But if you look at the PIAA itself, it talks about its goals, and one of those goals is to place interscholastic athletics in the context of secondary education. You also heard that sitting on their board is a member of the State Department of Education, and yet even though the people on the board don't have to be public school employees, they are for the most part.
They could change that, right? The PIAA, since it's not created by the General Assembly, could change that, couldn't they? They're not required by law to have those public officials on their board, are they?
Absolutely correct, Your Honor. Or they could do the opposite and have more people on. It could be, but looking at the context that you're looking at this case now, and I understand this court has to look forward as well, but I think the PIAA is such a unique creature that when you're looking at it under your analysis that you have to do from a constitutional standpoint, that the rational relationship to including it in the law because of the taxpayer money that's involved, and it's not a great amount of money. In fact, when I had this case, I handled the FIA case years ago, and that was FIA's argument. Well, our budget's $1 billion. We only get $400 million from the Commonwealth, but here we only get 10%, but it's still taxpayer money, and largely the use of taxpayer-paid facilities, sports stadiums, high school football fields, all paid with tax dollars.
Counsel, could you not obtain that information through right-to-know law to those particular institutions and organizations outside the PIAA?
Well, Your Honor, you could with regard to that particular institution, but I think the thing here is that you have this body that oversees the whole system statewide, and therefore it's important that it be subject to the law for transparency, particularly with regard to fiscal situations, as opposed to going at it piecemeal. And I used to know at one time how many school districts there are in Pennsylvania. There's a lot.
So here's what troubles me about your argument. This is a voluntary association, and they've become good at what they do. And so consequently, there is an imposed transparency on this voluntary nonprofit association. They can change their membership. People can drop in and drop out. The state has no control whether or not they continue to exist. And saying that because they're good at what they do, and I will grant you that although they have never come into my household by way of what they do on a day-to-day basis, they're ubiquitous. But I don't know how that makes them a subject to the right to know law just because the legislature says so.
Well, Your Honor, I can answer that, I believe, in this manner. As I've said before, I know it's been a long day, I don't want to keep repeating myself. But you...
Our day is just beginning.
Yeah. I can believe that, actually. You have to understand, as you used the word ubiquitous, but I think you have to use that in the context of the organization itself and the impact it has on student athletes in the Commonwealth. And I think for that reason, yes, it is a nonprofit, yes, it's a voluntary organization, but it has become so pervasive, and its control over interscholastic sports in Pennsylvania has been so pervasive that the legislature decided it's necessary to make sure that we can keep an eye on it. And I refer back to the Oversight Committee Act that keeps...
But that wasn't, they didn't take over the PIAA. They put together recommendations. I mean, they didn't attempt to co-opt the voluntary nature of this association.
Agreed, but I think this idea that it's sort of PIAA says, look, we're totally divested from the Commonwealth at all, from the government, and that's just not true. They've been looked at carefully by this committee. They have to make annual reports. They have modified what they do.
At the Catholic Church, that doesn't make the Catholic Church subject to the legislative or executive branch. I mean, it's something that the legislature does in terms of its investigative abilities.
Mm-hmm. I appreciate what you're saying, Justice Donahue, but I think that here again, we're talking about a very unique organization here when you're talking about the PIAA and the effect it has on statewide interscholastic sports and part of the education system.
But let's separate its influence. We're looking at whether it's a government entity subject to a right to know. And the Commonwealth doesn't control how it collects money or how it spends money, does it?
It does not directly, no.
Okay. So therefore, what gives an individual the right to look in their books?
Well, here again, I think because the element of the fact that there's taxpayer funds that help pay their membership dues, their sporting events are held in taxpayer-funded arenas, stadiums, etc.
So technically, do you believe that a deli of an individual who used taxpayer dollars, a.k.a. SNAP or food stamps, do you have a right now to inquire into that deli's books because they've accepted a taxpayer check, a.k.a. use of an access card or welfare? The answer is no.
The answer is no, Justice.
So why do you want to do that just because they're larger and they have more money?
But I think that sort of misstates why we want to look at them. We look at them not because they're large or because they have lots of money or they have taxpayer money. Those things combined. But it's here again, you cannot underestimate or underappreciate the impact on the education, the student athletes, and its sort of symbiotic relationship with education within the Commonwealth. I think that's another key factor that we're dealing with high school, middle school student athletes.
Can I follow up on that, Counsel? Because I wonder if you could explain how that point isn't undermined by Mr. Boynton's argument about the decentralization. So for example, the WPIAL in our area, like my kids did WPIAL sports when
I went to Norland High School. So
but I mean, they had nothing to do with the PIAA. They never talked, but nobody talked about the PIAA. It's just an umbrella organization up here somewhere that is. It seems it's the tail wagging the dog by being listed in here, to the exclusion of all these other non-government entities that could also have been listed here. WPIAL, for example, or PIAA, or the Rugby League, or what have you. Why is this organization crammed in with all these government entities?
Well, Your Honor, I believe the answer to that is because the PIAA is statewide. It's pervasive. The WPIAL in the western part of the state deals in its little part. The other one's divided up with their little parts here and there. But the PIAA is pervasive throughout the Commonwealth and has the single largest effect on student athletes in the middle school and high school level.
Is it the only statewide organization of its kind?
It's the only one that I'm aware of, Your Honor.
It's a convenience to people like Mr. Campbell, following up on Justice Doherty's question a moment ago. It's a convenience to people like Mr. Campbell. They can just go to the PIAA and try to get everything there rather than having to go to these constituent parts, the WPIAL and the Eastern people, or to the individual school districts themselves.
And also, I would submit to Your Honors that it's also a sort of safeguard or protective measure to look at the umbrella organization, and even though it may want to distance itself from the divisions it has, they're still part of the overall system. As be able to keep an eye on from a sort of I don't want to say 30,000 foot level, but to see the overall effect of money spent, money brought in. And, you know, with regard to the student athletes themselves, you know, don't forget the effect here. The PIAA and its members, it affects eligibility. It affects the rules. It affects the training, who can be officials and who can't be officials. So, like I said, it has this statewide pervasive effect over almost every aspect. In fact, I think on their website, they control every sport at the middle and high school level except for 4.
And now girls wrestling.
Exactly. And
but to be simplistic, so what? I mean, it's a voluntary association, and they've hit on a formula here that seems to work, that keeps, you know, its members happy in how, you know, these sports interscholastically take place. I just don't know. I still struggle with that notion that a successful nonprofit, one that's good at what it does, all of a sudden becomes stuck with the moniker of state-related agency. It just doesn't compute with me.
Well, Judge, I understand your frustration somewhat, but I think you're overlooking the fact that they chose to become what they are. In other words, they have chosen to become the largest, you know, group involved with middle school and high school athletics of students in the Commonwealth. They have chosen to set up these systems, you know, to determine the eligibility rules, the rules of the game to be played, who the officials are.
People agree to it. I mean, people don't have to agree to it. You know, if their members say, no, we don't like that. You know, I mean, recently, there was a recent article regarding the eligibility of a transgender player on, and I forget what the team was, it doesn't really matter. The PIAA's position was, that's up to the principal of the school. I mean, that was their official position. I mean, it seems to be, you know, the essence of what this association is. Now, of course, there are members who are saying, no, we really want the PIAA to take a stance on this. That's a different issue. I mean, if all of the members get together and voluntarily say, I think we should have a policy on this, you know, we'll see what happens with that. But I think it's indicative of what we're dealing with here, which is a voluntary association of school districts who have agreed to operate by these rules. Any one of them could stop agreeing. Anyone could attempt to try to change the rules. That's what I'm saying. I mean, the lack of any government control over how this happens seems to me to be the antithesis of a state-related agency.
Well, I understand your frustration, Justice Donahue, but here again, I don't think you can underestimate or underappreciate it. We're not talking about the Kiwanis. We're not talking about the Rotary. We're talking about an organization that has imprinted itself throughout the state on the like organization of and control of student athletes that are coming through largely the public school system, but also charter and private schools. So I think
They're good at it. I mean, that much I gave you in our first discussion of this. They become very good at what they do.
Sure,
and I don't know how that works to what they perceive to be their detriment in terms of the type of disclosure that's being foisted on them.
Well, I would never say transparency is a detriment, but like
if you're a nonprofit made up of voluntary members, you know, I mean, maybe it is. One other question.
I understand the desire not to be. Believe me, I do.
Well, let me just ask you another question.
Sure.
You know, you mentioned, and you know, obviously for obvious reasons, that this is statewide. But what it is a voluntary statewide group of local government elected individuals. So
Right.
if you, does that make it a state-related agency, even though it's really composed of local government elected and appointed members?
Well, here again, I think the legislature, in looking at the law, there were only so many holes to put it in. And so they chose to put the state-affiliated entity, as put it there.
I get that, but maybe they don't fit into that hole. I mean, I guess that's what isn't that what the discussion is?
Well, I believe that's the ultimate issue here, Your Honor, I said. But I believe it does. I'm sure there's people in the room who disagree with that.
I don't know.
But as I said, here again, I think what makes it different, it obviously is a different creature in and of itself, but what makes it different is the pervasiveness and the control it exercises, even though it's made up of, as you say, voluntary organizations and local districts throughout the state, and what it controls in those aspects of sports and how the impact it has on the lives of student athletes overall.
Could you tell me why Section 3101 of the Right to Know law doesn't control the outcome of this case so that we don't have to reach the constitutional issue?
Yes. Here again, Your Honor, the Section 3101.1 here there is no conflict of the provisions. They're merely different provisions that provide for access to similar types of records. Now, we give you the example, there are a couple of examples. We talk about the Coroner's Act, where you have an act that gives access under certain conditions through the Coroner's Act. Then you have the Right to Know law, which gives you access to certain coroner records. Just the Coroner's Act will give you them faster, but you have to pay more for it.
But the difference there is those Coroner Act records were always available to the public. It was just a question of when and if you had to pay for it. Here, under the nonprofit law, these records are not available to the public. They're available to directors and they're available to members.
Under those statutes, yes, Your Honor. But like I said...
So there is no analogy with the Coroner's Act case.
But I think there is, Your Honor. But to move on, I think I think you have to look. It's not really the PIAA wants you to think there's a conflict and then say because there's a conflict then you can do this or that. There is no conflict. You have two different statutes that allow access in different ways to different people.
To different people, though, there is a conflict. Under one act, the public has no access, and under the Right to Know law, the public has access. That's a conflict.
Well, I think in the context of the Right to Know law, though, in looking at as we talked about the exemption section.
Well, but that's a different.
I understand.
That's a different issue. I mean, their argument is that 31011 controls here, and there is a conflict under the law that they are relying on. There is never public access. It just isn't.
Well, I understand from the nonprofit corporation law. But I do think if you look at the Right to Know law and its effect here, even though there might be a greater access to a greater number of people, I still don't think in the context of the conflict provision of the Right to Know law that it comes into play. And, and we've argued that in our brief as well, and I won't belabor the point unless you have other questions.
Mr. Starbmeyer, would you like to wrap up unless any justices
I'm all done.
any questions?
Thank you.
Would you conclude?
I would just conclude by saying that, based upon, the briefing that you've had and the arguments you've heard, it's our position that the law is constitutional as applied to the PIAA, that there is that the conflict of law question raised under the Right to Know law is not applicable, and therefore we would ask that you would affirm the Commonwealth Court's decision in all aspects. Thank you.
Thank you.
Thank you.
Thank you.
Thank you.
It's been a long day. Sorry? I think they overstepped their authority.
What's that?